So very good morning. So today we are going to start with day 1 revision on CA Interlaw. This is a 3-day revision session and today is the day number 1. We will be covering totally 10 chapters in our syllabus in this revision class. Firstly, we will cover today 3 important chapters coming for 30 marks. Number 1, interpretation of statutes. Number 2, FEMA. And number 3, LLP. These 3 acts will be accounting for 30 marks in examination. Okay. We will be doing questions from here and we will be doing also the examination past questions that were given in the study material, such that you will have a clarity on an entire concept. Okay. Next, if you remember, for the FM what we have done, complete study material we have done without leaving any question. So like that, here also once you do the study material you will get the confidence. So that's what we are going to do. With regard to the law, why I am starting first with the other laws. Companies Act, every time people will take, but other laws is not taken properly. So therefore let us revise first from the other laws point of view, so that everyone will get overall benefited, because this is the most important area in the entire law paper if you ask me. Reason, 11 chapters of Companies Act will be coming for 60 marks. But 4 other laws are coming for 40 marks. Obviously, on an average, each chapter will be accounting for 10 marks in examination. So this is extremely important area. In that we are going to cover 30 marks. Means today's class, if you listen properly and complete, okay, pass guarantee. With 1 revision session, pass guarantee first. Examination and other things, give it to God. First you will pass. Tomorrow's session also completed. 60 guaranteed. Next also you completed. Definitely will get a very good score, which will make you to pass group 1. That much aggregate addition will be made by this. Okay. Let us begin. What is the name of the chapter? Interpretation of statutes. First let me explain what are all the concepts in this chapter. Okay. This is my notes. This covers each and every minute detail of your textbook, institute textbook. Nothing is my language, nothing is added. Each and every point in the notes, what I am showing you now, is complete text of what is there in your study material. Listening everyone? Okay. From here it starts. See here, this hand notes is 10 pages hand notes. Interpretation of statutes. How many pages? If you read the 10 pages, 10 marks pakka. Not guarantee. Exam date we will meet again. Okay? Not guarantee. 100% guarantee. Name. Remember my name. Okay? If you read this 10 pages notes, every question that comes in exam will be from this 10 pages. Okay? So what is there in this 10 page notes? See there. Meaning of a statute. Meaning of interpretation. Meaning of construction, internal aid for interpretation, external aid for interpretation, rules of interpretation, interpretation of documents and deeds, miscellaneous. Okay, first let us see. If you observe, meaning of statute, meaning of interpretation, meaning of construction, long title, short title, preamble, headings, marginal notes, illustration, explanation, schedules, proviso, rules of interpretation, rule of literal construction, Ejusdem Generis, last item 6 marks. That's it. These are the things you are expected to write. Noscitur Sociis, Contemporanea Expositio, Headens Rule, rule of beneficial construction, golden rule or reasonable construction, exceptional construction, interpretation of end and or, may and shall, harmonious construction. That's it, chapter 1. These are the areas. Listening, huh? What they do in exam, I will tell you. 2 questions will come from this chapter. How many questions will come? 2 questions will come. From this, 1 question will come. From the remaining part, one question will come. Are you with me, everyone? From this, one question will come. From all the remaining part, one question will come. So if you prepare this set, 6 marks pakka. Remaining set if you prepare, 5 marks pakka, 11 marks total. That is smart way of preparing this chapter. Clear? So how to prepare for this chapter? First you have to complete all the rules of interpretation. Regular classes we will start first with what is a statute, what is interpretation. Like this we will begin. The exam oriented revision sessions, the intense batch, where we will consider first what is important from the exam's point of view. Listening? Let us start. No waste of time. Let us begin. What is the first concept? Rule of literal construction. Rule of literal construction. First, everyone in the class should know that there are totally 9 rules of interpretation. How many? 9. 10 will be there. You can make it 9. Okay? 9 rules are there totally. Listening now, everyone? What are the 9 rules? First point number 1. Rule of literal construction. Tell me, what is it? Rule of? Second one. Rule of reasonable construction. Rule of beneficial construction. Rule of harmonious construction. Rule of exceptional construction. Rule of Ejusdem Generis. These are all called as a primary rules. Okay, first remember this way: literal, beneficial. Loudly, first one: literal, beneficial, harmonious, exceptional, beneficial, Ejusdem Generis. Ejusdem. Along with that, Institute has added another more rule, Haydn's rule. What it is called as? Haydn's rule. That is what expected for the May exam. I am expecting Haydn's rule to come this time. He will ask for 4 to 5 marks. Explain the Haydn's rule with an example. Like that he will ask a question. Understood? So listen carefully. They are totally, listening, 7 primary rules are there. How many? 7. Actually 6. Institute material they added Haydn's rule also. 7 rules. I will write here. See. First one, literal construction. One second. Reasonable just a minute. So let us start with revision on interpretation of statutes. Name of the chapter is Interpretation of Statutes. In this 2 stages we are going to discuss. Number 1, first stage rules of interpretation we will cover. Once rules of interpretation is completed, then we will be going into other aspects of interpretation of statutes chapter. Clear? So what are all the exam oriented topics we need to discuss? First of all, 9 rules of interpretation are there. How many? 9. 9 rules of interpretation. Once the 9 rules of interpretation are completed, next stage we will discuss 2 more concepts. What are the internal aid of interpretation, external aid of interpretation? With that chapter will be completed. Exam from these only questions will come. From 9 rules of interpretation, 1 question will come for 5 to 6 marks. From other concepts of 4 marks to 5 marks, another question will come. So technically this chapter will be accounting for 10 to 12 marks in examination. Clear? So let us first cover this. Please see the screen. See here. First one. What do you mean by rule of literal construction? First, everyone speak out the names of various rules of interpretation before we start with. I will write, just read. First one, literal construction. Second one, reasonable construction. Third one, harmonious construction. Fourth one, beneficial construction. Beneficial construction. Next one, exceptional construction. Next one, Hayden's rule. Next one, Ejusdem, Generis. These are all primary rules of interpretation. Primary rules of interpretation. There are two secondary rules of interpretation. Noscitur, Sociis. These are all Latin words. That's why we needless to say this is not English. So Noscitur, Sociis. Next one, Contemporanea Expositio. What is the next one? Contemporanea Expositio is the name of the concept. Okay. So now answer my question. What are all the primary rules of interpretation first? Literal construction, reasonable construction, harmonious construction, beneficial construction, exceptional construction, Hayden's rule, Ejusdem, Generis. What is these primary rules of interpretation? Along with the primary rules, how many secondary rules are there? Two. What are those? Noscitur, Sociis, Contemporanea Expositio. Totally 9. From this 9, one question will come for 5 marks to 6 marks. From all other concepts, another 4 marks to 5 marks will come. Understood? This is the agenda of this particular chapter. Let us begin. What is the rule? Rule of literal construction. Let us first focus on what is this rule all about. So let us begin. See here. What is the topic name? Rule of literal construction. Rule of literal construction. So let us try to understand what is this rule first. See here. Whenever there is any provision in the act, okay, bro, kudirte ito kuchova. Because off the camera I cannot see. If possible, come to the first bench, or else for you I need to see there. That will be easy for me, or else every time I need to concentrate on the corners. Shall we begin? Rule of literal construction. What this rule says? First one, there are 9 rules. Primary rule of interpretation will be rule of literal construction. How many rules are there totally? 9 rules. In that, what is the primary rule of interpretation? Rule of literal construction. What this rule of literal construction says? Let us first try to understand. Whenever you are reading a provision, I repeat, whenever you are reading any provision inside the law or in an act, always remember, give its grammatical meaning. Give its a grammatical meaning. Don't go for hypothetical interpretation. Simply to tell, when you are reading the text of law, read it as it is. Try to give the meaning which you are intended to give to that word. Like this, if I tell, people can't understand. Therefore, I will give super duper examples for you to understand. Before that, you see there. Read the first lines. The first and the primary rule of construction is that intention of the law shall be understood from the words of law itself. I will give you super example. Everyone here, do you know the concept of annual general meeting? Annual general meeting, right? Tell me, annual general meeting must be conducted in what way? What are the time limits to conduct AGM? Next, 6 months. Next. Next. No. What are the time limits? 6 months. Some people are saying 15. Next. No. Subsequent annual general meeting only. So listen carefully. Lawmaker will tell like this. See here. I will show you one point on the screen. First, try to understand that. Okay. Now see. What is the section we are seeing on the screen? 96. Everyone please concentrate properly, please. I can't repeat n number of times on a revision. Annual general meeting section. Every company other than one person company shall in each year hold, in addition to any other meeting, a general meeting as its annual general meeting, and shall specify the meeting as such in the notices. Like that they have given some data. First point number 1. What is rule of literal construction? Literal construction is a concept where read the law as it is. Read the law as it is. Don't unnecessarily give extra interpretations, unnecessary interpretations to the words of law. Understood? Intention of the law must be understood from the words itself. Repeat my statement. Intention of the law must be understood from the words itself. I will ask you one question, answer. See there and answer. See there and answer, no problem. I have 2 questions to ask. Okay? Every person in Zoom also please participate. I have 2 questions to ask. Question number 1. Is this section optional or mandatory? How do you know? That means intention of the law is understood from the words itself. Hello, everyone. What I say? Repeat. Intention of the law must be understood from the words itself. What is the words used? Shall. Shall is a mandatory force or an optional force? You have to do, may be done or may not be done. The word may represents optional. The word shall represents mandatory. So, the intention of the law. What is the intention of the law? Must and should you should conduct annual general meeting. How you understood? Did you do any extra interpretation? No. From the words itself. This is called as rule of literal construction. Ante, over. Understood? Tell me, what is the first and foremost rule? Rule of literal construction. Point 1. The first and foremost rule of interpretation is rule of literal construction. Very good. Done. Second one. The rule says that, which rule? Rule of literal construction says that the lawmaker's intention must be understood from the words itself. When the language is plain, concept is plain, clear, don't unnecessarily go for extra interpretations. Read the words as it is and give the intended meaning. Understood? Now read. The first and primary rule of construction is that intention of the law shall be understood from the words of law itself. First point, I think you are all understood. Next one, point 2. If the words of law are capable of giving only one meaning, then it is not open to the courts to ignore its plain meaning and adopting hypothetical construction. Tell me, what do you mean by shall? Is there any 2 meanings for the word shall? Answer. Is there any 2 meaning? English the word shall represents what? Something you have to do is called as a shall. Correct or not? And it is talking about something optional or mandatory. 2 meanings are possible. Only 1 meaning is possible. When only 1 meaning is possible, don't go for hypothetical constructions. Or hypo means beyond. Read as it is. Why you are unnecessarily going beyond the words of law? Listening? Now I will tell, repeat. If the language of the law is plain. Bad. Everyone repeat again. If the language of the law is plain, courts cannot go for hypothetical construction. That's it. 3 points you now answered. Tell me, what is the point number 1? The first and foremost rule of interpretation is rule of literal construction. Half mark. Second, the intention of the law must be understood from the words of law itself. Half mark. Third, if the meaning is plain and capable of giving only one meaning, even courts also cannot go for hypothetical construction. 1 mark. How many marks you got now? half and 1. Totally how many marks? 2 marks out of 5. Instead of writing all these, rule of literal construction is a interpretation. Rule of literal construction is a literal construction. Half mark also you don't give. Write what is there in study material, not what you remember. Understood? Over. Sir, first, second point, everyone understood or not? Answer. I will ask a question. Shall means what? Same question again. Answer. Mandatory. Sir, I will show you one point. See there. See the screen. What is this? I'm not joking here. This is not a timer. Please read. What is that? What do you mean by every? All. Okay. Next. Every company. Other than. What do you mean by other than? Except. Very good. Genius. Other than a one person company. What is this? Shall. In. What is this? Each. I will ask you questions now. Okay, one by one you answer. Why you will not remember interpretation of statute chapter? I will see. Endu gurtu pettukone nenu chusta. See there. First point. What is this word? Shall means what? Compulsory, optional, compulsory. What is this? What do you mean by each? Every. Okay, each year means every year. How do you know all these meanings? Such a genius people you are. ఇంత జ్ఞానం ఎక్కడి నుంచి వచ్చింది? ఎవ్రీ మీన్స్ ఆల్, అదర్ దాన్ మీన్స్ ఎక్సెప్ట్, షల్ అంటే కంపల్సరీ, ఈచ్ అంటే ఎవ్రీ. హూ టోల్డ్ యూ దట్ ఆల్ యూ రిమూవ్? అబ్బా, నా డైలాగ్ నాకేకు. సో మై క్వశ్చన్ ఈజ్, హౌ డూ యూ నో that these are the meanings assigned? I didn't tell any time before. Grammatical meaning. What meaning? When the words of the law is plain. Repeat. Give what meaning? Grammatical and natural meaning. Which meaning? Grammatical and natural meaning. Read this. The cardinal rule, cardinal means the basic rule, is that statute means the law, has to be read literally with its natural or grammatical meaning. Did you give any extra? Every means what? Like this you did not tell. Every means all. One line you said. Until you are not going hypothetically for any interpretation. Every means what? Normally in English, what do you mean by every? Every means all. How easily you said? Ante, from this what common sense you should understand? Law 99 cases out of 100 cases goes with literal interpretation only. Goes with literal interpretation. Whenever literal interpretation fails, what I said? Whenever literal interpretation fails, or literal interpretation is giving 2-3 meanings, then you should go for reasonable construction. Then you should go for, or you go for reasonable. If not reasonable, next. How many rules of interpretation are there? Tell me loudly. Everyone, tell me all the 9. Literal construction, reasonable construction, harmonious construction, beneficial construction, exceptional construction, Ejusdem, Generis, Ejusdem, Rule, Noscitur, Sociis, Contemporanea Expositio. Last one is not there in your syllabus. Expresso unius est exclusive alters. That's there in the previous part. Now recently deleted in the syllabus. Sorry. Summary I will tell. How many rules of interpretation are there? Loudly? Wrong. Only 2. Number 1, literal. Number 2, reasonable. Reasonable, those are 8 are there. First, this general knowledge if not there, interpretation of statute chapter, even if you read, you did not read. There is no separate concept called as reasonable construction. Reasonable construction means all other constructions other than literal. What I said? when the literal construction fails, give a reasonable construction, or reasonable varieties are there. What varieties are there? Harmonious construction, beneficial construction, exceptional construction, Hidden's rule, Ejusdem Generis, Noscitur, Sociis, Contemporanea Expositio. These are all the rules in reasonable. Understood? Tell me. I want you to answer 1, 2, 3, 4. If the meaning is plain, go for. If the meaning is plain, go for literal construction. Don't go for hypothetical construction or reasonable construction. Do not go even for the case laws. Do not go even for the. These are the 4 points. 4 points will give you 3 marks. One by one. Read. What is the first one? The first and primary rule is that is the rule of literal construction. The first and foremost rule is the rule of. Yeah. Okay. Okay, see here. The first and foremost rule of construction is rule of literal construction. Number 1. Okay. As per rule of, that is first point. As per the rule of literal construction, words of the law must be understood from, intention of the law must be understood from the words itself. 2 points. Next, if the words of law are capable of giving only one meaning, even courts also cannot go for hypothetical construction. Second point also over. Next one. The cardinal, the basic principle is that whenever the words of law are there, which meaning you should give? Natural and grammatical meaning. Natural or grammatical meaning. When the language is plain, don't go for case laws. Don't go for. And every means what? Is there any Supreme Court case law? Overaction of the. Every means very clear. What do you mean by every? All. Why you are going for case laws? Understood the point or not? Every company means what? You should not get the company to overaction of the company and company. Understood the point or not? So therefore, when the language is plain, don't go for hypothetical, don't go for case laws. That's 4th point. Read. Read. Read it. If the meaning is plain, then it is not desirable to make the reference to cases. Don't go for cases. If the language is plain. Next. Again same. Language used in the statute is clear, unambiguous. Ambiguous means unclear, vague. Unambiguous means clear. Crystal clear. Everything is very clear. Every company shall hold. Where is the doubt here? Everything is clear. So tell me, if the language used in the statute is clear and unambiguous, and it is capable of only one interpretation, it is not correct to move out of natural or ordinary meaning. When there is a choice to make. Sir, 2 interpretations are there. Tell me, every company means some companies, all the companies, 2 interpretations are there. Some companies means narrow interpretation. All companies means liberal interpretation. Which we will go for, wider or narrow? Answer. See there. When there is a choice to make between 2 interpretations, a narrow and wider one. The narrow interpretation fails to achieve the purpose, then one should adopt for a wider one. So everything, if you observe, all the points are giving same answer at the end. Clear? These all points are there in your study material. Examiner, they are giving all these points in the key. If you write, you will get 6 marks. But one thing you tell me, is these points difficult? Answer. Student don't read this chapter and they will go to exam. 10 marks they will leave. If you read properly, 2.5 3 hours we can complete this entire chapter. 10 marks pakka. Clear? So let us begin. First one. What is the first and foremost rule? Rule of literal construction. Intention of the law must be understood from the words itself. 2 points over. Next. If the words of law are capable of only giving one meaning, courts also cannot go for hypothetical construction. Whenever the words of statute are given, first try to give them a natural and grammatical meaning. Number 4. Next, number 5. Case law, sir. If the meaning is plain and capable of giving only one answer, then it is not desirable to go for case laws. Next, if the language is clear and unambiguous and capable of only one interpretation, it is not correct to move out of natural or grammatical meaning. Natural or? When two interpretations are possible, one is a narrow one and another one is a wider one, and narrow one fails to achieve the purpose, go for wider interpretation. Understood the point clearly? With this, we completed 1, 2, 3, 4, 5, 6 points we completed. Okay? I will put it before you. 2 minutes time I will give. Please read it. Whichever book you are following, you follow that. But mine is a complete copy of study material, because from that only key will be prepared, from this only marks will be given. If you are following a material where these points are not there, first to close that and read this. If that material also contains these points, you are safe, because these are the points taken from study material. These are not my own point. If you have doubt on me, open study material and see. All these points will be there. Two minutes time. Read all the 6 points. Once you complete all the 6, I will go into the next part, natural and grammatical meaning. Thorough? Clear? Can I move to the next one? Okay. Now, what we completed now, can you please tell me? Rule of what construction? Literal construction. Okay. Examination la, there is one 2 marks question that is coming very frequently. What is it? Explain about natural and grammatical meaning. Explain about 6 keywords you have to remember. How many keywords? 6 keywords. Okay, let us see. I will write, see here. Remember this. What are these? NPO, PLG. Okay, these 6 words you have to write in exam. First I will explain what is this NPO, PLG. Clear? Listen. First statute has to be read. Statute here represents what, sir? Whenever I said statute, statute means what? Act. Statute means what? Act. Act has to be read. Act has to be read in its natural, repeat, in its popular, ordinary meaning. Start again. Act has to be read in its natural, popular and ordinary meaning. And naturally, popularly, ordinarily, generally, what meaning you will give for that? That meaning you have to give. Every company, every, naturally, generally, in your normal life, ordinarily, what meaning you will give for every? Anything. Correct or not? That meaning you have to give, such that which interpretation it should give? Plain, literal and grammatical sense. It should be understood in a plain, literal and grammatical, and as per grammar. If I open dictionary and check, that meaning should be there. Normally in our childhood, grammar we will see is, was. Was means what? Present or past. Is being, going on, continuous. Correct or not? And what you have to understand from here, whenever words are clear, first thing, always remember, law has to be read, act has to be read, statute has to be read in its natural, popular and ordinary meaning, and should be understood in a plain, literal and grammatical sense. Is 6 words. Repeat 6 times. Not like that. Tell the statement and repeat. Statute has to be read in its natural, popular and ordinary, such that it should be understood in a plain, literal and grammatical sense. Repeat. Statute must be read in a natural, popular and ordinary meaning, or words of the statute must be given. Repeat. Words of the statute should be given natural, popular and ordinary meaning, and should be understood in a plain, literal and grammatical sense. If plain, literal, grammatical sense is must be read as per natural, popular and ordinary meaning. It should be construed in its plain, literal and grammatical sense. If the plain meaning is giving rise to absurdity, repugnancy or inconsistency, then one can go for beyond the grammatical meaning. Beyond grammatical meaning we call as what? Reasonable construction. Reasonable varieties are there. So first clarity, read entire literal construction concept. Exam literal construction came for 6 marks. What we have to write? Everything you have to write. This full page if you write, then they will give you marks. Understood? Read it. Understood up to here clearly? Can you move to the next one? Natural grammatical meaning also understood? Next one. See here. What is the next rule? Ejusdem generis. So what is this rule of Ejusdem generis? Let us try to understand. See here. Rule of Ejusdem generis. Last attempt this question already came. Okay. But I will go in a sequence and complete. Whether came in exam or not came in exam is irrelevant. When it came in the very last attempt, I will give lesser importance to that rule because chance of recurring again is very less. So listen. What is rule of Ejusdem generis? First, there should be enumeration of certain specific words. There should be enumeration means explanation, enumeration or usage. There should be specific words. There should be enumeration of specific words. Enumeration of specific words. General words should follow specific words. Everyone repeat. General words should follow specific word. Specific words should fall into same category. Specific words should fall into same category. Specific words do not exhaust whole category. Specific words do not exhaust whole category. There is no other legislative intent. There is no other legislative remit. Take a minute time. Read all these 5 points first. I will tell the meaning of each and everything. Take a minute time. Read all. Okay. Shall we? First tell me. What is the first? These are all the 5 points you need to write when they ask about Ejusdem generis. When Ejusdem generis will apply? 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 Answer. When Ejusdem generis will apply if 5 conditions are satisfied. Number 1. There should be enumeration of specific words. Specific words are followed by general words. Specific words should fall under same category. Specific words should not exhaust whole category. There is no other legislative intent. Sir, I did not understand. Now I will give you super example. I said like this. I have huge fear towards lion, tiger, leopard, etc. What I repeat? I have a huge fear towards lion, tiger, leopard, etc. Now you answer my question. Lion, tiger, leopard are specific words falling under same category. Wild animals, 4-legged wild animals, not reptile kingdom. Hey, understood? Start again. I have a huge fear towards lion, tiger, leopard is a specific word. Etc. is a general word. Specific words will fall under same category. There are only 3 wild animals. So many wild animals are. Loudly. So my list is complete list of wild animals. It is only 3 examples. That's what he said. Specific words do not exhaust whole category. Exhaust means complete. Listening. In such case, what meaning you should give to general word? General word should take the meaning from previous specific word, not from normal general word. Etc. means ant, sheep, goat will not come. I am using that etc. in connection with wild animals, that too 4-legged wild animals. Listening or not? Dog will come or will not come? Will not come, because dog is not a wild animal, it's a pet animal. Domestic one. Buffalo, bulls and oxen, horses, camel, these all elephants, all these will not come. Understood the point or not? Listening? We are talking about the canine family, cat family. Understood the point? So tell me, what is my example? I have huge fear towards lion, tiger, leopard, etc. A lion, tiger, leopard falls under wild animals, four-legged wild animals which lives in jungle. And all belongs to one family called as a cat family. In that connection, you should take the meaning for the word etc. Not whatever you want. Understood? Huh? Loudly? Very good. Now you answer my question. Okay? Now you answer my question. This I understood, this I understood, this I understood, this I understood. But what is this? There is no other legislative intent. What do you mean by that? What do you mean by that? These minute details, once you understand, you will never forget about this line to write in exam. Whenever a person asks what is Ejusdem Generis, first you will tell this only. Why you are not remembering? Because you don't know the meaning. Correct or not, everyone? Why you don't remember? Simple answer. Yeah, you don't know the meaning. When you don't know the meaning, you will not remember. Listening? Sir, in connection, just for your understanding, I will tell. There is one Hindi movie made in Telugu also, but Telugu movie what is made is not that much good. There is one movie called as a Lage Raho Munna Bhai. It was made by Chiranjeevi in Telugu. Not that good, but Hindi movie, original movie is really good. In that movie, do you know what will happen? He will read about Gandhi, Mahatma Gandhi. Sanjay Dutt used to read about Mahatma Gandhi. He digests everything when he read. He will not just read and throw the book like us. He will read, he will imagine, he will digest into his bloodstream nervous system that Gandhian ideology will go. 200 pages book it is, example. 170 pages he will read. How many pages? 170 pages, example I'm telling. 170 pages he will read. In that 170 pages, whatever the content he used to read, everything used to go into his nervous system. Okay, in his bloodstreams that Gandhian ideology is already there. Whenever one person, for example, he will ask, what is the father's name of Mahatma Gandhi? Immediately Mahatma Gandhi used to come at the back. He used to tell his father's name. Means really Gandhi came, No, you digested everything. You understood, na? As if Gandhi is standing before you, you are confident. Listening? Later 30 pages you did not read. On that if a question comes, he will look for Gandhi. Gandhi will not be there. Such a great ideology the movie has. What do you mean by that? When you understand something, when you digest something and read, automatically you will remember the contents. You don't know what is the meaning of this sentence, then how will you remember? You will not. FM also I told the same when you came to the class. When you understand something, you will remember. When you don't understand, mugging up for 10 times, sitting for 10 hours in a study hall will not make you a perfectionist. Clear? So what is this meaning? Let me first explain with examples. Okay? From Companies Act, I will show you examples and tell you. Okay? See. I will show you one example. And the thing is, example is one section before 96A. See? Registers, etc. Registers, etc. Asal, what is this, etc.? What is this, etc.? What is this, etc.? Listen. Is this specific word or general word? Specific word. Etc. General word. General word should take the meaning from specific word. Register, what will come? I don't know. In registers, what will come? Registers, indices, annual returns. These are the three only that comes into etc. Legislative intent is to cover only three into that etc. You can't include any other thing. Ejusdem Generis do not work here. Understood the point or not, everyone? Ejusdem Generis will work or will not work? Will not work. Sir, registers, etc. Registers? Vouchers, bills, invoices, letterheads will come into that etc. No, will not come. Will not come because lawmaker intention is very clear to include only three into that. What are those three? registers, indices, and annual returns. That's all. This is how you need to understand this final statement. In that section 95, the term etc. wanted to include everything into that, or wanted to include only 3? 3, since I can't write in the heading, I have written etc. But etc. does not mean include everything you want, include only 3 what I want. There is a restriction in the legislative intention. Rule of Ejusdem Generis do not work. That's what this meaning. Understood or not? Tell all the points. Now you will remember everything. Tell me, when Ejusdem Generis will apply, there must be enumeration of next, specific words should be followed by general word. Specific words should fall under same category. Specific words should fall under same category. Specific words should not exhaust whole category, and there is no other legislative intent. If legislation intention nothing is there, then what will happen? You can include whatever that comes inside that. Understood or not? This is how Ejusdem Generis has to be understood. Clear? Next. The 96 section you can read 95 mean. At the time of learning itself, you should learn interpretation. That's why regular classes what I do is, interpretation of statutes I will not teach as a separate chapter. While reading the Companies Act itself, we will complete parallelly. Then how much clarity student will have? Okay, but no problem here. Humanly, as a human being, whatever best we can do, we will do in these 3 days. You know about me in FM already, we have seen. Humanly, whatever I can do, everything I will do to make best out of these 3 days classes. Clear? Let us see. Now you understand all the 5 points. Clarity, yeah? Okay. Non-applicability of the rule. When this rule does not apply, read. If the enumeration itself contain general words, means nothing specific there. Nothing specific. All are what words? General words they are using. When general words you are using, nothing specific in that, I can't use the rule of Ejusdem Generis. Second one is very important. Read. Particular or specific word exhaust the whole category. Repeat again. Particular or specific words exhaust whole category. Sir, what does this mean? Listen, I will give you this way. What do you mean by exhaust the whole category? Exhaust the whole category means, I said like this. This scientist is doing research on Mercury, Venus, Earth, etc. What will come into that etc? In all planets, Andromeda galaxy, every galaxy, whatever planets will come into that. First understand the rule. Specific words are how many here? 3. Mercury, Venus, Earth. What are all these 3? Planets. Wrong. These are all planets in our solar system. These are all planets in our solar system. Our solar system, how many planets are there? 8. How many? 8. Forget about Pluto. It's a dwarf planet and unrecognized now. I'm talking regular and recognized. How many? 8. 3 I used and said etc. In etc. what will come? All planets in universe. Our solar system. So now tell me. There is a enumeration of specific words is followed by general word. What is the general word? Etc. So on. Others like that I used. Okay. Done. Specific words belong to one common category. What is that? Solar system planets. Next. All planets names I said only 3 are. So can I use the word etc. now? Yes. What is etc.? What is etc.? What will come into that etc.? Mars, Jupiter, Saturn, Uranus, Neptune will come into that etc. Correct or not? This is how Ejusdem Generis can be used. I said like this. This scientist is doing his research on Mercury, Venus, Earth, Mars, Jupiter, Saturn, Uranus, Neptune, etc. నీ బొంద ఇంకేముంది ఎక్సెట్రా? Over all the things you only said. Understood or not? When you said everything, what is the meaning of that etc.? Etc. has no meaning now. That's the point. Understood the point or not? Answer. And moreover, first point, did you understand? First point here. First point what they said is, when you use specific words, those should be specific words first. Belong to one common category. I used to tell one story always. You should understand. When Lord Brahma appeared before Hiranyakashipa to ask for a boon, you have to ask or not? I should not be killed in the morning, I should not be killed in the evening. Like that you used to ask, na? Okay. He has given a list. Ejusdem do not work there. What they said, Galini Kumbini Agni Ambula Akasastalin Dikulan Relan Hasramulan Tama Prabala Bhuri Graha Raksha Murga Vyala Jentu Kalahan Nasti Samastastra Sestranic in Maranamani Jivambuloka This Pimpaway. Means he has said a list where Ejusdem Generis do not work. All are coming under different category. Relan Hasramulan Tama Prabha Bhuri Graha Raksha Murga Vyala Jentu Kalahan Nasti Samastastra Sestranic. There is no common category that is falling inside. So, whenever you say something on law and to apply Ejusdem Generis, all should fall under one category first. Clear? I have fear towards tax, income tax, GST, etc. Now I can understand. Okay, taxation law you are having a problem. Law law you are having a problem because all are coming under one category called as law subject. Income tax law, GST law, company law, FEMA law, you are feeling difficulty. I have fear towards accountancy, taxation, financial management and so on. Now I can understand you are having a problem with the practical papers. I have fear towards accounts, law, etc. Oh, CA gone. So, your etc. cannot be interpreted by Ejusdem Generis now because all are not falling in same category. I think now you understood what is the rule of Ejusdem Generis. That's the point. Now we completed another rule of interpretation. What are the two rules we completed? Literal, Ejusdem Generis. Over. Next. What is this? Noscitur Sociis. Sir, very easy. 90% similar to Ejusdem Generis, 10% different. What is Ejusdem Generis? From now EG, when I use Ejusdem Generis, okay, what is the EG rule? What is the EG rule? There should be specific words are followed by general words, specific word falls under some category, it should not exhaust whole category, no other legislative intention. Then general word should be taking the meaning from previous specific words. Hopefully you understood the point or not. Done. That is the meaning. Meaning of what rule? Rule of what? Ejusdem Generis. Everyone understood? Noscitur Sociis also same with a minor change. Words are used. Words are? All are similar and analogous. Analogous means same category. See? And it is followed by one word. That one word is having 2-3 meanings. Sir, like this if I tell you can't understand. Like Ejusdem Generis, I will first give example. I said to you, shall we? My bag containing, I went to a police station. Okay? I went to a police station and complained. Listening, my bag containing journal book, ledger book, okay? Journal book, ledger book, and subsidiary books, and a scale. Like that I made a complaint. Which scale? Richter scale, earthquakes they will check, na? That scale. In what conceptual point of view I'm telling you? Journal ledgers means handwritten journals. Listening or not? Ledgers means which scale? Normal ruler scale. Listening or not? Scale is a general word, a technical word, a general word. It has one meaning, 2-3 meanings are. Or I said like this, my bag containing toothpaste, toothbrush, towel and oil is missing. Oil here represents grease oil, petrol, diesel oil. Which oil? Hair oil. How do you know? From the category of words you are using. Now did you understand or not? What difference you found between Ejusdem Generis and Noscitur Sociis? Ejusdem Generis la general words they will follow. Specific words first, general words next. Noscitur Sociis the specific general will not come. Specific words will come. Another normal word which is similar to that will come, but that word has a 2-3 meanings. You should give that meaning which is similar to the previous words. Listening? Read. 2 marks answer. Read. When 2 or more words are susceptible of analogous to each other, then they must be understood in their cognate sense. Cognate means in a general sense, giving the same meaning. The general word shall take its color from previous words. Read it. Okay. So tell me, when 2 or more words are susceptible, susceptible means are sensitive of analogous to each other. Okay. Next, then they must be understood in their cognate sense. And when you are using that, they all will come under one category or not. From the category only, it should take the meaning. Cognate means from the general understanding of that sequence. Toothpaste, toothbrush, towel means these are all human consumables. In that concept only, you should use the general words also. Clear, everyone? My bag containing a wrench. Okay, my bag containing a wrench. Listening, everyone? My bag containing a wrench. Okay, next, oil puller. And oil is missing. Now, oil means which oil? Grease oil is talking about. Because the category, cognate sense, you have to understand the general word. Clear or not, everyone? And this is similar to which rule? Ejusdem Generis, but Ejusdem Generis is direct general word they will use. But here general word has multiple meanings. Understood? Okay, done. Noscitur Sociis over. What is the next one? Listen. Very important rule. Listen. What this rule wanted to tell. Concentrate. If this is completed, how many rules will complete? 4 rules will complete out of 9. Okay. What this rule says. See. This rule is based on a concept that, please listen, whenever you are reading a law section, you should read from the effect what is given on the date on which the law is made. Sir, I didn't understand. Again, example only will make you to understand. There is one case law happened in India. 1993 case law. J. Manjiram versus Fericiosias. J. Manjiram versus Fericiosias. This fellow is from Italy. This is an Indian director. We Italian director. Okay. Hello, listening? So I will write J versus F. J is a Indian director. F is a Italian director. Case happened in which year? 1993. Supreme Court case law. What happened? Let us see. Small thing went up to Supreme Court. 285 section of Companies Act, old Companies Act. 1993 means 1956 Companies Act. In the Companies Act, what they said in 285 section? They said, board meeting notice. Board meeting must be given by or hand delivery or director. I am talking about general meeting or board meeting. Board meeting and whose meeting? Shareholders meeting and directors meeting. You are a director. You came to registered office. I gave to you directly, sir. Meeting is there in another 15 days. Please come. This is called as hand delivery. You are not here. You are in Bangalore. I am in Hyderabad. I wanted to send you. Post I will send. These are the two ways. Listening, tell me. As per section number, board meeting notice must be sent by post or hand delivery. This is what used in which section? 285. What happened in this case law? In a particular occasion, this company conducted a board meeting. Notice must be sent or not? They sent notice by fax. To the Italian director J. Manjiram. Because post is taking 20. Okay. See here. What I said in that case law. Let us continue. What is the name of the case law? First tell me. Jai Manjiram versus Ferruccio-Sias. Jai Manjiram versus Ferruccio-Sias. This fellow is in Italy. This is in India. This Indian director is a Jai Manjiram. He is a managing director of this company. This person, what he did, post is taking 25 days time. Hand delivery impossible. To give you notice, I will come to Italy. A picture. Why I will come to Italy to give you a notice? I will not. Oh, hand delivery out of question. Post will take a lot of time. Listening. I wanted to conduct a meeting in how many days? 7 days. General meeting is 21 days. Board meeting is 7 days as per law. Therefore, 7 days law, at 1993, 7 days law, post will reach Italy. Today only it will not reach. So they understood. Practically it is possible or not possible? Not possible. But there is a problem. If you don't send the notice, meeting becomes invalid. Formality, you should send the notice. But sending a notice is not viable because it will reach after 25 days. And a meeting complete in 3 weeks, he will know about meeting. Which is unnecessary and undesirable. Then what company thought? Let us send by fax. Send by? This company director purchased a fax machine in India. Okay, at that time very new. 7,000 rupees they spent in 1993. Purchased a EPBAX machine and a fax machine. Fax machine purchased. And what they did, with that fax machine, he took the fax number of that foreign director, listening, put that paper inside the fax machine, sent him a message. Sir, there is a meeting on so and so date. If possible, please do attend the meeting. Like that, they sent a formal notice to the board of directors. Listening, Ferruccio-Sias also received a notice. He saw over, up, Up to there, everything is going well. Meeting conducted. Jai Manjiram from Italy, he didn't come. Sorry, no one will come for that case. He also did not attend. Over. Resolutions are passed. Meeting is completed. Minutes are prepared. Everything over. Jai Manjiram sent a lawyer in India to the court saying that section 285 has been violated. You should send only by post or hand delivery as per section 285. I received notice by fax. They listening or not? I received notice by fax. How you should send? Post or hand delivery. I didn't receive hand delivery. Post also I did not receive. I received by what mode? Fax mode. Valid or not valid as per law? Loudly. This is called as interpretation. When interpretation fails, construction starts. What I said. You know literal interpretation? Tell me what is literal interpretation? 3 lines you tell. The first and foremost rule of interpretation is rule of literal construction. Number 1. Second, the intention of the law must be understood from the words itself. From the very good. Now you tell. Notice of a board meeting must be sent by post and hand delivery. Law intention is understood from the words. Tell me what you understood. Post? No. Oral notice is not valid. That's the intention of the law. What is not valid? Oral notice is not valid. Ra, Uchai, Ingava. Like that you should not do. Idra like that you should not do. There should be documented proof. That's the lawmaker intention. Mode is not important. Making the notice available to the person in a written form is a lawmaker intention. Understood the point or not? When you read the law, what you will see? Post hand delivery. What do you mean by post hand delivery? Send by post, send by hand delivery. No, you are seeing the mode. You are not seeing the lawmaker intention. Understood the point? What is the lawmaker intention? They send notice in a documented format. Proof will be there that you sent. Fax will have a proof. Pakka proof will be there. When message started, when message reached, whether reached or not, delivered or not, everything will be available. Listening? Matter went to Supreme Court. Lawyer belonging to Fericiosias came. Jai Manjiram also went to court. Fighting started between both of them. They said, what is happening? Court cinema style, it happened. One judge is sitting in between. He is asking, what happened? Explain the case. He explained everything. He is explaining everything. He said, so at the end, judge has to give a judgment or not. Then lawmaker intention was coming out. He said, sir, as per the rule of literal construction, post means postal. Hand delivery means one person has to come. Since notice is not received by post or hand delivery, notice is invalid as per law. This is literal interpretation. But you should not interpret that way. When literal construction fails, reasonable construction starts. In reasonable construction, one of the reasonable construction is what? Contemporanea Expositio, which says that whenever you are reading the law, which is made in the long back, you should read that long back provision from the contemporary situations. If law is made in 1993, when this case happened? If law is made in 1993, if 1993, fax machine is available or not? Lawmaker would have included fax into the law or not? 1956, when law is made, fax is there or not? That's why fax is not there. That does not mean fax is an invalid communication. That's how judge has given the judgment. Understood the point or not? The word fax is there in the section or not there in the section? Loudly. Not there. But judge said that fax is a valid communication. Using what? Using what? Construction, not interpretation. Interpretation means reading the law as it is. Construction means forgetting about the words, giving the meaning intended by the lawmaker is called as construction. Understood the point? Huh? That's why this is important. Contemporanea Expositio. Expositio means old position. Contemporary means today. Old law, don't read from the old circumstances, read from the today's scenario. Understood? This is our interpretation. I think you now understood interpretation of statutes in a proper way, right? Read the point. Start. The rule is based on a concept that statute or a document shall be interpreted on the basis of exposition it has received under contemporary situation. Law should be understood in a sense in which it was understood when it was passed. Means, go back to 1956. At that time, lawmaker mindset you read. At that time, facts is not there. That's why facts is not there in the law. That does not mean facts is a wrong communication. Understood? You should remember and mug up these 2 lines. Will you remember? You should revise it 10 times, 15 times. Now you understood, na? 10, 15 times you need not. 2, 3 times if you revise and remember, examiner will write the right answers. What examiner is doing is, 4 marks questions they are giving. How? 2 marks each. Explain the following. Noscitur Sociis 2 marks. Contemporanea Expositio 2 marks. 4 marks if you write these 4 lines. Hopefully everyone understood. I am making it full screen. Read for 2 minutes. We will be going into next interpretation rules. Have you read both? Can we go into the next one? So what we completed now? There are 4 rules of interpretation that we have completed which are very important. One is rule of literal construction, rule of Ejusdem Generis, Noscitur Sociis, Contemporanea Expositio. Okay? Now, let us now move on into the next set. What is the next one? Headens rule. Sir, Headens rule, beneficial construction, both are similar, but institute divided both of them and given 2 different concepts. Sir, how do you know both are similar? Actually, interpretation of statutes is in CA final. Now they brought from final to inter. Listening, since I am teaching for past 12 years only for CA final, because we know what is there. Previously, Headens rule used to be merged in beneficial construction. Inter level, they broken that into 2 concepts now. Shall we continue? First, I will give you beneficial construction. Later, we will go for Headens rule. Simple. Beneficial construction says that whenever act is made for unprivileged sections in the society or for which society? Unprivileged means poverty, simple kind of factory workers, labor intensive factories, these kind of persons, for them some laws are made in India. For them some laws are made in India. Whenever you read those laws came for what purpose? Benefit. Benefit to whom? Poor and underprivileged sections. Correct? Bring and read the sections in such a way. Bring as many beneficiaries into the provisions. If I tell like this, no one will understand. Again, I will give example. There is one act called as a Payment of Bonus Act. What is it? In that one case law happened. Autonagar Karmachari Sangh versus Commissioner of Bonus. What happened? Let me explain. In that particular company called as Autonagar Karmachari Sangh, it's a workers union. It is a workers union in Uttar Pradesh. Workers union in Uttar Pradesh with the name called as Autonagar Karmachari Sangh. It's a group of people forming a Sangham. That's called as Autonagar Karmachari Sangh. What happened? In that particular factory, it's an automobile repair factory. Autonagar Karmachari Sangh, automobile workshop. What they did? Autonagar Karmachari Sangh, lorries, trucks, big vehicles used to come and stop and do their repair work there. 24/7 they have to work. Means what will happen if 24 hours they work? Some people will come in the morning, some people will come in night shift. Autonagar has to work 24/7 to service the people. Why? Common sense, na? Vehicle traffic will be there 24/7. Correct? Highways, lorries will go more on night time. Cars and others will go more on morning time. When traffic will be there on highway? 24/7 traffic will be there. Therefore, Autonagar has to work 24/7. Rule over. This Autonagar Sangla people, they work on a shift basis. Some people will come in the morning shift 6 hours, mid shift 6 hours, night shift 6 hours, 6-7 hours. 24 hours they divide into 88, not 6, sorry, 8. Some 8 hours, mid 8 hours, night 8 hours. 3 shifts people used to work. Listening, huh? Bonus will be paid to employees. This is the word used in Payment of Bonus Act. Bonus will be paid to employees or workers. Employees are workers. Sometimes what used to happen, whenever big vehicles come, which vehicle? Big vehicles come. 5 people, 6 people cannot work. 20, 30 people has to work simultaneously. Then only we can complete that in 1.5 day. Therefore, they used to bring some people on a part-time basis from other places, nearby villages, like that they used to call. They used to work, take money for the part-time work, they used to take money and go. Doubt came whether to pay bonus to them or not. How did you understand or not? Answer, sir. Doubt came whether to pay bonus to that part-time workers or not. Okay? Matter went to the court. These part-time workers in one particular month, 1,600 people started working in part-time. They all formed one Sangh called as Autonagar Karmachari Sangh, filed a complaint in the court, saying that we are not receiving bonus. Matter went to the court. Court read, bonus will be paid to employee. Are you an employee? Ante, I am not employee, sir, part-time employee. Now doubt came, whether part-time employee can be treated as a employee or not. If you say employee, he will be paid bonus. Now tell me. Then they thought, okay, why Payment of Bonus Act is made? Not answering. Why Payment of Bonus Act is made? To punish people, to give benefit. When your intention is to give benefit, why to give benefit only to a certain category? Give to everyone. Therefore, employee includes part-time employees also. Even if you work 1 hour, for that payment you should add bonus. As understood everyone. What is the word used? Employee. Part-timer, full-timer, seasonal, employee, employee, that's it. The word employee is having one meaning or multiple meanings. That's what I said. When the meaning is a plain, go for literal. Here meaning is not plain. Then you cannot go with literal construction. Must and should the rules of which interpretation should fall in place? Reasonable construction. In that reasonable, which type of construction should come? Beneficial construction has to come. Are you listening? Tell the answer. Read. It is a method of interpreting the provision liberally so as to give the effect intended purpose of legislature. What is the purpose of legislature in making bonus act? You are not answering. What is the purpose of legislature in bringing bonus act? To provide benefit. That you should keep in mind, not the words. Read. Where a provision is made to provide benefits to the people who are underprivileged in the past, sections should be read to give extended meaning so as to benefit all. As it is in study material. Whatever any third party material you are reading, see whether these words are there or not. If there, you can follow that material. If not there, you are under a warning bell. Keep the book aside, read the study material. Okay? Hello, listening. Sir, I will show you study material. Yeah. You need not even believe me. Which chapter we are reading here? Interpretation of statutes. Okay? Which construction we are reading? Rule of beneficial construction. 2.18 19. Other contents you leave. Main point, what you need to write in exam. All these three things you have seen in my notes or not? First, liberally you have to read for giving the declared intention of the legislature. Underprivileged in the past. In such cases, it is permissible to give what meaning? Extended meaning. Employee means don't just tell employee, extend that. Liberally you read. Employee means what? Present employee, past employee, probating employee, peace rated employee, hourly rated employee, seasonal employee, part-time employee, every employee. Bring as many into that net. Intention is to give benefit means why to give benefit only to one or two? Give to everyone. Whoever carries a tag called as employee, give benefit to everyone. Understood? The book, whatever you are reading, you can tell me honestly, do you find these points inside? Strike it out. Put the book aside. Useless. Because from that questions will not come in exam. Answers will not be from that materials. Clear? So therefore, study material, study material, study material. Always stick to study material. Because key will be prepared not by me, not by anyone. Key will be prepared by ICI. They will check answers from the institute material. Listening? Sir, tell me, I discussed in the class from the study material. You read. Is it really difficult? Can't you remember? It's a habit of reading simple things. Bad habit. Listening? It's a very bad habit of reading simple things. And people are making students as thinking that they can't understand. In the concept of simplification, the main essence is going out. Marks will not come at the end of the day. That is important for us. When you are not giving out the content in the study material and writing some third party content, why you will get the marks? Obviously we will fail. Listening? Passing with 40 if it is the intention. Any book you can read, they will give that 40 if you write something. But our intention is not 40 kada. Other laws of 30 means we should target 25. That can can be achieved only if you read study material. Listening? That's the main point. Sir, okay, everyone understood what is the beneficial construction clearly? Yeah. Tell me what we completed, what are the rules we completed one by one? Tell. Literal construction, Ejusdem Generis, Noscitur Sociis, Contemporanea Expositio, rule of beneficial construction. 9 lo 4 5 completed now. Give me 2 minutes time, we will complete Hedon's rule also. Okay? Now, what is the next rule? Hedon's rule. This rule is also called as a mischief rule. Which rule? Mischief rule. Sir, what is this mischief rule? I will explain this way. We read up to here. We are now going into mischief rule. 1, 2, 3, 4 questions are there. Okay? Those 4 questions, if you can answer, then Hedon's rule will be applied. What will be applied? Hedon's rule will be applied. Sir, what is Hedon's rule? Hedon's rule always say that whenever a section is made, whenever a substance over the form, what is it? Until you should not see the form, you should see the substance. What is the main intention you should see? Sometimes words may give one meaning, but the intention inside the words will give a different meaning. Listening? Again, same. Like this, if I tell you, may not understand. I will give one example, 2 examples, one general example, one Companies Act example. One general, one Companies Act. Then we will read this. You will automatically remember entire content. Start. Number 1. What is the thing you need to remember and understand? Shall we see here? There is one case law. There are four girls harassing one boy in London. Maybe Jambalakade Pamba type. Okay. How many? 4. 4 girls started harassing one boy when he is going on a road, street. When he is going on a street, they started using bad, foul words on him, started harassing him. This fellow is a sensitive person. Immediately he went to the local court and filed a complaint. Sir, I know these 4 girls where they stay. I stay in a hostel for my college. They are staying just opposite to my hostel. They are harassing me. They asked, do you know their names? Names I don't know, but where they stay, because I see them every day. Sir, okay. I will send a court notice to them, he said. Sent a notice. All these 4 girls attended to the court hearing. Judge asked, did you harass them? Shamelessly, these people also said, yes, we did. Judge said that under Street Offenders Act, repeat, any harassment or using a foul language, etc., on the street by any gender, male on female or female on male is irrelevant. On any one person on another, even male on male also. If a person is going making bad comments on him, it's an invalid thing. Under which act? Street Offenders Act in London, foreign case law. Okay? Street Offenders Act law, what they say? Harassment or any other foul language used on the streets on any person by any other person is strictly offended and is punishable under Street Offenders Act. This is what said in the law. Up to here, understood or not? Over. First time they did mistake, now court also said warning for all the 4 girls. Never do this again. We should not be repeated. Next time if it is getting repeated, severe punishments will follow. So don't invite unnecessary legal complications. Go out. Pay some penalty, they said. Some penalty they paid, left. They started keeping grudge on him. Same hostel, opposite hostels. 5-6 days after, from the hostel balconies, they started harassing him. Understood? From the hostel balconies. They used to, balconies will be there. He is standing on this balcony. These 4 ladies are standing on this balcony. They started harassing him from the balconies. Throwing papers, stones, everything. This fellow got offended again. Again he went. Filed a complaint. Judge said, are you really clear that these are the 4? Yes sir, they only have done. Proof also there. One of my friend also saw when it happened. Witness is available. He called the witness. He said, sir, yes sir, I have seen. With my own eyes I have seen. These 4 girls started throwing papers on him using foul language from the balcony. Matter went very serious. Courting, those 4 girls were called. He asked, "Arey, just 1 week back, I said, what is problem with you?" They said, "Sir, we are not punishable." Why? Under Street Offenders Act, street law you should do. From where we did? From balconies we did the offense. Section will not get attracted. Lawmaker used the word. Hey, read. Literal construction kada, important for life. Read literal construction. What do you mean by literal construction? Give as it is. You only said na NPO, PLG. What is NPO? Natural, popular, ordinary. Such that it should be understood in a plain, literal and grammatical sense. Plain, literal, grammatical. If I give street means road. Street means what? Road. Listening? Therefore you did on road, not on road, not on road. Therefore you 4 girls are very nice persons. Do like that. That's correct interpretation. When the plain interpretation, literal interpretation, grammatical interpretation, ordinary interpretation, natural interpretation fails, reasonable interpretation starts. Understood? Then court gave a judgment saying that here we should not see the form of harassment, substance we should see. Ante street, here lawmaker intention is generally offenses happens on street. That's why they have written the word street. That does not mean place is important. Intention of law is not the place of doing that. Intention of the law is the act of doing harassment. So the word court finally, do you know what they said? They said by using the Heden's rule, the term street includes balconies also. The term includes balconies also. And the place is important. Harassment is important. Harassment is important. And do you know what court further said? I said Street Offenders Act. Correct? Your building is on sky. And the building Akasanlo unda. Your building is on sky. Where your building is, some street number is there, na? In that way, if you interpret also, it is Street Offenders Act. Understood the point clearly or not? So, I think everyone understood the logic behind the rules of interpretation, okay? This is called as a mischief rule. Do you know what is a mischief here? Mischief means nonsense. Technically, mischief means what? Nonsense. Means nonsense rule this is. This is not creating nonsense. Nonsense in the law will be avoided with this rule. Listening or not? When I use the word street, don't strictly interpret street means only on street I should do, in house I can do whatever that is not the meaning. Place should not be given importance. What should be given importance? Essence of doing the harassment and bad things should be given importance there. Adi lawmaker intention. Clear everyone? So therefore, what rule we read now? We did not read rule. I explained example. Clear? Whenever Heden's rule question comes in exam, whenever Heden's rule comes in exam, you should write down these 4 questions. To apply Heden's rule and give judgment, 4 questions should be answered. Read. Sir, what is that question, sir? Law, act, both are same. Here, the word law represents general practice of traditions or ethics. Harassing women, harassing men, good or bad? Bad by which law? Ethics, yeah. By tradition, you should not do that. Why you have an option to harass anyone? Anandam, sadism. Why you need to harass anyone? Men or women, keep it away. Asal, why you are taking an option to harass people? When there is an option to, when there is a option to live peacefully, why you are choosing harassment? That is the first question. Here gender important, act is important. Act is important, not gender, not place. The act of harassment itself is not good. Understood or not? So, What was the general ethics before making law? Harassment is allowed or not allowed? Not allowed. Tell the first question. What was the law before making this Street Offenders Act? What was the law? Harassment is valid or not valid? Loudly. Not valid. To correct that, to curb that harassment in London, they brought which act? What is the mischief that law has not provided? And the general ethics law, what is not provided? General ethics law, what is not provided is punishment is not provided. What is not provided? Sir, I will ask a question. Temple, church, masjid, these three are important places of worship for any religion. For Hindus, temple; for Christians, churches; for Islam, masjid. These three are great, sacred, holy, religious places of worship for the respective religions. Correct? Can you go inside with the footwear? Loudly. If you go, what is the punishment? We don't know. Law is ethics here. Not law means company law, income tax law, law. Law here represents traditions, practices, ethics, morals. Adi law here. Listening, what is the general traditions before making this? Don't go with footwear inside the temple. Inside the India, a place of worship act is there. You know or not? Footwear, if you go, 10,000 rupees penalty under that act. Which act? Place of worship act is there in India. Because some nonsense idiots in India are not respecting the respective religions, they are going inside the temples with the footwear, that law was brought. Understood or not? Now tell me, what was the law before making that place of worship act? Don't go into the temple, church or a masjid. Those are great places of where the God resides. Don't go with the footwear. Understood? That's a law before making place of worship act. What law does not provide? Punishment law does not provide. God will punish you means an intangible thing. Because God can't come and punish you directly. Listening. What is the remedy act has provided? Punishing people who misbehaves in the, not temple, it can be any religious place of worship. Understood or not? So, act has provided. What is the reason for such remedy? What is the reason why you brought that? Because some people are going inside without respecting the God inside. And they understand from that point, read the law. Tell me, what are the 4 questions that should be answered to apply Ejusdem's rule? Don't see. What was the law before making the act? Second, what law does not provide? Third, what remedy act provided? 4, what is the reason for such remedy? How easy it is? Start again. 4 questions to be answered. What was the law before making the act? What was the mischief for which law does not provide? What is the remedy provided by the act? What is the reason for that remedy? If you can answer this one, Ejusdem's rule is answered. Understood? Read now. First one you read. When the language of statute is so that it is possible of making 2 or more interpretation. Street Offenders Act. Street means I can make 2 more interpretation. One, street literally any building on the street. Which one is correct? Which one is correct? Depending on the facts of the case, you need to give the judgment. Listening or not? Ejusdem's rule, same thing will happen in the harassment case. What was the law before making the act? Harassment is not valid. What general ethics does not provide? No punishment as such. Why the Street Offenders Act came? To punish people who harass. Generally on streets. Listening? That does not mean street means only street. Anyway, building is on a street. That will also be covered. Here, reason for remedy. So tell me, why Street Offenders Act came? If I ask, what you will tell? To punish whom? People who does a harassment on the streets only. Adi. Harassment. Generally, harassment on people happens in the street. Listening, sir, I will harass, I will, for example, my brother is there, my sister, I will harass my brother and sister inside home. Answer. I have a brother, I have a sister at home. I will harass them, I will harass my mom, I will harass my father. No. And generally at home harassment generally don't happen. Generally people harass us at street. That's why street was written. Not with the meaning that only street. Understood the point or not? That's the point. Hence the court should always seek to read, suppress the mischief, advance a remedy. Suppress the mischief, advance a remedy. See here. One second. Read this. Where the language used in the statute is capable of more than one interpretation, it is a firmly established rule that the principle in Haydn's rule. Suppress the mischief, advance the remedy. That's what I have written here. My book will not leave even a single line in study material. 4 questions. Okay? Did you understand the main content now? That's it. If you write this, you will get that 4 marks or 5 marks. Tell me, what all we completed? Rule of literal construction, rule of Ejusdem Generis, Noscitur Sociis, Contemporanea Expositio, rule of beneficial construction, rule of Haydn's rule. These many things we completed. Listening? What is the next one? Golden rule of interpretation, also called as what? Rule of reasonable construction. Okay, I will explain this and I will give a short break. Okay, listen. Final explanation for this. Nothing great in this. See here. You should tell me. Normally, which interpretation we should do? Literal. But when literal interpretation fails to give the real meaning, go for reasonable. Ante over. Ade golden rule. Golden rule, sub rules are there. What are the sub rules? Rule of harmonious construction, exceptional construction, beneficial construction, Haydn's rule, Noscitur Sociis, Contemporanea Expositio, beneficial construction. All these will come under golden rules. Clear? Read. Generally, words of a statute should be given sensible meaning. Means what meaning? Ordinary meaning. Who says that? Which interpretation says that? Rule of literal interpretation. Continue. It is only when there is a scope for 2 or more interpretation, construction comes in place. Giving the plain meaning to the words and giving the meaning to them and reading is called as interpretation. Forgetting the words, giving the lawmaker intention is called as construction. Post to hand delivery of facts added is a construction. Street law houses included is a construction. Hey, understood? So that interpretation which further represents achieve the object of the act should be preferred to which one defeats it. And a word should be given importance. Intention of the lawmaker should be given importance. Lawmaker intention is to stop harassment, not to stop harassment just on the streets. Understood or not? Give importance to curbing the harassment, not the place. Okay, so next continue. Similarly, when the grammatical interpretation is leading to nonsense, absurd means what? Nonsense. Courts will resort to reasonable construction. Thus, if the court finds that giving a plain meaning will not be fair or reasonable construction, it becomes a duty of the court to depart. Depart means what? Going out from dictionary meaning and to adopt such construction which will suppress the mischief, advance the remedy. These all points we already read so many times or not. I will show you the study material now. See, What meaning we should give? The words of the statute must be construed so as to give a sensible meaning. Have you seen that word in my notes or not? Generally, the words or phrases of the statute are to be given ordinary meaning. It is only when the words of enactment are capable of two construction and there is a scope for interpretation or construction. Continue. Next. Then the interpretation which furthers the object should be preferred over which defeats it. Similarly, when the grammatical interpretation leads to manifest absurdity, means illogical nonsense, then the court shall interpret the statute to resolve the inconsistency, make it as a consistent whole. Again, this is repeated. That's why I have given important content again. See, when grammatical interpretation leads to certain absurd, it is permitted to depart. Depart means what? Going away therefrom, and to interpret the provision of the statute in the manner to avoid absurdity. Listening, only to avoid that absurdity you should do, not further. Okay, this is called as a golden rule. Read this point, brackets. It becomes duty of the court to depart from the dictionary meaning and to adopt the construction which will advance the remedy and suppress the mischief. If you write this, then you will get the marks. Understood? It requires some amount of revision. Concept you understood, everyone in the class? Revision will take 1 hour time. Morning 4:30 time nuki, once you wake up, read interpretation of statutes properly from the material I have written. You will definitely get that 10 on 10. It requires some time and energy, that's it. Clear everyone? Take a short break and come. We'll continue the remaining things. First of all, I want a reply from every one of you. Are you all satisfied with the first chapter up to here? Take a break and come. So let's continue. Next one is, we completed up to the rule of reasonable construction. Okay. Next, let us go into the other aspects. See there. What is the next one? Rule of exceptional construction. Okay. Okay, see here. What is the next concept we are going to start with? Rule of exceptional construction. Previously, 7 rules we have completed out of 9. Everyone understood all the 7 rules clearly? Rule of literal construction, Ejusdem Generis, Noscitur Sociis, Contemporanea Expositio, beneficial construction, Hidden's rule. Next one is reasonable construction, golden rule. So next one we are going into the other areas called as, what is this? Exceptional construction, and finally the concept is a harmonious construction. Okay, so let us move on into the remaining 2 and try to complete. See, rule of exceptional construction. Rule of exceptional construction. Sir, what is this exceptional construction? Name itself is there, rare, exceptional. Rarely we will go into this rule. Okay, what is that rare situation that happens? Generally, word will have a meaning. Word will have a meaning. Till now what we learned, whenever the words are used, give the plain meaning to the words and read. Sometimes plain meaning may give a wrong answer. At that time, go for an alternative interpretation. Correct? Post hand delivery includes what? Facts. Street includes any other place. Correct? Wherever in examples, whatever we have taken, word is there, we went beyond the words and made the interpretations. We call it as what? Construction. Giving a right meaning is called as what? Interpretation. Going beyond the words and giving the importance to the lawmaker intention is called as what? Construction. There is a thin line difference between both of them. Listening? Okay. Now listen. Not yet done. Exceptional construction is a rare situation where we will give opposite meaning to the words used. What we will give? Opposite meanings to the words used. Yes will be treated as no, no will be treated as yes, left will be treated as right, right will be treated as left. Okay? Actually, these are not the two explanations I wanted to give. Understanding sake, I am telling. Actually, it is yes, we treat it as no. Actually, it is right, we treat it as left. Okay? Likewise, you will tell, I will listen. What is this? What is this? What do you mean by may? Optional, mandatory? Everyone? And it is directory or compulsory? Directory means I will direct you to do that. You may do, may not do. Those are called as a directory provisions. Those are called as a next one. What is this? Shall is a directory force, compulsion. Loudly. It is a compulsion. One is a directory in nature, one is a compulsory in nature. One is a directory in nature, another one is compulsory in its nature. Okay. Now, whenever the provision is a directory, you may do, you may not do. Shall means compulsory, you must do. Now the problem started. Where the problem started actually? See here. There is a section. Section number 139. Auditors. In that, first auditor. Which auditor? First auditor. First auditor has to be appointed within 30 days of the date of incorporation by the board of directors. By the board of directors. Actually 1 month. 30 days you can remember. Start. First auditor should be appointed within 1 month, 30 days of date of incorporation. Who should appoint? Do you know what section said? Board of directors shall appoint. Repeat. Shall appoint whom? First auditors within 30 days from the date of incorporation. Who should appoint? This is said in section 139. In 139 they said like this. If board of directors fails to appoint first auditor, recently I kept a video also on first auditors in YouTube. You can listen. I kept all these. So, if board of directors fails to appoint whom? First auditor, then shareholders in a general meeting by passing a ordinary resolution may appoint first auditor. May appoint. Tell the full provision now. Tell the full provision now. The board of directors of the company shall appoint the first auditor within 30 days of the date of its incorporation. If board fails to do so, shareholders in a general meeting may appoint first auditor. This is provision originally. In one of the cases what happened, let me explain. Tell me. Shall for whom, may for whom? Shall for board, may for shareholder. Shall is compulsory or optional? May is compulsory or directory? Do you know what happened in one of the companies? One very big listed company is there. In that listed company, what happened in one occasion? Shareholders, board of directors shall appoint. Board failed. Board failed. Now who should do? Shareholder said like this. When shall, board did not do. For may, why we should do? We also will not do. Compulsory person don't do means optional person why you will do? Understood or not? They said that when shall is there, compulsion is there, mandatory is there, they did not do. Ours is not shall. Ours is what? May. Then why we will do? We also will not do. Akada shall ki shall did not do, may also did not do. Company became auditorless. Another in the company. Company with is having an auditor, not having an auditor. Not having an auditor. Company became orphan. What to do? Matter went to the court. Court said, we invoke the rule of exceptional construction. The word shall should be read as may. The word may should be read as shall. I said the word dash should be read as dash, shall should be read as may. Obviously, may will be read as shall. Though, now tell me. First, I want you to, 1 second, I will do one thing. Now read. Just I scribbled with answer. Read. The board of directors of the company appoint the first auditor within 30 days of date of incorporation. If board fails, shareholders may appoint. Here what is used? Even then they did not appoint. Here what is used? May. It's optional. Therefore we also will not do. Compulsory they did not do. Means optional. Why we will do? In India. Compulsory people didn't do. Optional why we will do? We also will not do. Company became auditorless. Financial statements can't be approved. Who should sign? Who should sign on financial? Auditor. Want the director. Auditor will sign on. Ye bootu. Mamul bootu adi. Parama bootu. Auditor will sign on financials. Who will sign? Board of directors. Signed audited statements, approved audited statements will go to whom? Auditor for his comments with an audit report. On audit report, auditors will sign. Financial statement, why auditor will sign? Whatever prepare chesada. So auditor won't prepare financials. Na? On the prepared financial statements, I will comment the accuracy. I will comment the fair and correctness. I will comment on the true and fair view. I will comment on the standards on accounting. I will comment on the standards on auditing. Those comments I will make. Clear? Now answer. In this case, what happened is, shallki they did not do, make why I should do, I will also will not do. What happened at the end of the day? Both of them did not appoint the first auditor. Now you tell me. Court said that the word shall should be read as, the word may should be read as. Now read the provision and tell. The board of directors of the company may appoint the first auditor within 30 days. If may for them, may itself they will do means super. If they failed, then shareholders shall appoint the first auditor. Like that we need to interpret. Which rule of interpretation we used now? Loudly everyone. Which rule? Rule of exceptional construction. Understood the point or not everyone? Next issue after that. So we completed rule of exceptional construction with an example. First, read this particular concept, rule of exceptional construction. Read. Generally, the words of law should be read in such a way to give its a sensible meaning. Sensible means what? Making some sense. Meaningful. Understood or not? It should give a meaningful meaning. It should give a meaningful meaning. That meaning must be meaningful first. Clear? Continue. Ignoring the general rule, if the ordinary meaning is not sensible, at a shall if it is read as a shall, may it is read as may, ordinarily, shall means what? Optional or mandatory? May means, if literal construction if you do, shall means mandatory, may means optional. But if that meaning is given, it will be furthering the object of law, defeating the law. Loudly. In such case, we need to go for alternative interpretation. Okay. Now see here. Read. Ignoring the general rule. If the ordinary meaning is not sensible or is defeating the object of law, it should be eliminated. Next. Read. Interpretation of and or. Generally, the word and means. Sorry, I will tell one thing. Two conditions between and is there. Both should be completed. Any one. Very good. Two conditions between or is there. But sometimes end will be read as or, or will be read as and, shall will be read as may will be read as shall. Ante. This is exceptional construction. Understood? Read. And is a conjunctive particle. Or is a disjunctive particle. For this half mark he will give. Tell me. And is a conjunction. Or is a disjunction. Conjunction adds two things. Disjunction divides two things. Continue. And is an expression to join or connect to two provisions. Or is used as an alternative. Either this or this. Generally, and is conjunctive or is disjunctive, but sometimes and is read as or is read as and to give full effect to the intent of the legislature. These are all. Inga paruda. See there. Which rule? Rule of dash construction. I will show you the proof. 2 point. It came. See, as it is, what we have written in the notes will be there. See, words of the statute must be construed to give sensible meaning. Had we written in the notes? 1 point. Next. If no sensible meaning can be given, it would defeat the real object. It would be eliminated. Had we written that? Yes. Now you will read. And is a particle joining the words and sentences and in relation to a connection or addition. And is normally conjunctive. It is a conjunctive sense used to conjoin words, clauses, sentences. Or is disjunctive particle and used as a alternative. The word and is normally conjunctive while or is disjunctive. But sometimes and is read as or and vice versa means what? Or is read as and to give effect to the intention of the legislature. Over. That's it. That's it. If you write, you will get the 4 marks. Any other thing if you write now, marks will be gone. Understood now? Is it really difficult? It requires some attention to detail revision. That's it. You will get the 10 on 10 in the chapter. Okay. Next. What is the next one? May, must, shall. Must, shall both are same. May and shall. May and now you will tell. May is a directory provision or it is a compulsory provision. Shall is a mandatory provision. So tell me. May is a directory provision. Shall is a mandatory provision. Read. Where enactment or a provision prescribes any action to be taken without any option. Shall may na. Hey. Read properly. There is a provision. That provision, option I will not give. You must to do. Then what the lawmaker will use? Mandatory and shall. Discretion or option is there. Then what they will use? 80% answer over. How many of you prepared all these in the last attempt? Yes, very good. You prepared and read all the points. That is okay. That I should not tell. You prepare everything like this? No. That's the problem. But now did you understand the change? If you prepare from study material, there is no concept of failing in exam. Asal failure chance not there. If you read study material, the concept of failing in exam, that's why observe clearly. Never ever in my life I said read any third party material for law. Read Bare Act. Bare Act copy paste study material. Understood? That's it. Since interpretation of statutes is not an act, it is a chapter. That's why we are reading from the study material directly. If you read study material, understand it properly, chance of getting failed is very minimal. Okay? Third party material you will read. In that this content will not be there. You saw with your own eyes, kada? Then how will you get the marks? You will write that content in exam and you will feel you read right. Last attempt, Ejusdem Generis came. Correct? You will read that book and you will go and write in examination. What you will think? Generally, what you will think? You will think that question came for 6 marks, at least I will get 5 marks. You got 1 mark only. Like that, what will happen? Your estimate will be somewhere in 55, 56, 60. How much you got? Can you tell? You expected that mark below 40. How much you expected? Above? Why that much difference came? Because of that. Now did you understand, everyone? And I am not a damn bloody fool after having a 13 years of experience. I always take only study material because of that reason. I always suggest all the live students also listening, read from study material only. Clear? Success will be yours. If you read study material, success yours. Doubt illa. The moment you divert yourself to third party materials, these people while making third party material, what will happen? To simplify the concept, essence will be diluted. And moreover, point is, study material is not that difficult actually. Meaningful way they are writing or not. Only thing required is what? Unnecessary points you can eliminate, and point wise like this you can write. Okay? Now you will tell. May is a directory force or discretionary provision. Okay? Shall is a mandatory provision. If section provides for something which must be done, it is mandatory optional. Associated with the may, shall. If something in the provision is optional, you may do, you may not do. Optional, mandatory. Optional, mandatory. Discretionary, compulsory. Shall, may. That's it. 1, 2, 3, 4. You complete all the 4. You can read now. Okay? Everyone? Under 4 points, pakkana, clarity, yeah? You should not do mistakes again. 4 points you have to write in exam. Okay? See here. Another thing. May is a provision having authority. Shall is a provision with command. Repeat what I said. May is a provision with authority and a power. Shall is a provision with command. Sir, may power in, sir. May is a power. Shall I tell you? Listen. A police has right to arrest a person. A police has right to arrest a person. Okay, na? Now, police must arrest, may arrest. Everyone. Ante it's a power given or not given. That's why power always associates with the word may. Understood or not? A police may arrest. May is more powerful than shall. People, what we will think? Shall. May. Then what you will read? May means it is a normal section. May section say important sections in exam. May section say important sections in exam. EGM may be called by board. That's why important for exam. That's why AGM question never comes in exam. EGM comes in exam. AGM is shall. Understood or not? AGM shall. EGM may. Postal ballot may. Poll may. Show of hands shall. Anke show of hands never come in exam. Section 107 show of hands never asked in exam. Poll 109 last attempt came. Why? Always may provision say important for exam, not shall provisions. Buyback may comes in exam. Redemption of preference shares shall will not come in exam. Understood the point or not? So dividends will come in exam. Always the may provisions are power carrying provisions. Listening, tell me, section containing may is given with authority. Section containing shall is having a command. Do it. You must do. AGM shall be held. Yesterday morning you read na? AGM may na shall. You must do. So alternative process of thinking will not come there. May, whenever it comes, thinking process will be there. Whether to do, not to do. Their professional advice is required. Understood or not? So which is more important in life? May is important in life because may the great dilemma will come. What dilemma will come? Whether to do, not to do. That at that time professional expertise should come out. Something must be done mean where professional advice is required. Anyway, how to do that? Like that you should think while reading the law. Listening, ఏమన్నా అర్థమైందా? என்னப்பா புரிஞ்சுதா? ఆన్లైన్ స్టూడెంట్స్ సరే. Now answer. Point number 1, 2, 3, 4. Now I want you to read 5. Start. May signifies a permission and a authority. Shall, on the other hand, is a word of command. For this, I saw the answer key. 1 mark they have given. 2020-23 May attempt it came. One of my friend used to value the answer paper. Happily 1 mark here. If you write this line, 1 mark. See. Read this. Read. May signifies permission and a authority with discretion. Discretion means what? If you want, you do. If you don't want, you need not do. Listening. When the discretion will be there? May. Board may call EGM. Loudly. When board should call? Discretion of the board now. Understood? Next. Shall in normal sense imports a command. Understood the point now? Now continue. In case where normal significance and interpretation as permissive gives rise to absurdity, inconsistency, then it shall be disregarded. Sometimes, though may is permissive. Permissive means you may do, you may not do, and directory it shall be read as if it is mandatory, and therefore it should be read as shall. So sometimes may should be read as shall. Obviously when may is read as shall will be vice versa read as may. Read this. May, though permissive, sometimes has compulsory force and is to be read as shall. Ordinarily the word may always used in permissive sense. There may be circumstances where this word will be construed as mandatory, and therefore we should use word what? Shall in that place. Everyone understood? With this we completed another rule of interpretation called as exceptional construction. What construction here? Okay. Now I ask a question. When may should be read as shall? When may should be read as shall? May is a discretion, permissive, authority na command. It is a discretion, authority or compulsory and command. But when I give that meaning, when I give sensible meaning, it is giving rise to absurdity and inconsistency, like what we say in the last example of first auditor. Clear? In that section, reading may as may, reading shall as shall is creating a problem. Correct or not? To clear that problem, exceptional construction came in place. Understood? And that doesn't mean every time whenever you read section may will come read as shall. No. Problem comes May will be read as shall, shall will be read as may. Problem didn't come. May is may, shall is shall. But when interpretation still a problem came, may will be read as shall, shall will be read as may. Sorry. If you don't think that I am taking another 5 minutes of your time, I can give one excellent example for you. Shall I? Now, cinema begin, listen carefully. Name of the section, Customs Tariff Rules. Customs, ship. What happened one day? There is one company in Madras, old case law, 87 case law, but relevant even for this. 1987 one case law happened in Madras, Chennai. Chennai seaport one ship came and stopped. That ship is starting from Chennai. Okay, there is one exporter in Chennai who is exporting fish, lobsters, crabs and other seafoods to other countries. Listening, UK, Norway, Sweden, these places. Middle East ki he will supply the seafood. This is what business. How much? Load, each load of container will be there in a shipler. Each container contains 7 crore worth. At containers and containers, 1,000 containers, 5,000 containers full of fish, lobsters, all these things will go. Ship will take at least 6-7 days to reach there. But 6-7 days, fish has to live or not. You may know, dead fish, dead prawns, all these people won't buy. Only live fish they will take and then they will kill. That's a different thing. Correct or not? Dead thing they don't entertain. Therefore, when you export the fish, lobsters, etc., it should go in living condition and dead condition. But 7 days, how can I make it to live? Therefore, they used fumigated boxes. Which boxes? Fumigation concept is there in science. Wooden box they will take. Which box? Wooden box. Powder will be injected into the wooden boxes. That powder converts normal air into carbon dioxide and oxygen, such that fish inside will live for 7-8 days inside the boxes. That's a scientific way of making the oxygen to pump inside. Listening or not? One oxygen cylinder will be kept inside the container. They will release that oxygen. Oxygen will pump. Listening? That particular fumigated box, when it absorbs the oxygen, fresh oxygen will be released into that. That's a scientific way of making the fish to live. But that can't be done for 10-15 days. Maximum 6-7 days they can do that. Fumigated boxes, once fumigated box is there, if you open that, gone. You should not open. Once open, you should keep it in the ice box. These are all the situations. One fine day, what happened? Chennai Portla smuggling is going on. Customs Commissioner said that stop all the ships and containers. They stopped also this ship. That ship contained the container of all fish, lobsters, everything. So they stopped. Over. They said, what is there inside? Sir, bill of lading, port dockyard document. You can see fish, lobsters, all these are there, sir. Totally 450 boxes are there. 450 boxes worth 4.5 crore worth seafood is there inside. This is the proof. They said, no. There also one container is there. Dock paper light was written that there is some iron and metal. When we opened, diamonds and other smuggled goods are going on. So we have doubts also on you, they said. Sir, no sir. This is not our first export. Our company is doing export in the last 17 years. Never we did like this. Please sir, it doesn't have anything like that. Or you do one thing sir, let it go to UK, ask the authorities there. Listening, ask them, is there anything? You do proper checking there. They said, no. Once it reaches UK, with UK, India doesn't have the financial links. Legal links are not there. That's why Vijay Mallya stay there. The king of RCB. Why he will stay there? Because of that reason only he will stay there. Or UK, once it reach, they don't give any information or data to you or to me. No, we don't believe. Sir, please sir, don't do like that. If you open that, not gone sir, entire material waste. They said, no way. you should open. Sir, they will die, sir. The moment you open, expose it to normal sunlight and other things, they will die. They said, it's none of my business as per customs tariff rules. As a customs commissioner, these are the provisions under the Customs Act. I have a right to seize any vehicle, seize any container, and check with a roving inquiry. Please don't stop me. I will enter into the container. He opened randomly 15-20 boxes. Listening, other boxes were also kept outside. Oxygen cylinders are there inside the container. Outside normal sunlight, Chennai you can know huge extreme sunlight is there. Because of that, entire box of fish died. All 450 boxes of fish died. Fish, lobsters, whatever. Okay. Oxygen not there. Listening, proper oxygen not there. Immediately 1 hour, 2 hours, so they kept in open sunlight. All the boxes, fumigated boxes, gone. All fish dead 1 hour la, everything is dead. 4.5 crores worth of fish, lobsters, everything dead. They opened randomly 30-40 boxes, sampling basis la. Everywhere fish, prawns, all these things only there. They said, okay sir, you are a gentleman, thank you very much, you can go to UK, they said. He saw like this. What I told you? What I told you? I told very clearly. This is not our business for the first time. Last 17 years I am doing the same business. And in this, why I will do smuggling, I told. If you remember 10 times I said, sorry, please. You did not listen. I said, open one box and check sampling. 30 boxes you opened. But 30 boxes, other than fish, prawns, did you find anything? You did not. Sir, 17 boxes you did. Okay, 6-7 lakhs lost to me, I will leave. Remaining all the boxes you kept in sunlight. I said very clearly, don't remove. You said, living legend I am. I will remove everything. You kept outside. Open other boxes, they would have already dead. 4 crore loss for me now. 4 crore loss is the loss of product inside. I promise that person that I will send in 7 days, he will ask me now. Again, how I can make arrangements? Correct or not? They will file a case against me under breach of contract that I am not providing the goods on time. Damages who will pay? Your grandfather will come and pay. He went to court. Who went to court? Company person went to court. Filed a complaint against Customs Commissioner. Customs Commissioner was called to the court. Judge asked him. This fellow sitting one side, that fellow sitting another side. Judge asked him, tell what happened in the case. They explained everything. This fellow, Customs Commissioner, will be there, na? First he was questioned by judge. Why you did not take any action, proper action on that? Fish, lobsters, all these are perishable commodities. What commodity? And which will get damaged by efflux of time. If you put more milk, flowers, milk, fruits, vegetables, what are all these? Perishables. And a long shelf life will not be there. They will get spoiled just in hours. Fish, all these hours, days also will not be there. Understood or not? So, you would have sold it. Customs Act, what was written? Customs Tariff Rules, clearly it was written. If the goods seized by the Customs Commissioner are subjected to perishing in nature, Customs Commissioner should take all reasonable steps. Customs Commissioner may take all reasonable steps to get the goods disposed of. 4.4 crore worth goods are there inside. Customs Commissioner should get them sold. If the goods seized are which nature? Customs Commissioner should not keep it with him. What he should do? Get it sold. get the money. Later we will do investigation. Court asks the same. Customs Commissioner judge asked, "Arey, Customs Commissioner, clearly act like it was written. If the perishable goods are there, seized goods are perishable in nature, you should not keep it with you. You should sell that." Sir, no sir. There you read section properly, sir. Enna sir, Pakshapatam. Nanda, nee. Ellarame Customs Commissioner, government authorities, na. Please, sir, understand properly. See the bare act. What it was said? Customs Commissioner may get the goods disposed. It's not shall. Therefore, I did not do, sir. It's a directory provision. It's a directory provision. It's a permissive provision. Permissive means I was given permission. I may do, I may not do. Listening or not? It's a provision which is permissive in nature. It's an authority. I may do, may not do. I did not do. Oh, that's what your interpretation. Yes, sir. He said, "Oh, that means you did not read study material properly when you prepared." No, sir, third party material. Andike ila tagaladdavu. So immediately he said. So he said very clearly. First point, number 1. Sometimes may will be used in the act as a conventional courtesy. As a conventional courtesy. What do you mean by conventional courtesy? Courtesy means out of respect. Who are you? Which commissioner? Police commissioner. Who are you? Agni. Who are you? You are a customs commissioner. You are a guested rank. You are on a guested rank. Yeah? You are a big authority. Customs commissioner, people will be scared. Such a kind of authority you are. How can law tell, shall sell the fish, go out? Are you understanding the point or not? How can I tell to a customs commissioner, go out and sell fish? That's why I use the word may. May was used not really to mean may. Should or not? It's a courtesy, respectful. Sir, I will give you an example here. I'm taking class. Okay? You came 1 hour late. You wanted to come inside. What you will ask? May I come in? May means option. In reality, you wanted to come. May I come in? May means shall. I will come inside is your intention. Courtesy we will use may sometimes. That doesn't mean literally you should mean it may. That's how court said that the word may used in customs tariff rules should be interpreted as shall. That's how judgment came. Understood the concept of exceptional construction or not? So teeste law oka pedda movie. Prati scene climax. So the point is, in the little time available, I am trying to make it more simplified such that you will remember the concept. Everyone understood the concept of may and shall. You will forget, shall forget, may forget. Don't forget. So, the point, everyone understood the concept clearly? So, this is the meaning of interpretation of the words may and shall. Okay? Read it once. Loss? Loss will be paid by department. Obviously, department has to bear the loss. In the case, 6.1 crores or something damage was paid to him. It's a complete mistake of customs department. Listening? For that only, 4.5 crores is the worth of amount. 2 crores he paid as a breach to that person, that also recovered back. Okay? That's why. Just because of one reason it all happened. What reason? Because of not reading study material. If you would have read study material, at least you would understand may is not may is shall. Read properly now. Read. Hey students, Chennai. என்னப்பா புரிஞ்சுதா? எல்லாரும் புரிஞ்சுதா? டேய் என்னடா எக்ஸ்பிரஷனா? இந்த மூஞ்ச பார்த்த பேஸ்ட் டேய். Understood the concept of may and shall? Others continue now. Babu, you also read properly. May shall are the expected question. Yeah, this attempt. Exceptional construction is an expected question for this attempt. What is the next one? Very another expected question for this exam. Mark it important. Sir, expected, not expected, you leave it. Okay, I'm just telling my expectation. It may come. It may. It really may should be read as may. So, because not Kausham Gesha, no one knows what will come in exam. It is only a bare expectation that I can make. Okay, may come. Okay, interpretation of statutes shall come. In this question, may come. Discretionary. In both of the cases, shall should be read as shall, may should be read as may. Right. From today, wherever possible, you will now read may. May means this may normal may na, shall may na. This normal shall la, may shall la. So, read now. What is the next concept? First, I will tell this concept in a easy way. Later, textually, we will read. See, there are two provisions. There are two provisions. Two provisions will discuss about same subject matter. There are two means minimum two, or 2 or 3 or 4 or something. There are minimum two provisions. Two provisions are discussing about same subject matter. There is a conflict. There is a conflict between the provisions. First, step number 1. Try to resolve the conflict. Try to resolve the conflict and apply both the provisions. Why, sir? Why I need to apply both? Then why lawmaker has written both? If really one is waste, he wouldn't have written that in the act. When I write two provisions, there is a use with both the provisions. If really not required, he will not write. When lawmaker has written something in the section means it is having a relevance or no relevance. When it is having relevance, you should be relevant. You should give importance. Start again. There must be minimum two provisions should discuss about. There exists a conflict. Firstly, try to resolve the conflict and apply both the provisions. Sir, I tried to apply both the provisions, sir, but both can't be applied together. In that case, specific provision should prevail over general provision. Repeat. When specific provision should prevail over general provision? When it is try to resolve the conflict, when it is not possible to resolve the conflict. When it is not possible to resolve the conflict, specific provision should prevail over general provision. These are harmonious. But with example, if I tell, life never you will forget. Okay? But before that, read the text in the book. Start. It is a recognized rule of interpretation that expressions used in a statute must be interpreted sensibly that harmonizes with the object of the statute. Continue. Opposite of harmony is conflict. Means whenever 2-3 provisions are there, harmony means peace. P-I-E-C-E, peace illa. P-E-A-C-E, peace. Adi harmony. Harmony means don't create dispute between two sections. When 2-3 sections are there, read in harmony. సినిమాలు చూడట్లేదేంటి? In the movies what they do, as per section number 302, 307, 307A, 309, 254A, 254B, harmonious construction. Watching movie is not important. Whenever you watch the movie, first you should understand on what basis they are telling all this. That is harmonious construction. You have done only one act there in the movie. For that one act, so many sections are getting attracted. Understood or not? That is harmony. Harmonious means what? You have done only one act, but whatever the section that get attracted to that, all of the things should come in place. That's called as a harmony. Listening or not? Now tell me. Now you will read properly. Read. It is recognized rule of interpretation that expressions used in a statute must be interpreted sensibly. Ante with a common sense you have to apply. That harmonizes with the object. If you do some wrong, for that wrong, under one section compensation, under one section punishment, under one section jail, under one section POXO, like that so many things will get attracted. Understood or not? So many sections will get attracted around that. You should harmonize everything, apply all the sections on that case, send him inside. Understood the point or not? Finally, you should go inside first. So to go inside like that, so many sections should harmonize. Later, court will evidence collection and all these Indian Evidence Act, all these things will come later. Whether it done or not done is a secondary thing. First, send him inside. Understood or not? So the point that you have to understand is, see here, it is a recognized rule of interpretation that expressions used in the statute must be interpreted sensibly that harmonizes with the object of statute. Harmony opposite is what? Conflict. Means sometimes two provisions are discussing about same subject matter. Same? Sir, I will tell one thing. Listen. A person has done an offense called as X. Some XYZ offense he has done. Okay. For that offense done, section 1, section 2, section 3 are there. One is talking about compensation to the victim. 2 is talking about punishment. Listening? 2 is talking about fine. C is talking about jail. How many sections are there? Now tell me, what section should get attracted on you? A na, B na, C na, all the sections are. All the sections should get attracted. Correct or not? Act done is only 1. But sections getting attracted are 3. Because harmony is possible. That's what the first point wanted to tell. However, this rule will be applied when there is a conflict between. When you can harmonize, I will do that. But sometimes one section cannot be applied if another comes. Another section cannot be applied if someone comes. In that case, when the harmony cannot be established, then what they say is, read. If it is possible or not possible. See there and read. Is possible or is not possible. Is possible. To avoid the conflict between the provisions on a proper construction, the court should interpret in such a way that should bring harmony between each other. That's what I said in a easy language. If it is possible to resolve the conflict, resolve them and apply both. Apply. Continue. Generally, a statute has to be read as a whole. Every provision in the statute must be read in reference to another section to give effect to both of them. However, if it is not possible to avoid or resolve the conflict, specific rule shall override general rule. Normally, the discussion everyone understood clearly. Tell me, whenever 2 sections are there, how to read the section? Sensibly, such that it will harmonize the object of the statute. Opposite to harmony is conflict. Opposite to harmony is? Okay, this rule will be applied. Harmonious construction rule will be applied when everything is plain and harmony. When there is a conflict, harmonious construction will come in place. Listening? As per the harmonious construction, first what you need to do? You should create a conflict. Try to avoid the conflict. Avoid the conflict and apply both the sections and bring harmony. If it is not possible to do so, specific rule should prevail over general rule. See here. These are all examples. You can read it later at home. Okay. Main content I will explain. Read this first paragraph once, everyone. Up to here you read. First read up to there. All the points are there or not? You should only tell. Then read this word up to here. Okay. Next. Read. Did I write this in the notes or not? If it is not possible to give effect to both, okay, then what should happen? I read this point or not? That's it. Please cover. Line student cannot remember. I have pointed out all the important points in the notes. Clear, everyone? So these are all the points you have to write in examination. Okay? Listening, everyone? So this is the end of another concept called as a dash. Harmonious construction. Okay? Harmonious construction will not work in some cases. Will not. That I did not write in the notes. I will show here directly. Okay? See. Whenever a section contains, notwithstanding, for example, notwithstanding anything contained in section 10. For example, I am writing section 85. Randomly I am telling the name. Which section I am reading? 85. I am reading section. Example I am telling. Don't go for 85 and read that. Example I am telling. Some act, not Companies Act. Some act you are reading. Section 85 you are reading. They said, notwithstanding anything contained in section 10. What do you mean by that? Section 10 and this section are talking about same thing. But when you are reading this section will override section 10. What is the meaning of notwithstanding? Ignoring section 10, read this. Are you listening? Tell me. Notwithstanding represents what? Notwithstanding represents what? Ignore. I will ask a question. There are two sections, X section and Y section. Listening? Y section I use notwithstanding anything contained in section X. Who will win over whom? Y win over X, X will win over Y. Y will win over X. And a section using the notwithstanding will win over the section referred in notwithstanding. What I said? Yes, sir. What is said in the center in the above? What is said now? A section use the word, for example, section Y is using notwithstanding anything contained in section X. Now who will win? Y section will win over section X. Why it has to win? Because both are discussing about same subject matter. Listening? In this case, harmonious construction is there or not there? It is there by the law itself. So you need not do any interpretation. Understood? Already lawmaker, he himself is saying that this will override section Y. He created harmony already. Who will win, who will lose, he only told. You need not do any interpretation. Clear? Notwithstanding, the variety types are there. notwithstanding anything contained in some section, section X, Y, Z, notwithstanding anything contained in the foregoing provisions. In the loudly, I am in section 100. I am in section. I use notwithstanding anything contained in the foregoing provision. Ante 1 to 99 ki 100 will win. Foregoing means before. Foregoing means, tell me, notwithstanding anything contained in particular section. At the type 1, second type. Notwithstanding anything contained in the foregoing provisions. What do you mean that? Previous provisions before that section. Hey, listening. Third case. Notwithstanding anything contained in this act. Notwithstanding anything contained in this means what? In any section in this act, if there is a similar thing provided, on that this will win. Listening. Fourth case. Notwithstanding contained in any other law for the time being in force. I am not winning against any one section. I am not winning against any foregoing section. I am not winning against the sections in this act. I am winning entire acts in India. Those are much powerful. Tell me, what are the four types of notwithstanding? Notwithstanding anything contained in a particular section. Notwithstanding anything contained in the foregoing provisions. Notwithstanding anything contained in any other provision of this act. Notwithstanding anything contained in any other law for the time being in force. Listening. Section referring in the notwithstanding will win, or section using it will win. For example, section 10 is using notwithstanding anything contained in section 9. 9 will win, 10 will win, 10 will win. Section used will not win. Section using it will win. What I said. Section used will not win. Section using it will win. Understood? Sir, ours is not regular batch. I am trying to put everything in simple format. Understood clearly? Now, read. Notwithstanding clause is called as what clause? Non-obstante. Means no obstacle. I will win over everyone. No one can stop me. Unstoppable. Okay? Who is unstoppable? Bale Baba. See here. Here unstoppable is the section using notwithstanding is unstoppable. A clause that begins with the words notwithstanding anything contained is called as a non-obstante. Listening, when this term is used, then the clause will prevail over other provisions mentioned therein. Section using notwithstanding will win. Section referred in notwithstanding will win. Now see, type number 1. Read. Notwithstanding anything contained in another section. Next. Notwithstanding anything contained in a statute, entire act. Notwithstanding anything contained in specific sections or subsections. Next. Notwithstanding anything contained in any other law for the time being in force. I think now you understood the meaning. Understood? Exam key, you need not write these. You should remember that 4 types are there. Whenever these 4 are there, notwithstanding comes, harmonious construction is to be done, already done. Already done and given. You need not do any extra interpretation there. They only said that this and that when fight, this will win. Then why you are making again? When you have to make, when there is no indication of notwithstanding, your work will be there. I am only telling this will win over that. Then why you are again making a dispute? Clear, everyone? Next. What is the next one? Without prejudice. Sir, prejudice means causing a damage, causing a disadvantage. Tell me, what is it? Causing a damage or causing a disadvantage is called as what? Without prejudice. Okay? See, let me explain. Same concept again. Without prejudice to, subsection 1 means when you are reading subsection 2, hey, listen, when you are reading subsection 2 it was said without prejudice to subsection 1 means when you are reading 2, Don't damage one. Give importance to one and read. Give one lo something he said, two lo other thing he said. Cinema lo I said na 205A, 245, avanni without prejudice. For example, there is a thief, ransack a house, robbery, caught red-handed by police. He said, sorry sir, never I will do in my life. Take your goods back, he said. He gave the goods. Understood? Huh? Understood? What he did? Huh? He has a liability to give back the goods or not? What is that liability called as? Companies Act, what you read here? I am getting doubts. This is called as a civil liability. This is called as? What is civil liability? Compensating the person for the loss caused to him because of you is called as what? Civil liability. That's why section number 35 of the Companies Act. Civil liability for the misstatements in prospectus. Easiest thing in the class, do you know? Saying yes. Difficult thing, shall I tell? Shouting like me. Okay. So point is, civil liability means compensation paid to others is a civil. Do you know what is the notion in the student's mind generally? Criminal case, imprisonment. First put him in jail. Criminal case. Fine. 500,000. It is civil. Salakadu. Whenever section uses the words shall be punishable, adi fine imprisonment or forget. Those are all criminal sections. When section use the word shall be liable to a penalty, those are all ROC adjudicated penalties under section 454. Civil liabilities means compensations will be there. Today go home after the class. Open prospectus chapter 35. In that, whenever there is a misstatements in the prospectus, whenever misstatement, whenever any person has subscribed to the shares of a company on the basis of the prospectus or the misstatements in the prospectus and has incurred any loss or a damage thereon, the consequences will fall on the director, proposed director, promoter, experts, and any other person who has authorized the prospectus under section number 26. They are liable to compensate the person who underwent the losses, and the victimized will be paid compensation on the basis of disgorgement under class action suits under section number 245. These all will be there in section number 35. Section 35 is talking about civil liability. Which liability? Civil means what? Human being. Because of you, another person is suffering. As a human being, what is your liability? First, compensate him. That is civil liability. They saved money. Their hard-earned money kept in the Albara. You went inside and robbed their money. Compensate them, give them back. This is your civil liability. But for the theft done, even though you give back, you should be punished and kept in jail or not? Answer. Without prejudice to compensation, you are under punishment now. That's the meaning of without prejudice. Just because of the reason that you have given back their goods does not mean you will be relieved from the punishment. Theft is a theft. Wrong is a wrong. Answer. That's it. So therefore, tell me, whenever I use the word notwithstanding, section containing it will override. Section referred in that section is override. Section using section used. Section, very good. Second question for you. Second question for you. Whenever I use the word without prejudice, section using it will win. Section referred is winning. Section referred will be winning. Without damaging that section, you should read this. Sir, I want one example. Examples are there in Companies Act. One example shall I show? Section number 102. Tell other than that anything else. 1 or 2. What explanatory statement will contain? Every notice calling a general meeting must contain an annexure to the notice calling a general meeting containing the material facts relating to the nature of concern or interest of the director, manager, relative of KMP, and any other information and fact that will enable the members to understand the meaning, scope, and implications of a resolution and pass a resolution thereon. This is what said in the Bare Act, section number 102, subsection number 1, clause number A and clause number B. Section number 102, subsection number 2 says that every resolution passed in a general meeting, being an ordinary business, approval of annual financial statements and board report and financials, and declaration and payment of dividend, appointment of audit directors and reappointment of auditors and fixing their remuneration shall be deemed as an ordinary business. All others will be deemed as special. This is what said in 102, subsection number 2, clause number A, subclause number 1, 2, 3, 4, and subclause number B. So, summary I will tell you, listen carefully. Good. 102, subsection 2, clause A, subclause 1, 2, 3, 4. Okay, this is Bare Act. Let us move on to the main content now. See the screen. Read this. Read. Explanatory statement lo you should disclose. You did not disclose. What will happen? Read. Where, as a result of non-disclosure or insufficient disclosure in any statement referred to in subsection 1, being made by promoter without prejudice to any other action being taken under any other law for the time being in force, be liable to compensate the company. Again, without prejudice to subsection 4, penalty also will be levied. Compensation plus penalty. Just because of the reason that you compensated, you can't escape penalty. Boya cheppinattu adi undali. So, main point that you have to understand is 4 should be there, 5 also should be there. Understood? So, without prejudice, whenever a section is using, without prejudice, whenever section is using, you should override the section, you should take that section, take the section, notwithstanding ki, throw that section, prejudice ki, take that section. First case la, harmony la, dispute la, you will win. Second case la, harmony la, you should go with it. Here harmonious construction required or not required? Not required because already lawmaker said what to do with the 2 sections. Understood? Ante, over. That's what applicable for your exam. With this, we completed all rules of interpretation. The main content of the interpretation of statutes is over. Understood? Other provisions are also there. I will just clear that in 5 minutes. I will not go very deep into the other things. Easy concepts are there. I will just tell what is that. You can read it later and complete. Main concept of interpretation of statutes is completed with this. Sir, everyone tell me, interpretation of statutes, what is the difficult one? Rules say difficult. What is a preamble? What is explanation? That you can also read. Clear? See there. But I will not leave completely. I will just tell what is there. Later you can read from the notes. Okay? Shall I? See the screen. What is this? First one. I will put it full screen so that you will also get a clarity. Before that, sir, students joining in the live from Chennai, everyone understood the concept up to here? 102 section, explanatory statement, interpretation without prejudice. Understood? D. Sirikadre, answer. Thank you very much. Read management administration properly, or else gone. Shall we begin? People here also, please listen carefully. Let's see the screen. Okay. See here. What is the first topic? Read there. Long title and sir, what is this long title, short title? Question will arise, correct? Simple concept. One range gaadi. See there. What is this long title and short title concept? Long title. Once upon a time, 1999 time la, long titles used to be there in the law. Long title means what? There are 3 titles totally. First one is called as a short title. Second one is called as long title. Third one is called as a preamble. Third one is called as loudly. Short title. Section 1 is always a short title. Section 1 is always a, who said? Section 1 is said. Who will tell? I didn't write law. Let's say, who said? Section 1. Who will do section A said directly. This is short title. Short title contains the name of the act. How you can call this act is said in short title. Read. This act may be called the short title. Short title will tell what is there inside Companies Act. Will just recognize the act. This is Companies Act. This is GST. This is income tax. Like that, short title will not explain anything. It will just tell what this is. Long title, now in the acts not there. Once upon a time, why long title used to be there? It will not just recognize, it will more describe the act. More? Later, 1999, after constitutional amendments made in India, after that they brought preamble. Once the preambles came, long titles are removed from all the acts. Preamble will contain the scope, objective, purpose of bringing an act. Scope, purpose. Why this act came? There in preamble. Purpose, there in preamble. Operation, there in preamble. Everything is explained in preamble. When already preamble is there, why long title again? Therefore they removed. Tell me, what short title will contain? Short title will just recognize the law. Long title will not just recognize the law, will give some explanation. Read. Read from here. Read this. You read yourself. You remember, that's it. Enti, completed, huh? Whatever I said is there. Next, what is the next one? I told you just now, preamble will contain the purpose, scope and object of an act. Why an act has come into existence is explained in preamble. Cause will come, evil it want to remedy. Evil here represent not evil, deadly evil. Evil means the bad. Bad is going on. I want to stop that bad through an act. That's why preamble explains the object, scope and purpose. Preamble explains the object of an act more comprehensively than long title. When already I am explaining why long title again, they removed that. Listening? Continue. Next, preamble will express cause of an act. Next, evil it wanted to provide a remedy. Preamble cannot override the plain provision of law. Ante, what do you mean by this? This line you must write in exam. 1 mark will be given for this. What is that? Preamble cannot override plain provision of law. Sir, what does it mean? There is a section. You read. Sir, this section has what link with preamble? Like that you should not see each and every section. That's why in regular class, always I tell this as an example. If I take interpretation, preamble is like a reception to an office. Reception la what institute can do, what our services are, we will tell. Correct? Each and every day, everything need not happen as per what they said. Overall idea will be coming when you go to a reception. Same preamble also. Preamble will tell overall why an act has come. Every section you should not match with the preamble. Understood the point or not? Every section you should not match with the preamble. Okay? You went to an hospital. Reception you asked what services they will do. Cardiology, neurology, like that. So many things are there. They gave, listening, they gave, take a blood test. Where is blood test here in the board? Blood test not there. You are doing something ultra wise. Like that we should not do overaction. Reception is saying what all we will do or overall idea. Like that preamble also will tell overall what we can do. Exactly every day need not do what they said. Like that, preamble cannot override the plain provision of law. Okay, but when there is an ambiguity, preamble can be used for interpretation. Done. Can I go to the next one? Okay. What is the next one? Heading. Headings and title of a chapter. I will give you example. What is the chapter 1 of Companies Act? Preliminary. Chapter 2, Incorporation. Everyone, chapter 2? Okay. I will ask you one question, tell me. I wanted to know about how to issue right shares. Which chapter I should read? Chapter 1 or 2 or 3 or 4? 4. What is the name of the chapter? Share capital. How do you know? Because where share capital concepts are there, you know that there is a chapter with that name. And the answer is over. That's what you wanted to tell. Title will always help you to know what are the contents inside. The moment when I ask something about share capital, immediately, mindly you are getting, okay, chapter 4 share capital, because he is asking question on shares. And you are interpreting or not? Read. Generally, we find grouping of some say number of sections referring to a particular context or a subject. They are grouped by a prefix called as chapters or heading. One can legitimately use the heading to interpret the part of enactment. Means what? By reading the heading, I can understand all contents inside the chapter will be relating to share capital. When I ask you how to issue shares, your mind does not go to dividends chapter. Your mind does not go to accounts chapter. Your mind directly went to, that means you are interpreting or not? Answer. Now tell me, that interpretation is possible because of chapter heading. Where chapters are? In the act or outside the act? That's why these questions are called as internal aid of interpretation. Internally in the act only these are all helping you. Listening? That's it. Sir, I think you can understand all this. I don't want to waste time. Will you read it later? These are all small questions. Just read and leave. But pakka, one question will come from this. One question will come from the rules. Difficult one I already completed. Easy one I am leaving it for you to just give a reading and leave. With this, a 12 marks area is completed. Interpretation of statutes. Okay. Everyone in Chennai understood the entire chapter clearly? Perfect. Now, next area we are going to begin. So, the next area we are going to start in the revision is the Limited Liability Partnership Act. This act will be coming for 8 marks minimum, 10 marks maximum in exam. FEMA, LLP, next one, interpretation, general clauses come for 40 marks in exam. 4 chapters will come for 40 marks. So, extremely important from the exam's point of view. Shall I continue? See the screen. One by one, let us continue. First point. This revision session on LLP, I will go with all important concepts first. What are important from exam's point of view? I will complete them first. See, important dates. Act was announced on 9th January 2007. Parliament approved on 12th December 2008. President's assent is received on 7th January 2009. there are 4 schedules. Listen, 4 schedules are there. Schedule 1, LLP agreement format. Everyone tell me, LLP agreement format. What is LLP agreement? It contains rights and duties of partners. It will contain the, that is contained in which schedule? First schedule. 2, 3, 4 are conversion schedules. Conversion of firm into LLP, conversion of private company into LLP, conversion of unlisted public company into LLP. Read these 3. I'm making it full screen. Read and complete fast. Do you know for what this will be useful? MCQs. If you want, you can write it down somewhere. The dates and other things. Important for MCQ. Already one exam it came. That's why. Have you read? Next. See here. From now, provisions will start. See here. Listen carefully. First, definitions are important. First one. Shall we? Tell me what is the first one? Before going into body corporate, I will tell you what it is. Corporate features are of 5 types. Not like in a regular session, I will just go into the point required from exams and I will move to the next one. There are 5 corporate features. Okay? Like how we have human features, see, touch, taste, like that. Companies have corporate features. Corporates will have corporate features. What are they? Artificial legal person, perpetual succession, limited liability, common seal, separate legal existence. All these are called as what? Corporate features. Loudly. Very good. Corporate features. Okay. Now. Natural body or artificial body? Artificial body. Having. Loudly. Incorporated under. We call them as companies. Next. Body. Having. Incorporated under any act. Incorporated under Companies Act, any act. What is this? What is C? Body corporate. Understood the point? Tell me, any body, artificial body having what features? Corporate features. Incorporate under which act? Any act. We call it as what? Body corporate. In this any act, Companies Act also will come. Therefore, every company is a body corporate. Every body corporate is not a company. Tell. Every company is a body corporate, but every body corporate is not a company. Understood the point? Done. This is a point. So suddenly why you are explaining all this? Shall I tell you one thing? We completed the answer. Tell me, incorporated under which act? To become a body corporate, incorporated under which act? Hey, which act? Any act. Under which act? Any act, any Indian act. Any act that may be Indian, foreign. Means body corporate means company, and it includes LLP incorporated in India, LLP incorporated outside India, company incorporated outside India. Answer over. Just common sense. Nothing more required. Okay? Next, what is the definition we completed now? Body corporate. Next question for you. LLP can do charitable activities. Answer. LLP can do charitable activities. Answer. So, the point is, listen carefully. Whenever body corporate is, whenever I said body corporate, LLP is meant only to do profit oriented business. It cannot do charitable or non-economic activities. Correct? Ante it should do what? It should do what? Business. When I say business, business does not mean buying, selling. Business does not mean manufacture and sell. Buying and selling is called as a trade. TPSO are popular ones. Trade, profession, service, occupation. TPSO. T. P. Yes. O. All these four are coming under the term business. Read. Understood the point, everyone? That's it. Second definition over. What is the next one? Limited liability partnership. Tell me, partnership formed under Partnership Act is an LLP or not an LLP? Partnership formed under Partnership Act is an LLP or not an LLP? What is an LLP? LLP is a partnership. LLP is a formed and registered under LLP Act. Answer completed. Next definition over. Next definition. What is this? Okay. Listen. How to become a partner in LLP? By LLP agreement. By LLP? Answer completed. And they over. Partner means a person. Partner means a person. Partner means a natural person or persona. So company can also become a partner in an LLP. LLP can become a partner in LLP. Listening? Can Mr. A, Mr. B become partner? In LLP, can Mr. A, Mr. B become a partner? Yes. Mr. A and A Limited? Yes. A Limited, B Limited? Yes. A LLP, B LLP? A and Co partnership and B LLP? No, because partnership is not a person. Partnership is not a... Then partnership is what? Partnership is what? Partnership is a person or not a person? It is not a separate legal person. Why it is not a separate legal person? You should have come to foundation with me. then you might have understood partnership வேற level. See, I used to give this example always. Yesterday also when I was in Chennai, one foundation batch revision is going on. Like you for the CA Inter, there for the CA Foundation. Yesterday Partnership Act only completed for them. Partnership ki basic introduction. First introduction to partnership starts with this example. Father, mother, child 1, child 2. Forget about the gender. And if male and female are there, brother and sister, both are girl child sister, both are boy child brothers, adi forget. Gender I am not taking now. I am talking about the name given to the relationship. Tell me, C1 and C2 are called as what? Loudly. Okay, I will write here. Called as a sibling. Okay, very good. Now, how many people are there in this family? Answer. 5. Father, mother, child 1, child 2, sibling. Solunga. Tell, who are there in this family? Father, mother, child 1, child 2, sibling. 5 people are there. Why no? Sibling is a persona. Sibling is a name given to relationship. Alane partnership is a name given to relationship. Partnership is not a person. Understood? That's why you should read Partnership Act properly. Section 4 of Partnership Act, what it say? Partnership is a relation between the persons. Partnership is a relation between the persons who agreed to share the profits of a business carried on by all, any of them acting for all. That's what the definition of a partnership. Yes, sir. Yes. Now tell me, partnership is a person, not a person. Why? Now tell the reason. Partnership is a name given to the relationship. Relationship is not a person, it's a name. Company is not a name, company is a person. LLP is a person. So tell me, who can become a partner? Person. LLP can form LLP. Company. LLP. Company LLP. LLP company. Individual. Individual company. Individual LLP. Partnership LLP. Partnership. LLP partnership. Company partnership. Individual partnership. Individual. Perfect. Like the speed you should give an answer. Then you are understanding. Next one. Tell me, what is a foreign company? Foreign company means a company incorporated outside India and having a place of business in India. This is the definition of what? Foreign company. Now put LLP in place and read. Foreign LLP is a LLP incorporated outside India, having a place of business in India. Same. Read. Tell me, what is a foreign LLP? LLP incorporated outside India, but place of business is in India. Done. Next. Easy. Kachara section. Tell me, financial year starts from 1st April, ends with 31st March. However, company started, LLP started after 30th of September. After means how much gap is only there? 6 months. If I start, for example, today, what is the date here? 27th March. Today I incorporated a company, LLP. Financial year 4 days is there. 28, 29, 30, 31. 4 days ki what balance sheet you will prepare? Correct or not? If a LLP gets incorporated, after 30th of September, it becomes very difficult to close a financial year because lesser period is there. So what they said, if a LLP, normally financial year starts on 1st April, ends on 31st March next year. However, if LLP gets incorporated after 30th of September, two options are given. Two options are given. It may close its first financial year in the immediate 31st March or 31st March of the following financial year. Following? Do you know what does it mean? First financial year of LLP can be as low as 1 day, as high as 18 months. What you understood? What I said now? First financial year, not every financial year. First financial year of LLP can be as low as 1 day. For example, I started on 31st March. 31st March I prepared balance sheet means 1 day. I started on 31st March. Okay. I can close not in this I started on 1st October. Now I can close this financial year not in the 31st. Go up to next 35. Then next year 12 months, this year 6 months. Total 18 months. This is possible every year of first financial year. That's it. Answer is completed. Read financial year definition. After reading all this, I will give you 5 minutes time to read from study material also. You will read and confirm whether whatever we discussed is there in the study material again. Okay, na everyone? Understood? What is the next one? LLP, tell me. Partnership has agreement or no agreement? Partnership has agreement or no agreement? If no agreement, no partnership. Yeah. Partnership is a relation between the partners who have agreed. But the problem is there that agreement can be oral, written, express, implied. But here it should be in a written form only. Where? LLP. So LLP agreement is a oral agreement, written agreement. Written agreement. It is an agreement between whom and whom? This is very important. It is an agreement between partners with partners and partners with LLP. Because LLP is a separate person. LLP is a... Tell me what it contains. It contains what? Mutual rights and liabilities. Duties. Repeat. Mutual rights and duties. Of whom? Partners with partners. Partners with LLP. Understood? Answer over. Read. Okay. Next, what is the next one? Small LLP. Tell me what is a small LLP. First tell me what is a small company. Section 2 class 85. What is a small company? Small company means a company other than public company having a paid up share capital not exceeding rupees 4 crore and turnover not exceeding 40 crore, and nothing in this clause shall applicable to a holding company, subsidiary company, or a section 8 company, or a company or a body corporate incorporated under special act. Section 2 class 85. What do you understand? What is a small company? Small company means a company who has a paid up share capital of not exceeding 4 crore, turnover not exceeding 40 crore. Here 4 to 40 does not apply because it is LLP. It is a small size. Therefore, not exceeding 25 lakhs, turnover not exceeding 40 lakhs. Answer completed. Which one you completed now? Small LLP. How much maximum government provided? Not required. As of now, 25, 40 you have to remember. Listening, more, not more than. Okay, if it is more, status will not be given. Up to 25 they will give. Clear? Next. What is the next one? Designated partner. Before going into the designated partner and other things, up to here, did you all understand all the definitions? Please come to LLP Act definitions. One sec. So students in Chennai from live, have you all understood all the concept up to here? Done. Let us complete fastly. See here. What is required? Those definitions only I am reading. Unnecessary address, all these things they don't ask anyway. Main definitions I am covering. Body corporate definition, have you read or not? Next one, business. Hey, business. Business, TPSO, trade, profession, service, occupation. Next one, chartered accountant. Required definition. They don't anyway ask in exam. Chartered accountant means chartered accountant as defined in Chartered Accountants Act. Yeah, the definition. Next, what is the next one? Designated, just now we are going to read. Designated partner means a partner. Repeat. Designated under section 7. That's it. First he should be a partner. Later given with a designation. Given with a. To become a chief minister, first you should become a MLA. Understood? MLA will be designated as chief minister. I like that he also. First to become a partner. After that we will designate you as a DP. Listening? Next. Entity also not required. Financial definition completed? Yes. Foreign LLP? Yes. LLP? Yes. LLP agreement? Yes. Name not required now. Partner. Hey, partner. Partner in relation to an LLP means any person who become a partner by what agreement? LLP agreement. LLP? Regional director, registrar, company secretary we will read directly. Okay, not required now. Small LLP, 25 lakh. Okay, 40 lakh. Had we read or not? Next. Tribunal means NCLT. Tribunal means? And their definitions are over. What are you waiting for? Over. Okay. Next. What is the next concept here? You see how many characters are there? 16 characteristics. Sir, how many hours it will take? 16 minutes also it don't take. At the easy it is. Okay? Count. Listen carefully. First I will explain every point. I will not leave anything. Each and every point. 16 are given. Exam if they ask at least 12 we should write. How many? At 12 important I will spot out and I will explain. Okay? First one. What is the first one? First one. LLP is a body corporate. Sir, everyone should listen. People in live also please listen carefully. Please. Start. LLP is a. Because LLP is a body corporate, it gets the characteristics of corporate features. Tell me, what are the corporate features? Artificial legal person, perpetual succession, limited liability, common seal, separate legal existence. LLP is a body corporate. LLP is a separate legal entity having perpetual succession. That's it. That's the main point. Next one. What is the second feature? Second feature. Okay. Now, perpetual succession means partners may come, partners may go, but LLP will always remain. Same like a company. Death, insolvency, insanity, retirement of the partners will affect LLP or will not affect LLP. That's it. That's the perpetual succession. Okay? Have you read? Now tell me, LLP is a body corporator, not a body corporator. Therefore, it is separate from that of its partners. liabilities of LLP are paid out of assets of LLP only, not out of the pocket money of partners. Liabilities of LLP is paid out of assets of LLP. If assets are insufficient, then who will pay? Partners are liable, but to the full extent, only to the extent of agreed contribution. Only to the extent of agreed contribution. Creditors of LLP are treated as creditors of LLP alone. Read the third one. Okay, have you read or not? Mutual agency you leave because that is a partnership related. I don't want to discuss now. Next one. Now you tell me, please tell me in one point. LLP agreement is a oral agreement or written agreement? Agreed by partners. What it will contain? Just now I told mutual rights and duties of whom? Of the partners will be contained in the LLP agreement. Will be contained in the LLP agreement. What will be contained in LLP agreement? Mutual rights and duties of whom? Of the partners will be contained in LLP agreement. Clear? From this what you have to understand? Rights and duties of the shareholders, rights and duties of the directors in companies is decided by Companies Act. But in LLP, flexibility is there. What is my right as a partner? What is my duty as a partner? Is decided by partners itself. Is decided by. That's the beauty of LLP agreement. Now tell me, LLP agreement is a oral agreement, written agreement? Written agreement. It is an agreement between partners among themselves, partners with LLP. It is prepared by LLP Act. It is prepared by partners. Partners. Therefore, there is a flexibility. If partners do not prepare LLP agreement, Schedule 1 will apply. What is Schedule 1? Format of LLP agreement. If you write your own LLP agreement, I will not interfere. If you don't write, Schedule 1 of LLP Act will apply. So Schedule 1 to apply or not to apply is in whose hands? Partners' hands only. If you write, I will not interfere. If you don't write, I will interfere. But one thing is common. Without LLP agreement, LLPs are not formed. Do you know one example shall I give you? What should be the profit sharing ratio? For example, 3 partners are there. What should be the profit sharing ratio? 2 partners are there. What is the profit sharing ratio? Loudly. First they have to decide and write there. 60-40 or 30-70 or something they have to write. If you don't write, LLP agreement will apply. LLP agreement equal share. That's how it will apply, LLP agreement. If you write on your own, that will apply. If you don't write, I can't just sit calm. I will apply the LLP agreement as per Schedule 1 of LLP Act. Understood? Next issue. You can read in the meanwhile. Done? What we completed now? Tell me the features we completed till now. Body corporate, perpetual succession, separate legal existence, LLP agreement. Okay. Next, artificial legal person. Artificial are a super easy concept. Tell me, LLP is a person created by law. So it is a person clothed with natural personality like you and me with hands and legs. Legal personality. But it can do whatever a natural person can do. Now tell me, can you buy goods? LLP also can buy. Can you sell goods? LLP also can do. It can do whatever natural person can do. It can do whatever natural person can do. Except certain things like marry. Array, this is not my example. See there. Adi vaadi creativity. Cannot marry, cannot get divorce, cannot learn a profession. All these things are the creativity of ICAI. So, with an absolute respect, due respect on the institute, let us read whatever is given by the rules of the institute. What is the side heading we are going to read? Artificial legal personality. What an artificial legal personality wanted to tell? LLP is an artificial person created by law. It is a legal person clothed with legal personality. It has all the characters like a natural person. It can buy, it can sell, it can dispose, everything it can do. But certain things like a human being, it cannot do, marry, etc. Listening. Asla understood up to here? Final touch. Okay. Whenever I said artificial legal person, it is a person first. Who recognizes it? Law recognizes it. Therefore, under law, whatever you and me can do, everything they can also do. Contract act I can buy, LLP also can buy. I can sell, LLP also can sell. So as per law, LLP can do everything except a few. Understood the point? See this? LLP is an artificial person because it is created by legal, it is clothed with rights of an individual. It can do everything what a natural person can do except it cannot be jailed, etc. Okay. Next one. From here, just it will take 1 minute each to complete all. Tell me what are all the features we completed. I will tick mark. Body corporate, perpetual succession, separate legal entity, mutual agency not completed, LLP agreement, artificial legal. What is the official signature of an LLP called as? Common seal. Common seal is optional, mandatory, optional. Next one. Tell me, liability of a partner in LLP will be unlimited or limited? Limited to the extent of agreed contribution. Limited to the extent of what is the next one? Tell me, in a company who will manage the business? Directors. In a LLP who will manage the business? Everyone? Partners will manage. Partners will. There is an absolute wrong notion in the mind of these students. Designated partners are like directors to company. No. Listen. LLP is an artificial person, a natural person. Loudly. If LLP does a mistake, can I put LLP in jail? Answer. For example, LLP is not paying GST. It should be punished by keeping in jail. But LLP is a... How can I keep that in jail? So I require one natural person to put in jail. That responsibility of legal compliance is taken by DP. DP is not a management. Tell me, who will manage the business of LLP? Partners will manage. But the legal responsibilities and compliances are taken by designated partners in LLP. Hopefully everyone understood clearly. Okay. Next. Minimum and maximum number of members and partners. Tell me, company ki minimum number of members, private company 2, public company 7, maximum private company 200, public company unlimited. LLP minimum number of members partners will be 2, maximum is unlimited. Next, business for profit only. I told already. LLP cannot be incorporated for social cause, non-economic purpose. No, it should be formed only for business purpose and for profit. Next. Remaining not required here. Foreign LLP. LLP incorporated outside India. Place of business in India. Total all. How many are there totally? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. Conversion into LLP. Tell me. Conversion of other entities into LLP possible or not possible? Possible. 3 things is possible. What are those? Firm into LLP. private company into LLP, unlisted public company into LLP. Possible or not possible? That's it. With this we completed 12 features out of 16. If comes in exam, it will come for 4 marks. At least write down 10 points. Listening, huh? Everyone in the class understood clearly? Okay. With this, we completed, what we completed now? What we completed now? Characteristics of a company is completed. Okay, let's continue. First, tell me everyone, all the characters of LLP understood clearly? Done. Let's go to some more important concepts. See here, first, designated partner. What is the next concept? Designated partner. Let us see. Designated partner means a partner who is designated as such as per section number 7. Means in section 7 of LLP Act, we will designate a partner as a designated partner. Who is a designated partner? A partner who is designated under section 7. What is the purpose of designated partner? Just now I told before break. What is the purpose? Legal compliances responsibility is taken by designated partner. There should be some person to be kept in jail or not if something goes wrong. To keep in jail, 2 things are required. First, he should be individual. How can you put company in a jail? So designated partner must be individual. Sorry, individually, he is in Switzerland. How can you? Therefore, he must be resident. Understood? So, minimum how many designated partners must be there? 2. In that, at least one should be resident in India. So, resident means income tax residential status. No, not less than 120 days he should stay in India during the financial year. During the... Okay, read now. First, modes of appointment. Modes of appointment. Hey, please see here. Modes of appointment means how to appoint designated partner. Read. Situation 1. Read. If you are appointing the designated partner at the time of incorporation, way 1. Read. Huh? Okay. So see here. Mode of appointment. How to appoint a designated partner? Designated partner can be appointed in 2 ways. Number 1, way 1, at the time of incorporation. Way 2, after incorporation also you can change the designated partner. If you appoint a designated partner at the time of incorporation, how many ways are there totally? 2 ways. What is the way number 1? Incorporation document may specify who will be the DP. DP means what? Designated partner. Sir, what is this incorporation document? Listen. To incorporate a company, there is a form called as a SPICE. Called as what? SPICE. Simplified Proforma for incorporating the companies electronically. What is the form? SPICE. To that SPICE form, what we need to attach? MOA, AOA, other documents we need to attach. To what you will attach? To what you will attach? To the SPICE is called as incorporation document. Like the LLP also have an incorporation document or not? That's called as a form 1. Called as what? To that form 1, you will attach all the things. That incorporation document form 1 may specify who will be the designated partners. Where you will mention? Where you will mention? Hey, where you will mention? Incorporation document. What you will mention? Who should be the DP? Once LLP is incorporated, immediately that person will become DP. That is one way. Way number 2, read. Incorporation document may state that each partner shall be DP, and in such case, all partners shall be DP. Means what? Separately, I will not tell who will become. I will tell all partners are DPs. 6 partners are there. Incorporation over. What will happen? All 6 will become DPs. And every partner is a both partner as well as designated partner. Next one. After incorporation, a partner may become DP by LLP agreement and cease to be a DP as per LLP agreement. So even after getting incorporated also, you can add DP, you can remove a DP. Understood? Yep. See here. First point. Read point number 2. A, B and point 2. Read it. Okay, done. Did you find all the points or not? Next, this is important one now. Preliminary conditions. LLP must have minimum how many DPs? 2. Only who should become a DP? Individuals. Not only just having 2 DPs is important. At least 1 DP shall be a resident in India. Shall be a resident in? Next, a LLP with all partners being body corporate, nominees shall become DP. You tell me, who can become a partner? Any person. Can company become a partner? A limited, B limited. Can they form an LLP? A limited is an artificial person or natural person. Cannot become a DP. Can become a partner but cannot become a DP. B limited is a artificial person, body corporate. Can become a DP or cannot? Cannot. Therefore, if all the partners in LLP are DP, all the partners in LLP are non-individuals, in such case, those body corporates will nominate individuals, nominate as the DPs. They will be part, A limited will tell Mr. A is my nominee. B limited will tell Mr. B is my nominee. Those nominees will be taken as a designated partners. Understood the point clearly? Very, very important point here. Tell me, how many DPs are minimum? Only who can become DP? At least 1 DP shall be resident in India. Sir, what is a resident? Read. Resident shall stay in India for not less than 120 days during the financial year. Now, read. LLP with all partners being body corporate, nominee shall become DP. A LLP with both body corporate and individuals shall have such individual partners to be the DP and nominees of body corporate being individuals to be DP. Mr. A and A limited are partners. Mr. A and A limited are partners. Now what you have to do? Mr. A will become DP. A limited's nominee will become another DP. Understood? In simple language, whenever body corporate is involved, it cannot become DP. But what it will do? Nominate a person, that nominee will become DP. Clarity, yeah? Okay, done. Now I want every one of you to read this and this. Completed? Understood? Hello, everyone in the class understood? Next. So we completed up to here. Now, from here, dead easy, other points will come. Before getting appointed as a DP, take his not consent, prior written consent. 3 conditions. It should not be taken after appointment, taken prior. It should not be oral consent, written. And you should take a consent. 3 conditions. Prior written consent. Very good. You appointed him. ROC also should know or not? Send to ROC within 30 days. 30 days. Directors will have DIN. These DPs will have DPIN under section number 153 to 159. Okay. Sorry. Okay. Everyone in the class understood this point, section number 7 clearly? Very good. So, this is all. Before that, what we need to take? Prior consent must be taken. File with the registrar within 30 days. You should obtain DPIN. Under which section? 153 to 159. Do you find all the points in my material? Yes. That's it. Over. Main concept on DP is over. Later I started with the characteristics of a company. LLP. Over. Next. From here, listen carefully to the logic. I will tell you. We will first read. I will give time. Read the study material. Confirm whether everything is complete or not. Once you say yes, we'll go to the next one. Clear? Okay, start. Non-applicability of Partnership Act. Non-applicability of? Tell me, what is the act we are reading? L means? Another L? P? Therefore, Indian Partnership Act 1932 will apply or will not apply? Will not apply. That's it. Section 4 over. Okay? Just because of the reason that this is a partnership, Partnership Act does not apply. For this separate act is written. What is that? Limited Liability Partnership Act. That will get applied. The provisions of Indian Partnership Act 1932 shall not apply for LLP. Which section we completed now? Section number 4. He did not give here. What is the next one? 5. Section number 5. Okay. See here. Section 5, I will make you to read from here. Listen. Section 5 is talking about disqualifications of partner. Means to become a partner, these are all the qualifications and disqualifications. You cannot become a partner if he is of unsound mind. Who should tell that you are unsound? Court should tell. Or you are declared as insolvent, or you yourself applied that you will be insolvent. Creditor filed a complaint on you and court said that you are insolvent. Second point. You yourself applied on you saying that I am insolvent. Then court need not do investigation. From the application date itself you are insolvent. They listening? Insolvency can be of how many types? 2 types. Creditors filing a complaint on debtor. Second one, debtor filing a complaint on himself. When you make complaint on yourself, nothing to prove, you yourself is telling that you are insolvent. Then we need to wait till the court order. Need not wait. Need not wait. From the day of application itself you are insolvent. From the day of application itself you are disqualified. Clear? That's why 2 points of insolvency is there. What is the second point of insolvency? What is the first? Insolvency, what is the first one? Undischarged insolvent. Means court said that you are insolvent. You are inside the insolvency, not it discharged. That's called as undischarged insolvent. Second one, you are not proved that insolvent. You may made an application only. Listening, but who made application? Himself made an application. From the date of application itself, you are disqualified. Understood the logic? Okay, done. So tell me, what are the 3 situations under which you are disqualified to become a partner? Unsound mind, decision given by competent court. Second one, undischarged insolvent. Next one, applied to be adjudicated as insolvent. And application is still pending, but no problem, you are disqualified. Listening? Which section we completed now? Section number 5. Next, what is the next one? Section 6. Listen, minimum, you know this already. Minimum partners in LLP is 2. Maximum unlimited. But one point is there. If the number of partners in LLP, if the number of partners in LLP falls below 2, falls below, and only how many are there? 1. Nothing will happen all of a sudden. 6 months we will wait. In that 6 months period, you need to bring another partner, again make it to 2. If no partner was brought within 6 months, stop doing the business. No, sir, I will continue. If you continue, any liability incurred after 6 months with that one partner will become personally liable. What liable? See this example. Tell me. We started LLP with how many partners? See there and tell ya, 2 partners. Okay. 4 years we continued with 2 partners. So tell me, any liability incurred between these 4 years, who will be liable? LLP is liable. 4th year, one partner is died. 2 partners became 1 partner. Can I continue or cannot? Can continue for 6 months. In this 6 months time, who is liable? LLP liable. In the 6 months, ideally what you should have done? Bring another partner, make it 2. But still it is only how much? 1. Continued for another. This 3 months is a offensive time. During this period, you should do or should not do business? Should not. If you do, anything happen, who will be liable? Partner liable. After 3 months, again you brought a new person, making it 2. From this again LLP is liable. Understood? That's why lawmaker uses the word during such a time. During such a time, that period only. Read the point. If at any time, number of partners of LLP is reduced below 2 and the LLP carries on the business for more than 6 months, while the number is so reduced, the person who is the only partner of LLP during the time and so carries on business after 6 months and has a knowledge shall be liable personally for the obligations of LLP during that period. That period means which period? Period within which number is reduced below 2. Understood? That's it. Difficult or easier? Tell me first. Very, very easy if you read once. One time effort you should put now first. That's it. So we completed section number 4, section number 5 and section number 6. See, first one, unsound mind finding is in force. Undischarged insolvent applied to be adjudicated as insolvent. Correct? Okay. Next. These are all for regular classes, not for revision classes. Yeah. Lot of analysis we have done in the class at that time. Not required from the revision point of view. But see here. Pre-incorporation procedures will start. Okay. Okay. Now I am going to do analysis on, tell me, 15, 16, 17, 13, 14. Okay. Those are the things we are going to discuss and complete. Okay. Tell me, what are the things we are going to do now? 13, 14, 15, 16, 17. Okay. Those are the things. Once those are completed, remaining concepts will not take much of the time. We'll complete it in no time and we will close it. Okay. Mainly our target now, we have to complete section number 13, 14, 15, 16, 17. If we can complete that, half the LLP will be over with it. Listening, remaining half will take around 1.5 hour time. Next session we'll first start with and complete, and then we'll go into FEMA. Clear? Then another 10 marks also will get completed. Finally, I will go into the GCA. What is GCA? General Classes Act. Then 4 acts completed. How many marks is over? 42 days lo 40 marks coverage. Understood? Once completed, then after that, important concepts of the Companies Act I will deal with. Understood? Then you will also get a confidence. When I say important concepts on Companies Act, I will first start with companies incorporated outside India. Compulsory areas are there in Companies Act. Okay? Okay, management administration, share capital, companies incorporated outside India. Like this, 5 important chapters are there. Those we will summarize and complete. First importance is on other laws. 40 marks. Don't take a chance. A 40 level, you should get minimum 32 to 33. If you getting 70 plus is not a problem. Students will not get 70 plus in law because of the reason that they don't know other laws first. First interpretation of statute say they don't study. 10 marks gone. At 10 they are getting 1 or 2 marks. FEMA law they are getting around 5 to 5 marks max. LLP law they will get around 2 to 3 marks or 4 marks. Over. At a 30 law you are hardly scoring 10 marks. Then how can you get 70? Understood? 70 marks ki secret of success is very simple. Like in FM, when I take the sessions for you, what I said, the selected chapters will be there, the quality chapters. Because those things if you do, you will get that 40 plus in 50 marks. Like that here also, these are the chapters you need to study. Clear? Let's begin. Target sections 13, 14, 15, 16, 17. First what I will do is, I will complete 15, 16, 17. Reason, ditto Companies Act. Okay, let us start. What is the concept? Name. Listen. Whenever I say LLP, LLP should add the name LLP at the end of its name. You can add in 2 ways. Full you can write Limited Liability Partnership, or you can write as LLP. Listening? Next. Name of LLP should not be undesirable, should not be identical or too nearly resemble to the name of any other LLP or name of any other company or a name of any other registered trademark. Answer completed. Tell answer now. How the name of LLP should be? What should be there, sir? See, name, whenever I ask, you should tell do's, don'ts both. What you should do with name, what you should do not do with name. Okay? What you should do with the name. How LLP name should be. LLP should use the words Limited Liability Partnership or LLP at the beginning, middle, end. 1 point completed. How it should not be? It should not be undesirable. It should not be identical or too nearly resemble to the name of an existing LLP, company or a registered trademark. Understood the point or not? Done. This is also there in Companies Act. Which section? Chachindi gurre. Which section? Section number 4. Section number 4. 3 is formation of company. 3 is formation of company. 3A will be talking about 3 formation. 3A, members personally liable in certain cases. Same this concept. Partners became 2 from 1, there became 1 from 2. Their number of members became less than 7 in public company, less than 2 in case of private company. Same concept. Adi 3A. 4 will be talking about memorandum. In memorandum, name clause is one among them. There we will see that. It is there, believe me. Which section it is there? Section number 4. You can blindly believe when I say section numbers and content. Okay? So now, section 15, everyone understood clearly? Next, what is the next one? Section 16. This concept is also there in Companies Act. Their Companies Act reservation is there in section 15. Rules it is there. Where it is? Rules. Here it is there at section 16. Shall we go into it? Listen. Directly you cannot start LLP with a name. First you have to reserve a name for an LLP. Reserve a Name for LLP. You want a name. Reserve the name first. After reserving the name of LLP, after reserving the name of LLP, then you should go for formation of LLP with that reserved name. Tell me, what should you do? First, what you need to do? Reserve a name. After reserving the name, then you have to go for formation of LLP. So directly you cannot form LLP with a name. First, what you need to do? Reserve the name, and then you have to go for formation of LLP in the name of that reserved LLP name. Understood? Okay. Now, a person may apply. When I say a person, you, me also can apply. Okay? Why? I wanted to start LLP. I can apply for reservation. You wanted to start LLP. You will apply for reservation. Okay, any person. Apply to whom? Apply for what? Reservation. Reservation will be made in two situations. I wanted to start LLP, ABC LLP. For reserving that ABC name, I require to apply for reservation. Correct or not? I started. 10 years completed. I wanted to change the name from ABC to XYZ. ABC to? And my company is existing company, a new company. Existing company, I wanted to change the name. Change the? Even in that case, you can't change directly. A change in name first you have to reserve. That's why name to which LLP proposes to change its name. So tell me, when reservation is required? At the time of formation, at the time of change, both cases are. Both cases. Understood? Okay, tell me, who will apply? Proper response. Who will apply? May do what? Apply. Apply for what? Reservation. Reservation of what? Name. Of whom? LLP. For what LLP? Proposed LLP or existing LLP wanted to change its name. In both cases, reserve. Reservation you need to apply to whom? Form number, all these are not applicable for exam. So unnecessarily don't do overaction. Just write down such a form, such a manner, with a such fees. That's all over. But you should remember one thing. Apply to whom? ROC. Apply to whom? ROC, registrar. Reservation is valid for a period of 3 months from the date of intimation by registrar. Today registrar sent an email. Your name has been registered, reserved. That reserved name will be valid for? What do you mean by reserved name is valid for 3 months? What do you mean by that? What do you understand from that? No. Within 3 months you should incorporate LLP. If you don't incorporate LLP within 3 months, cancel, again pay money, again reserve the name. And your incorporation process should complete within 3 months. That's the meaning here. Listening? Okay. So tell me, who should apply? Any person. Apply to whom? ROC. Apply for what? Reservation. Reservation of what? Name. Name of whom? LLP. Which kind of LLP? Proposed LLP or existing LLP which wanted to change its name. Okay. Who will receive application? ROC. With the payment of fee. Then he will reserve the name unless it is rejected. Your name is undesirable. What he will do? Reject. Understood or not? Name of LLP what you selected is an undesirable name. What he will do? Rejected. Rejected under which section? Section number 15. That's why he said, not one which may be rejected under section 15. Then he will reserve the name for a period of how many months? 3 months. Within the 3 months, what you should do? Incorporate LLP. If you don't incorporate and slept for 3 months, what will happen? Gone. Expiry of that reserved name. Other person will take it. Understood? Next. What is this? Everyone, rectification. See here. I will give you example. What is this concept of rectification? Full point I will tell. See here. So this concept is ditto there in Companies Act. There it is section 16. Last attempt 5 marks question came from this only. Last attempt. Jan 2025 attempt 5 marks question came from this in Companies Act. Okay, rectification of name. What name here? Let me explain what is this concept. Mistakes can be done by anyone. ROC also can do mistake. This section is ROC's mistake. And a mistake means what? Mine is an LLP. I applied for a name. Computers will have intelligence, but not wisdom. Intelligence is different. Wisdom is different. Who will have wisdom? Human beings will have wisdom. What is right, what is wrong, who will know? Human being will know. Computers don't know. Computer, if you give command, it can do. Sir, people will tell, so many things are going on, so many things are happening. Artificial intelligence like Grok, all these things are came. Artificial intelligence is taking a different turn. But at the end of the day, everyone should understand one thing. Whether it is artificial intelligence or chat GPT or whatever it may be, someone should have already given the answers to it or not. That answers, so mixing it will do appropriately. But someone might have feed the answers or not. For example, I said, give a story on Mahatma Gandhi, if I write. Already, data relating to Mahatma Gandhi is there in web. Understood or not? It will mix the data properly and give in a more cinematic way. That GPT can do. Data is not there. Write something about Kaushik Mukesh means what it will write. About me, what is there in websites, they will write. Kaushik Mukesh is a practice chartered accountant qualified in the year 2012. Like that, some details. What I kept on public platform, it will tell. Correct or not? Write about Kaushik Mukesh's father. What they will write? They can't write it because my father is not into public platform. Correct or not? What it will not write anything. Why? Source is not there in the web. Now you can understand what I said, right? Means computers will have intelligence. It will remember things, mix it and give a data answer. But it can't create something things. Correct or not? That's why human beings will have wisdom. Computers will have intelligence. Okay? On this only problem started. MCA website look you will go. You will start a LLP with the name Read properly, loudly. What is this? X. What is this? Y. What is this? Z. Actually, what is this? XYZ Limited. This LLP is already there. If you exactly give XYZ, what they will do? Cancel. Computer will have intelligence, na? Immediately database look, it will go. Your Gmail account exists already. It will give. Correct or not? One word if you change also, it will not recognize. Okay. Here not one word. Everything I changed. Correct or not? YEX is what? X. YEY? Y. ZED? Z Limited. Therefore, computer will accept this or not accept this? Loudly. Very good. This is a popular company. Example, let us say. Next day paperly it came. Or next day newsletter they said, XYZ Limited has done scam. Actually, this company has done the scam. But since this is popular, what people will think on the sounding they will go. Correct or not? The problem. That's why sometimes by inadvertence, by what? Inadvertence. Advertence means unintentional. Inadvertence means without any intention to do some wrong. If name of a LLP is recognized and registered with the name of any LLP which is already in existence, or it is similar to the name of a trademark, it is similar to the name of a, then the company or LLP whose name is similar to this should make an application to the government, central government should make an application to the, like trademark I have, what I have? My trademark name is XYZ. My company name is different. So do you know a company with the name DMart? D-Mart. You know a company called as a D-Mart. There is no such company. D-Mart is the name of a trademark. Name of the company is Avenue Supermarts Limited. Name of company so many people don't know. Name of the company is what? Avenue Supermart. Do you know there is a company with the name called as a DC Foodie eBay Limited? You know a company DC Food eBay Limited? A brand name is Zomato. People don't know company name. What people know? Trademark name people will know. Zomato does the fraud means Zomato company not there. Like anta knowledge Indians kunte. Are you understanding the point? That much knowledge we don't have. Company name is different. People go by trademark. How much Indians go to extreme ends in trademarks also. We use it as a verb. I googled it. Googled. And people, Indians will own it. I googled it. Google is a noun. They will use it as a adjective, verb, everything they will use. Where you went? I took Xerox. Xerox is a noun. And we use it for actions. Trademarks also same. Are you understanding or not? So, no one will tell I ordered food from DC Foodie eBay Limited. That much they don't tell. What they will tell? I ordered food on Zomato. And the people own trademark. That's why trademark is kept here. Indians own trademarks. Okay, we will take it to heart. Especially Indians. Brand ante manaku asalu adi sir mana brand. So we are more concerned about brand na. So that's why what they said, a lawmaker understood this weakness of Indians. They said, your name may not be similar to company name because people don't know company name originally. They are more going by trademark, brand names. Trademark means nothing but brand, yeah. Understood? How Apple company look like? Now one logo will come in mind. 1/4 bitten apple. That will come in mind. Really, Apple company doesn't look like that. Different style. How Microsoft will look like? How Google will look like? Now what came in your mind? Their trademarks, brand names came. A brand name is trademark. A logo is registered trademark. Understood? And the Indians who keep worldwide people will always remember only brand name. McDonald's, how it look like? Yamma and McDonald's look like Yamma. McDonald's brand is look like him. Now what you understand? People are successful in creating trademarks or not? That trademark you are copying. Your LLP should not be like that. Listening? So, by mistake, ROC incorporated LLP. Incorporated? Because computer don't know the mistake, na? ROC incorporated LLP with the name of a company or with the name of LLP or which is similar to the name of a registered trademark. Listening? Very good. So, see here. Notwithstanding anything contained in 1516, which is notwithstanding. What is notwithstanding? Ignoring 15, ignoring 16. Understood? Ignoring 15, ignoring 16. Forget about those two sections. Okay? Ignoring 15 and ignoring 16. Sir, why to ignore 16, sir? Question will come. My company name is similar or not similar? My company name is similar or not similar? Similar. Mistake is with whom? My mistake. My mistake. Not my mistake. Whose mistake? Your computer mistake. Whose computer? MCA. And the ROC means MCA. And this is your mistake or my mistake? Government mistake? Person's mistake? Government mistake. For that, why I will reserve? And I will pay money and reserve. Already reserved, you give wrong name. I was incorporated with a name which is similar or dissimilar. Who incorporated that? ROC. And a mistake is with whom? ROC said, sorry, your company, your LLP name is similar to another LLP name. Reserve with a new name, pay fees again. Me chupta vartadu. Understood or not? With a leather slipper they will hit. Arey, ROC mistake is with you. I have applied, you only said yes or that name. Why I will reserve? That's why notwithstanding 16. Understood the point or not? That's why notwithstanding 16. Forget about reservation. Rectification time, if you have to rectify, reserve and new name need not be done. Direct new name, put it, reserve with the, rectify the name and give a new name to that LLP. That's why notwithstanding anything contained in 1516. Regular classes means I can tell a lot of story on this, but understood or not everyone? What I said now? Notwithstanding real application we saw now. Okay? Through inadvertence and by mistake or otherwise, and a similar kind. Ejusdem Generis. Otherwise. Okay? Everywhere interpretations will come. The LLP on its first registration on its new name, the registered by a name which is identical with the name of LLP, company, or a trademark, or a registered trademark. Next. As likely to be mistaken, then on an application of such LLP or proprietor referred to in clauses A and B, or a company or central government may direct such LLP to change the name within a period of how many months? Means they should first make a complaint. Who should make a complaint? That other company whose name is matching with us, or a trademark owner will be there. That person should first make a complaint to central government. Central government will ask you to change within a period of 3 months. Within a period of, but one important point here. Okay? Trademark is there. What mark? My trademark is DMart. You started LLP with the name DMart. And your name of LLP is similar to name of another LLP, company, trademark. I came to know about it. I wanted you to change that. I will first make a petition to whom? Central government. Saying that, Babu, see there, one person has started LLP with the name of DMart. People will think if we do any nonsense. People will think I have done that. Please ask him to change it. Then ROC will see, I checked LLP names, registered trademarks, I did not check. Very, very sorry. I will ask him to change. He came to me and said, Kaushik Mukesh, you started LLP with the name DMart, na? Please change it. Reserve the new name. Pay fees, mean. Who asked you to reserve? First time I applied for DMart, you only said yes or not. So I will not do. So government will tell, no need to reserve. 3 months you give one name. This time I will check properly. Listening. With that name you can directly get rectified and with the new name. But rectification should be done within a period of how many months? But on one condition. The proprietor is there, na? He should complain within 3 years of registration of LLP with that name. Today I was starting my LLP with a DMart name. You came 8 years after. Not valid. Minimum how many years? 3 years maximum you should come. Next. Where LLP changes its name, it shall within a period of 15 days give a notice to the registrar. Ante ROC records still what name is there? DMart name only is there. ROC records change has to be happened or not. Once you rectify, tell the ROC within 15 days. ROC will make the changes within 30 days. Within? Sir, how many months time I have given? To change. Loudly, 3 months. Changed. You should inform ROC within. ROC will make the changes in his documents within. It is time limits. I gave you how many months time for you to change? Answer. You did not change. What to do? Then government will change your name of LLP into whatever name it want. At that time I will put the name Yallaya Pullaya LLP. Don't cry. Maryadaga I told you. Change within 3 months. You didn't change. Understood? If you don't change, I will not punish you because mistake is from my side. Therefore, I will not do any punishments on you. But at that moment, whatever name comes to me, best judgment, I will apply that name. ఆ టైంలో ఎల్లయ్య పుల్లయ్య లిమిటెడ్ I will put. Then you should not shout on me. Oh, why you put? I gave you chance for 3 months. 3 months you can suggest any name. You sat silent, therefore I gave a name to you. Understood the point? And issue for certificate of incorporation. If LLP is in default in complying with the directions of central government shall allot a new name to the LLP and give a certificate. That's it. Over. Everyone understood this? What are the sections that we are going to read? 13, 14, 15, 16, 17. Totally 25 sections are applicable for you randomly. Clear? Unless if you can complete 12 sections today, 12 will complete in the tomorrow's class. That's the point. We completed those basics, we completed features, we completed definitions, we completed basics, we completed these sections also we completed now. Remaining 1.5 hours, tomorrow's section we will complete and we will close. Then we will go to FEMA. Okay. But not yet done. Our work is not yet done for today. Another thing is there. What are the 2 sections, sir? 13 and 14. Okay. Sir, every company should have what office? Like that every LLP also must have a registered office. Registered office is a place of communication and notices. Simply care of address. Care of address of whom? Ante LLP. Next. A document which may be served on LLP or partner of LLP or designated partner of LLP. Tell me, I want to send a document to, loudly, to whom? Partner of LLP. I am not sending to Mr. A, Mr. B. I am sending in capacity as a partner. I am sending in capacity as a designated partner. Then you should send it by post. Send it by post. Or by registered post or by any other manner as may be prescribed at the registered office and any other address specifically declared by LLP. Simply tell me, I wanted to send a notice to whom? LLP, partner of LLP, designated partner of LLP. Where to send? Registered office you should send. How to send? Post, registered post or any other mode or any other mode or manner or any other mode or manner. Listening? Any other mode or manner, can I use Ejusdem Generis? Post, registered post, any other manner, etc. Can I use Ejusdem Generis? You cannot, because there is a legislative intention clearly, as may be prescribed, only those other manners. Today morning we read the concept. If there is a different intention for the lawmaker, any other, which any other, I am not asking people to interpret that. I only said as may be prescribed in the rule. Those only. Those any other. Not any other what you wanted to put there. If I don't use the word as may be prescribed, you can use Ejusdem Generis into any other manner. Understood now Ejusdem Generis interpretation? Okay. Next. LLP may change the place of registered office. Ante once registered office is established, permanent or temporary? Temporary. Whenever you wanted to change, you can change. But give a notice to the ROC about the change. If you contravene, penalty. Clear? Tell me. If a LLP is registered and incorporated, what will happen? Tell me. LLP once registered will become what corporate? Body corporate will have what features? Tell some corporate features. It can have common seal. It can have a right to sue and to be sued. It can acquire its own property. Correct? It will become what corporate? Body corporate. Answer is completed. With this, we completed part 1 of LLP. ఇప్పుడు చెప్పండియా, డిఫికల్టా ఈజీయా? Who will lose? 40 ki 40 you should get. Then how easy it is to get 60? Other laws are totally leaving and going to exam and you are expecting 40, 45. How you will get? Clear or not? And the easy chapters. Very, very easy if you read. And Companies Act also equally easy only. But at least their syllabus is voluminous. Yes, syllabus is short, crisp and clear. These are scoring areas. One day we can complete 30 marks portion, 25 marks portion, 25 marks portion complete, 20 marks portion completed. Means easily we can cover. So target is revision class la at least you should get 50 marks, damn sure. Remaining normally you will anyway read. That 50 marks should be guaranteed at least. Reasoning, that's why whenever revision classes are planned, the intense batches, the intention is very clear. We are not here to read and go. Whenever we say something, it should have an impact in your learning process. Same we have done in FM also or not? When you learn, something new should be learned. It should not be like, this formula, this answer. First, when you do something, you should have some clarity. It should be guaranteeing a success. Okay. So then anyway, first tell me, today's session, are you all having a full clarity? Yeah? Full one chapter completed. This chapter half completed. So tomorrow's session, another 15-20 marks I will cover. 40 marks, damn sure I will cover by tomorrow. How many marks, sir? Next day's session, another 15 to 20 marks I will cover. That's it. Just in 3 days, we can complete 60 marks of your portion. Main contents will be completed. Clear, everyone? Okay. Meet again in the tomorrow's class. Thank you. So students from the Chennai also please reply. Are you all having a clarity? Yeah. Thank you very much, everyone. Interpretation notes I will share in my Telegram group here. You can take from there. Full document I will send. LLP also. LLP already there. So very good morning. So last session, the first day of the revision class, we completed 2 very important chapters. One is the main concept is interpretation of statutes, and most important concept LLP. So now once LLP is completed, we'll be going into the next area called as FEMA. So once that is also completed, substantial portion of other laws being 30 marks will be completed with that. Okay. So in LLP, you can see on the screen. Shall we? Once LLP FEMA is also completed, then I will be going into the overview of a chapter called as General Clauses Act. Okay? General Clause Act is comparatively easy chapter when you compare with all the others. Reason is very simple. General Clauses Act is almost similar to that of interpretation of statutes. Listening. Only thing that is required is you should remember some definitions in General Clauses Act. So that's why I keep it at the last. First I will cover LLP, 1.5 hour time. Next we will be going into General Clauses Act, complete it fast, and finally I will touch the FEMA. Such that you will also have a clarity. So let us begin. What is the concept you are seeing on the screen? Incorporation of LLP, section 11 and section number 12. So let's see. What is the procedure for incorporating LLP? When I say procedure, just you need to remember the procedure. Nothing great, no great interpretations. See there. First, step number 1. Association of persons. And a group of persons will file a form. What is the form number? E form 1. With whom? ROC. For what purposes? Name reservation. If you remember yesterday, we already discussed about it. Directly you cannot incorporate company. Directly you cannot incorporate LLP. First stage, what we need to do? Reserve a name first. After reserving, the reserved name will be blocked for a period of 3 months. In the 3 months time, we need to incorporate the LLP. Correct or not? Same. Tell me. Who are they? Association of persons. Group of persons. Okay. They file with whom? ROC. What will they file? E form 1. Okay. For what purpose? Name reservation. Okay. Next. Please see there. Next one. Association of persons will file with whom? ROC for incorporation of LLP. They must do which business? Lawful business. Okay. 2 steps completed. Please read and tell. First one. What is the step 1? association of persons shall file a form E1 or form 1 to the ROC for the purpose of name reservation, and they are doing only what business? Lawful business. Next, that same association of person will file form E form 2 with ROC. That's called as incorporation document. Where you saw this incorporation document? Somewhere you might have heard about this in yesterday's class. Everyone, where you read this incorporation document concept in yesterday's class? How the designated partners has to be appointed. Names of the designated partners you have to mention in the incorporation document. Do you remember or not? Same. This is incorporation document. What is the format for the incorporation document? E form 2. I will ask one question, tell me. What is the incorporation document for companies? SPICE plus. Simplified pro forma for incorporating the companies electronically. SPICE plus is the incorporation document for companies. This is incorporation document for LLP. Okay. So tell me now, who is filing? Simply to tell, association of persons and group of persons will do 3 filings. Other 3 things they will do. Number 1, file E1, and they should do only lawful business, and they will file form E2. I mean E form 2. In all cases, with whom you will file? ROC, subscribing to the LLP. Next, take incorporation document, attach statement, statement given by a professional, for example, I will ask you a question, tell me. There are 4 doctors. Those doctors wanted to form an LLP. Correct? Business includes what? 4 things. TPSO. Trade, profession, service, occupation. Trade, profession, service, occupation. Doctor is a profession. Correct or not? 4 doctors wanted to start an LLP. Cannot? Can. 4 doctors started. Now you answer my question. Will doctor know about LLP Act? Answer. Then how will they file? Therefore, Taj Mahal is constructed by whom? Mason. Who brought the bricks, marble, everything attached? People, the workers have done. Okay? But technically name goes to whom? Likewise, for a company, Shah Jahan is the AOP, that association of person. But they will not do everything. They will get it done through others. Listening or not? Likewise, if you go to a doctor and tell, incorporate LLP, you don't know what is LLP first. Correct or not? Therefore, whenever incorporation is done, a professional will be there always in front. Okay? This person will involve in the formation of the LLP. Means complying with LLP Act, complying with LLP rules, incorporating an LLP, subscribing to the capital. All the legal compliances are taken care by whom? Professional. That professional should give a professional statement. What statement? Professional statement. That's why see there. Professional statement made by whom? CA, CMA, CS. That incorporation is made as per the Act, as per the rules, etc. Everyone understood the point? So now first part completed. Please read. First, easy steps here. Why you are bothered? Start. 4 steps we should complete the answer. Tell. Association of persons must file with the ROC E form 1 for the name reservation. They should do lawful business. They shall file E form 2 to the ROC for incorporation document. For incorporating what? LLP. That incorporation document should have attachment. What attachment? Professional statement. Made by whom? CA, CMA, CS. What professional declaration they will give? That incorporation of LLP is made as per LLP Act and LLP rules. That's it. Okay. Next. What is the next one? What is the form for incorporation document? E form 2. E form 2. What contents will be there? First, it shall be in form E form 2. Hey, it contains what? Company kit 3 documents. SPICE, MOA, AOA. Tell me, what are they? SPICE, MOA, AOA. LLP ki MOA ne incorporation document. LLP ki MOA itself is a incorporation document. MOA itself is, incorporation document itself is a AOA. There is no separate MOA, AOA. There is no separate MOA, AOA. MOA is what? Incorporation document. AOA completely is not incorporation document. For AOA, LLP agreement came. For AOA, LLP agreement is there. And mainly if a person asks you a question, where is MOA in LLP? LLP don't have MOA separately. LLP's ki what is MOA? Incorporation document MOA. Where is AOA? LLP agreement AOA. Understood or not everyone? Okay. Read. 1 second. Without reading this you tell. What are the clauses of memorandum in company? Name clause, situation clause, objects clause. Like that 6 clauses are there. Correct? Same ditto. Name of LLP, objects of LLP, registered office of LLP. Who are the partners? Who are the designated partners? Answer over. It's the simple concepts we are leaving and going to exam. Hardly this chart if you have, day before examination, how much time you will spend on this? 20 seconds. That's it. First, from the beginning when you see the answer, simple answer. Association person should apply in E form number 1 to ROC for name reservation. Association person should apply only for doing a lawful business. Association person should file a form E form 2 with ROC for incorporation. Listening, for incorporating LLP. 3 points over. And it should be attached with a statement given by CS, EMA, CS that the act and rules are properly complied with. Over. Incorporation document content, it should be in E form 2. It should contain the details as follows. Name, place of registered office, objects, names and addresses of partners, names and addresses of designated partners. That's it. Over. Listening? Next. What is the next one? Loudly, sir. Incorporation by registration. I will explain from the chart. After that, I will give time for you to read from the study material. Okay? See. First one. Incorporation by registration. Once the ROC is satisfied with the compliance of step 2 and step 3 and step 4. Step 2, that you are doing lawful business. Step 3, that you have filled in incorporation document. Step 4, professional has given a statement. If he is satisfied with the 2, 3, 4. Sir, 1 sir. 1 if you don't do, how can you come to step 2? Ante step 1 avasam leda sir. Is it really not required? Step 1 if not there, step 2 won't start. The moment step 2 started itself means what? Step 1 is already done. Separately I need not tell. Listening or not? A person came to CA final. I asked him, have you completed inter? How can I write final if I don't write inter? Understood or not? Like that. Step 1 is like intermediate. Step 2 is like a final. Step 2 when I am doing itself means what? Step 1 is already done. You need not tell again. Clear? Next. Consequences of contravention. Consequences of? Ante if in the incorporation document or in LLP agreement anywhere false information is given, imprisonment will be how many years here? 2 years. Fine minimum 10,000, maximum 5 lakh. Incorporation by registration. Incorporation by registration. Once ROC is satisfied with step 2, 3, 4, he shall register the incorporation document. Next, issue certificate of incorporation of LLP. Certificate of incorporation of LLP. On that certificate of incorporation, common seal of the LLP will be there, if any. Okay. Certificate of incorporation is said to be what evidence? Conclusive evidence. Means what? If a person asks, when this LLP came into existence, when this LLP came into existence, certificate of what date is there? That date is the formation of this LLP. Listening or not everyone? Answer sir. Up to here everyone understood what are the sections that we have completed here? Section number 11 and section number 12. I want you to read first section number 11. Next read section number 12. 2 minutes time. More than that, 1 extra minute also I am not ready to give. Start and complete. Section number 11, section number 12. Done? Completed? Yes, next. Did you find all the points clearly here? Yes, everyone? Yes, so, that's why I told you, whatever is required from the exam point of view, I kept in the form of the charts. Beyond this, questions will not come. If you can observe, all the core points of that particular concept were kept in the form of charts. Unnecessary contents, etc. I removed, trimmed, and I kept here. That's it. What are the 2 sections we completed now? 11, 12. Okay, next. Next, what are the next sections here? 55, 56, 57, 58, 59, 63, 64, 65 are the sections we are going to cover here now. Shall we start? That means you can understand all these are 1 mark, 2 marks questions. Okay? Let's complete a good set of sections. Please come to 55. See here. Conversion of LLP. Conversion of LLP. 55, 56, 57, 58. Okay? 59. Also 59 we can read. What are the sections we are going to cover now? 55, 56, 57, 58, 59. Look at the screen once. See here. Conversion procedure. Please observe the screen once. Important. Conversion procedure. Types of conversion and its governance. You know already that there are 3 types of conversions in 3 different schedules of LLP. Schedule 2, conversion of what into what? Firm into LLP. Schedule 3, private company into LLP. Schedule 4, unlisted public company into LLP. Firm to LLP governed by Schedule 2. private company to LLP governed by Schedule 3, unlisted public company to LLP governed by Schedule 4. Next one, legal procedure. What is the procedure for conversion? See, there are totally 3 important points, 1, 2 and 3. Observation required, please see the screen. You please tell me what is converted into what? Either firm getting converted into LLP, private company getting converted into LLP, or unlisted public company getting converted into, see there. ROC shall satisfy that schedules are properly complied with. First, to adopt the conversion, to say yes for the conversion, ROC first check whether you have complied with the schedules. Which schedule? 2, 3 and 4 depending on the situation. First, what you should comply with? Schedules. Then he will register the document and issue certificate of incorporation of LLP. Answer, in all the 3 cases, conversion is made from LLP, conversion is made to LLP. From firm, private company or unlisted public company. And the end result is what? Therefore, give certificate of incorporation of LLP. Number 1. Number 2, read. LLP shall inform the ROF or ROC. Super point. Listen. 3 conversions are there. What are the 3? First, let us discuss about firm. I am converting from dash to dash. Converting from dash to dash. Converting from the firm to LLP. Now doubt will come. Sir, I will file documents with ROC for conversion. LLP has to be created. Then what about the ROF, Register of Firms? You should also inform him that this firm is no more there. This has been converted into LLP. So your work is over. We are now going into ROC. LLP should inform ROF or ROC. Conversion is made from private company to LLP. Private company, who will govern? ROC. ROF. ROC. LLP ni? ROC. Therefore, in that case, one ROC to another ROC you should inform. Understood the point or not? LLP shall inform. Bad response, sir. Start again. LLP shall inform. What is the full form of ROF? Or ROC, Register of Companies. As the case may be. Within how many days? 15 days of registration as LLP. And at the moment you got converted into LLP, after conversion, within 15 days, inform whom? ROC or ROF, depending on the conversion case. I am converted from firm to LLP. What to do? After getting converted into LLP, inform whom? ROF. Okay, within how many days? 15 days. Very good. Third one. Dead easy concept. Yeah? Previously in the firm whom I am? Previously in the firm who I am? Partner. Now in LLP who I will be? Partner. In private company who I am? Shareholder. Now I will become partner. Public company who I am? Shareholder. Now I will become? Simple logic. How to tell? All the partners in the firm or all the shareholders of the company will now become partners of LLP. Answer completed. How many of you read this before? Very good. Super. Everyone, read these 3 points. Important. This time exam, do you know what is the important question? 42. 99% open the paper, you will find this question. We will read that separately. All important questions, a final touch. Okay? There are 6 expected questions for this exam. 6 I will cover at the last. Last means not revision last. Today in LLP, last I will cover those 6 aspects. From those 1 question will come this time. 2 questions will come on LLP. 1 6 marks question, 1 4 marks question. Listening, huh? 4 marks question I can't tell what will come. Easy questions only will come, but 6 marks, some difficult question will be tested. I will tell you what can be having a chance. Sorry, okay. Anyone, everyone understood all the cases are not clearly? Sum up and tell me. 55, 56, 57. We'll be talking about what? Conversion cases. What is of type 1 conversion? Firm to LLP. Type 2 conversion. Private company to LLP. Type 4 conversion. Schedule 4 conversion. Unlisted public company to LLP. Very good. Tell me the procedure. When ROC will say okay for conversion, comply with the schedules. Comply with the schedule. Then what he will do? Register the document and issue a certificate of incorporation of LLP. Over. Now, ROC, the work is completed. Now starts the work of ROF, ROC in the old one. Okay. You converted into LLP. You should inform whom? Answer. ROF or ROC, as the case may be, depending on the type of conversion you are taking. Within how many days? Okay. Partners of LLP, separately we need to appoint or automatic? Automatic. All the partners in the firm will become partners in LLP. All the shareholders in a private company will become. That's it. Same with the unlisted public company. Understood the point? Okay. What sections we completed? 55 to 50. Okay. Now listen. Next section is section number 59. What is the 59? Foreign LLP. Loudly. Dead easy. Listen carefully. What is foreign LLP? You already know the definition of foreign LLP. Tell me. Foreign LLP is an LLP incorporated outside India. India, what is there? Place of business in India. No doubt. Sir, foreign LLP incorporated outside India. Why Indian LLP Act will govern about it? Indian LLP Act, our LLP Act 2008, will not take care about your incorporation outside India. I am bothered about place of business in India. For that rules are made. And the answer is over. Procedure to establish the place of business is mentioned in the rules. Rules not applicable for exam. Listening? Next. Dissolution of LLP. Loudly everyone. What is the concept? Last attempt 4 marks question. Last attempt 4 marks question. Read. Types of dissolution. Read ya. What are the various types of dissolution? Voluntary dissolution, tribunal dissolution. Listen. Name lone clear. Voluntary means partners are voluntarily, they thought that let's not continue the business, close it. We call it as what? Voluntary. You have done some mistakes of frauds or creditors you are not paying the money. In such case, tribunal will ask you to wind up. What is a tribunal? Court. Okay? NCLT we call, National Company Law Tribunal. So that tribunal wanted you to wind up. Procedures. Procedures are specified in the rules. Rules are not applicable for your exam. Exam what they asked in the last attempt for 4 marks? This they asked. What is this? Grounds of winding up. Under what cases you can wind up? Okay? Important question. Last attempt already it came. Read. Step. LLP itself applied to winding up. This is called as what winding up? Voluntary winding up. Listening? Yesterday we discussed one concept. Number of partners can fall below 2. Chance is there? Because a death you can't stop. Na? Suddenly partner died. How can you stop the death? Impossible. So tell me, 2 partners became 1 partner. Will there be any problem? No. For how many months okay? 6 months okay. Within 6 months what you should do? Bring another partner into the LLP. If you could not bring within 6 months, what will happen? Who is personally liable? That one partner who is continuing the business is wholly responsible for the debts of the company during that period. Remember or not? Now listen carefully. If the number of partners are less than 2 for more than 6 months, unlimited liability, okay, you keep away. Tribunal also may ask you to close the LLP. Because LLP require minimum how many partners? Now how many are there? Then it is a sole proprietor concern. Why you are calling it LLP? Close it and start as an sole proprietor concern. That's why. Chance. May sections ivanni. Not shall. These are all may. Tribunal may wound up. Not shall. Listening or not? Next. Unable to pay the debt. Do you know what this is called as? Insolvency case. Which case here? Insolvency case. Next one. What is the next one? Against to sovereignty and integrity. Means India against you are doing the businesses. Okay? Against whom? Against country. Against the country. India is a sovereign. India is a sovereign state. India is a sovereign country. Na? For that, do you know what is sovereign? Sovereign means uniqueness, ultimate. Okay? Sir, I didn't understand. I will give you super duper examples. In India, certain things are there where only government should do those. Number one, currency printing. Number two, atomic research. Number three, defense. Number four, space. Number four, space. No country in the world will allow space research to be done by a private organization except USA. Elon Musk has done. Clear? And he has done better than NASA. Latest it happened, na? Yes or no? In the case of Sunita Williams. Such a great lady, dynamic lady, and such a dynamic Elon Musk type of person. When it is not even possible to NASA, he has done that. Reason? America always is favorable to the private organizations to enter into space research. But India inka anta dare cheyala. They are not doing. Listening or not? Because our people, if they leave, akkada kuda real estate modaladtaru. So therefore, government is not that much interested to give privatization of space research. I think it will not even do in the near time. Okay. America is ahead of all these things. We should appreciate for that. Okay, they are almost 40-50 years ahead of India in terms of space research. Not in all, in terms of space research, they are almost 60-70 years ahead of India. And what India will do in another 50 years, they have already done that in terms of space research. In terms of space research only. In various terms, India is ahead of them in certain areas. But in these terms, definitely they are 50-60 years ahead of all countries, if I have to tell. Okay, their concentration is more on that. Sir, okay. Now listen. Point number 4. If your LLP is formed to print currency notes, LLP is formed to do the defense research without permission of the government, those are all called as against to the sovereignty and integrity of India. Next. What is the next one? Statement of affairs. SOA means what? Statement of affairs. P&L balance sheet, yeah, statement of affairs means. Are you listening? Yes, Companies Act we call financial statements, correct? LLP we call statement of affairs. Understood? If you don't file it for not 1 year, not 2 years, not 3 years, 5 consecutive years you are not filing. Until you are a firm, your LLP is doing a business or not doing a business. Then why you are there? Close the firm. Next, last one. Just and equitable. Sir, what do you mean by just and equitable, sir? Any other ground other than the 5. Listening? Because lawmaker can assume 5 cases. Beyond this 5 also can come or not. Yes, whenever the word just and equitable comes, this means Ejusdem Generis. Are you understanding the point or not? Here, no alternative legal intention is there. You can include anything into this which is relatable to winding up. Listening. Tell me how many cases are there for winding up of LLP? 6. Tell me all the 6 grounds. LLP applied itself for winding up. Number of partners are less than 2 for more than 6 months. Unable to pay the debts and became insolvent. Against to the sovereignty and integrity. Not filed SOA for consecutive 5 years. Any other reason which is called as just and equitable. Do you know what it means by equitable? Equitable means fair. Just means justified. Any other justified and fair reason is there, wind up the LLP, close it. If you would have read this before, 4 marks happily you would have gotten. It's all about reading. First we have to read na study material. What sections we completed now? Tell the numbers. 55, 56, 57, 58, 59, 63, 64, 65. See here, I will show you the numbers. One second, see here. Winding up can be arbit tribunal. We read that point or not? LLP decides period of 6 months, number of partners reduced below 2, against to the sovereignty, integrity, not filing of the statement of accounts and solvency for consecutive 5 years, just and equitable. My charts book is ultimate solution because I can proudly tell I never went beyond study material. Unnecessary tail head I cut. Main body what is required to be written in exam I kept that. Understood or not? And if you remember just and equitable, remaining you can also write in exam. Just and equitable grounds or something. Just and equitable if you don't remember, over. Understood the point? So next, rules are given by the central government. So 63, 64 and 65. So everyone understood the point clearly? What are the sections we completed in this set? Please tell. 55, 56, 57, 58, 59, 63, 64, 65. 2 minutes time. Read the study material and complete it. Fast. Can you go to the next one? Shall we go to the next one? Next. Come to 26, 27, 28, 29, 30, 31, 22, 23, 24, 25. Okay? Or do one thing, 22 onwards we will start. 22, 23, 24, 25. Next, 26, 27, 28, 29, 30, 31. From what to what? 22 to 31. Totally how many sections are there? 10 sections, including 22. 22, 23, 24, 25, 26, 27, 28, 29, 30, 31. How many? 10. So 10 section set we have to complete. If you complete this, 99% of LLP Act will be over with that. Listening? Finally, there is an area called as a compromises, arrangements and amalgamation of LLP. Ade expected question for this attempt for 6 marks. This time, 99%
What question will come in exam? Undoubtedly, either 60 will come or 62 will come. Either 60 will come or 62 will come. 60 means 61 must be written with 60. So 60, 61, 62 lo one question will be there in exam. Which sections? 60, 61, 62 one question will be there. Doubt akkarla meeku exam paper when it is given etukkondi ekkadunna ee mooditu మీద question. Clear? Wherever question is there on these three sections, you search, it will be there, this attempt. 60, 61, 62 lo one question will be there. 22 to 31 lo one question will be there. Adi. And if you leave any of these, gone. That is the indirect meaning. Okay? If 10 sections or those 3 sections, 13 sections set if you leave, next attempt. So therefore that's the point. Shall we begin? So the core important areas of LLP actually starts now, from now. Please see the screen. I will begin with 22. See here. Charts material is more than enough. I will go by charts material. Fastly I will complete the concepts. See there. Eligibility to be a partner. Eligibility to be a partner. There are 2 ways of becoming a partner. Namely, number 1, subscriber to the incorporation document. Incorporation document ki subscriber means normally it will be done, or at the time of incorporation of LLP it will be done. Loudly sir everyone. Incorporation document, I will write your name as a partner. In that way you can become a partner. Second, LLP will get incorporated 5-10 years after. Through LLP agreement I will be admission of a partner. Admission of a? Tell me, what do you mean by admission of a partner? What do you mean by admission of a partner? No, shall I tell you? Admission of a partner concept will apply if a new person is entering into the partnership in a existing LLP. Example I will tell you. Shall we? For example, we 3 are starting an LLP, A, B, C. Listening, huh? We 3 are starting a LLP. Whom we 3 are? Normal partners are admission. Admission will not apply to us. The word admission will come only if LLP is already there. Asal LLP are not in existence. We are called as what? We 3 are called as what? We are called as subscribers to incorporation document. We are called as LLP got incorporated. We are called as partners. That's not admission or retirement. Simply we 3 are called as a founder partners. Which partner? Companies Act, same people will be called as a promoters. Called as what? In LLP we call as subscribers to incorporation document. STID. Remember, because your choice illa, you are having exam. STID means what? Subscribers to the incorporation document. Is it ringa? All subscribers to the incorporation document will become dash on incorporation of LLP. Answer. So tell me, what are the 2 ways of becoming a partner? Subscriber to the incorporation document or through an LLP agreement. Everyone understood 22 section or not? Next, come to 23. What is the 23? Relationship of the partners. Relationship of the partners. Okay. The mutual rights and duties of the partner and the LLP shall be as follows. Determining the mutual rights and liabilities by way of an LLP agreement. You will tell, I will ask. What is an LLP agreement? Oral or written? First tell that clarity. LLP agreement is a oral agreement, written agreement. Entered by whom? Between the partners and partners with LLP. Yesterday we discussed or not? Very good. I write LLP agreement. Whatever you have written will be applicable. If you don't write LLP agreement, Schedule 1 will apply. Do you remember? Answer over. Okay? How the mutual rights will be determined? By way of LLP agreement. In the absence of any LLP agreement, as per the first schedule. As per the... Okay, next. Changes in the rights and liabilities. Changes in the rights and... If there is any change in the mutual rights and liabilities, inform ROC. Inform whom? Very, very important. Pre-incorporation contract. Exam 3 marks ke expected area. Sir, what is a pre-incorporation concept? I will give you an example. For example, I wanted to start a company. I wanted to start a company, X Limited. Company. First understand for company, LLP easy to understand. I wanted to incorporate a company. Company incorporation, okay. But company once incorporated, it requires a registered office. It requires a... LLP also requires a registered office. Now you answer my question. LLP is a separate person or not a separate person? Company is a separate person or not a separate person? Kada? Company is a separate person, LLP is also a separate person. Correct? So tell me, building must be taken on rent. In whose name? My name, your name, company's name? Loudly. Company are not incorporated. In the name of company, how can you enter into agreements? By the time I am preparing MOA, AOA for company, company is already formed or not yet formed? Then how can you enter into agreements in the name of company when company are not there? Understood the point or not? Therefore, do you know what generally do? Even we will also do the same in practice. First, for example, these 3 people are starting a private company. These 3 people are starting a private company. Do you know what they will do first? Out of their money, they will first go and purchase one building or take a rent, pay advances, etc. Who will pay? Members will pay. Promoters will pay. Promoters will pay. This is called as a pre-incorporation contract. Enna contract ya? Company got incorporated. Company got? After company getting incorporated, now company is in existence or not, the all agreements what they entered, they will transfer in the name of the company. They will transfer in the name of, this is called as what agreement? Pre-incorporation contracts. Pre-incorporation, same ditto will apply also for LLP. That's what we are going to read now. Okay, shall we read? Other exam important, 2 marks question can come. Read. Any pre-incorporation contract entered by LLP or subscribers to incorporation document. Why not LLP? LLP not yet formed. Then how can LLP enter into agreement? Entered by whom? Subscribers to the incorporation document shall be settled by LLP if such agreement is consented by all the partners of LLP after incorporation. After incorporation, how many partners are there? These 3 partners will say, okay, that's it. Obligations of STID will become the obligations of LLP. Understood the point or not? That's the point here. This is one important thing which can come for 2 marks and 3 marks. A case study they can ask. First of all, you tell me 22, 23. Understood or not? What is 22? Eligibility to become a partner. Okay, next one. Relationship of partners. Read the third one. Cessation of partnership. Okay, that you need not read separately. I will tell you where to read. Section 5 I connected. I will tell you there. Directly read the next one. Registration of changes. Registration of. I will give you an example. Listen. Can a LLP change its name? Can LLP change its address of registered office? In LLP, can the partners change? 3 questions I asked you. Can LLP change its name from A LLP to B LLP? Can it change from Hyderabad to Chennai? Chennai to Bangalore? Bangalore to Vijayawada? It can change. So that means 2 things. Name can change, address also can change. Now tell me, A, B, C are partners. Okay? Next, they wanted to give their share to others. They wanted to leave. E, F, G wanted to come. Like this, partners can change or cannot change? Can change or cannot change? Happily they can change. That's what the point we are going to see. Please see here, registration of changes, 25. Read, type of changes. Changes in the name and address of the partner, changes in the partners itself. Okay, change in the name and address. Please read, partner should inform LLP within how many days? If the default is there, how much penalty? Next one, second branch. LLP should inform whom? Within how many days? 30 days. If there is any default, again penalty will be levied up to 10,000. Start again. Change in what? Name and address. Name and address of the partners is changed. Partner should inform LLP within. LLP should inform ROC within. Any default, penalty will be 10,000 rupees. Listening? Change in the partners itself. Okay? Either partner is admission or a partner take a exit. Okay? In that case, LLP should inform directly the ROC within how many days? That document, whatever you file, will be signed by designated partner and consent signed by incoming partner. If there is an admission. If there is a, sorry, here admission or exit or both are. Both, any case will be covered here. In case of exit, nothing is required. In case of admission, consent also should be signed. Default, again, penalty will be 10,000. I want every one of you to read 22, 23, 25. Leave 24. (22, 23, 25). Completed? Done? Can you go to the next one? Sir, all the important points only I kept here. Other points just you can read at the time of exam and write. The main content everyone understood clearly. Next, what are the 4 sections we completed now? 22, 23, 24, 25. 24 you will read later. 25 we completed. Next. Please come over to (26, 27, 28). Okay? Shall I begin? Yes, sir. Okay. First, listen carefully. I will explain first. After that, you can read. There is one concept in Contract Act. The name of the concept is Principal Agency Contract. You remember the concept? Know the concept at least? Principal Agency Concept. How many of you from foundation? Everyone almost, except one. All of you are from foundation only? Foundation, you have read concept in contract Act called a contract of agency. Have you read contract of agency? Sare. Contract of agency, two important persons are there. Who are they? Principal, agent. Sare. Forget about what is there in Contract Act. I will tell you the basics first. Principal is the owner. Agent is a servant. Agent will do the things on behalf of principal. Agent will do things on behalf of principal. Since principal cannot be present everywhere, he is not a Sri Narasimha Avataram to stay everywhere in the world. Therefore, what he will do, he will put his agents somewhere and get the business done. For example, I do my business in Hyderabad city, but I wanted to do my business also in Bangalore and Chennai. Personally, I can't go every day and do the business, correct or not? What will I do? I will appoint an agent on my behalf. But one catch point. Whatever agent does with the third party, listen to my words. Whatever agent does with the third party, who will be responsible? Principal is responsible. Sir, agent mistake by principal. Hala agent who appointed? That means a mistake is completely yours for choosing a wrong agent. Listening? Can minor become an agent? Yes. Minor can't be a principal. The contractor chadala. Minor can't become a principal. Minor can become an agent. If that minor agent does a mistake, principal can't even take action on that minor. So, buddha vadkondali. That's the logic of this concept. So, logic is very simple. The common sense should be there in the mind of principal. Correct or not? So, tell me, wrong agent chosen, mistake and obligation liability is completely whom? Except in one case. If, listen, after that you can read. If agent was given with a power, okay, within the ambit of that power, if agent does something wrong or right, principal is responsible. Agent crosses his boundaries, does something, then principal is not liable. Who is liable then? Sir, I will give an example. Principal can do textile business, agent also can do. Principal can sell, agent also can sell. Principal can buy in that locality some cloth, agent also can buy. Principal can give discount, agent also can give discount. Principal cannot do other business other than textile. But agent is doing textile plus pharma business. Now you tell me, agent does something which principal can do, which principal also cannot do. For that, who will be responsible? Agent is responsible. Clear? Textile business related. Which business? Textile business related. Agent does some mistake. Agent does some mistake. Now who is responsible? Principal is responsible. For the acts of whom? So, to sum up everything from the revision point of view, agent to principal relation, act of agent will become the act of, start again, act of dash will become the act of dash. Act of agent will become the act of, except in one case, if the agent does not have any authority to do that. Who has no authority? Agent. Agent has no authority to do that, because principal also don't have an authority. In that case, if agent does something, who is personally responsible? Agent will be personally liable for the acts. Understood? Or else, for all the acts of agent, who will be personally liable to the third party? That's what we are going to discuss in 26, 27 and 28. Clarity if you have, that much easy it is. Okay? So first point number 1. Every partner is a agent to LLP. LLP is an artificial person, natural person. It can do on its own, cannot do. It can do on its own, cannot do on its own. Cannot do on its own. It can do in its name, not on its own. And LLP hand selects will be there to go out and buy something. Who should buy? Partners. Who should sell? Partner. Everything. LLP is like a puppet. Tolubamma. It's like a puppet in the hands of partners. If you move, it will move. If you play, it will play. Clear or not? It's just a remote is in your hands. Car is there. Remote is not working. Then how the car will move? Our remote partners here. So tell me now. Point number 1. In case of LLP, LLP is a principal or agent? Principal. Who is the agent? Loudly. Ade 26. Clear everyone? Loudly. Tell me, what section 26 says? Every partner is a agent of LLP. Partner has done some nonsense. Okay, who will be responsible? Loudly. Wrong answer. It should be done only in respect to the business of LLP. With respect to the business. Personally at your home, if you do some nonsense, for that LLP will not take responsibility. Anything you do in relation to business, within your authority. For your acts, LLP is responsible. Understood? Read. Extent of liability of LLP. Are they important? Read. 1 minute. Start. LLP is not liable to third party for acts done by the partner who has no authority to act. And he has authority or no authority? Even then who has done? Further, who is not responsible? Next, continue. LLP is liable to a third party for the wrongful acts or omissions made by the partner which are within his authority. I think you can understand first two. Third one. Obligations of LLP are solely the obligation of LLP only, because LLP is a separate legal entity. My liabilities are my liabilities only. Understood? What is the next one? Extent of liability of partners of LLP. Okay. Read. No. Yes, read. A partner of LLP is not liable for obligations which are solely the obligations of LLP. Which are solely the obligations of? Sir, what is this, sir? Dead easy. LLP taken bank loan. LLP taken? Who should pay? Partners will pay, na? Those are solely the obligations of LLP only. Don't ask us. Clear? Read the first point again. Partner of LLP is not liable for obligations which are solely the obligations of LLP. Next. A partner is personally liable to LLP for his acts done wrongly or omission. So, just now you said he is not responsible. Now you said he is responsible. Inga paru. Read properly. Second point. This third party illa. LLP ke liable. Tell me. I am a partner. Within my authority, I can do certain things. I does that wrong. Who is responsible to third party? Loudly. But who is responsible to LLP? Partner. That's what he wanted to tell. Third party ki LLP is liable. But to LLP, who is liable? Third party slap the principal. Principal slap the agent. Understood the point or not? Third party can't slap the agent. That's what he wanted to tell. Third party ki no one is known. Third party only one person is known. Who is that? LLP. But LLP can take action against their agents or not. Next, last one. A partner is not personally liable for the wrongful acts or omissions done by other partner. Yeah. Sir, whatever mistake cheste, why you are blaming me? Yes, it is possible in case of partnership. In case of what? People will get doubt. Limited liability partnership is a partnership, na? Therefore, doubt will come. Like in partnership, if one partner does mistake, whether I am also responsible? No, not responsible. For that, this section came. Understood the point or not? What are the three sections we completed now? 26, 27, 28. Read 26, 27, 28 in your notes. Open study material and read, or read this. Completed? Understood the concept, everyone? Next, what is the next one? What is the next one? Liabilities of the partners, 29, 30 and 31. Next set of sections, 29, 30, 31. See here, we are having three sections again, 29, 30 and 31. Let's complete these three. Once we complete these three, we are done with 99% of the concept. Later, last three sections I said, 61, 62 and 63. Sorry, 60, 61 and 62, sorry. 63 already we completed. So 60, 61 and 62. Those are the sections you have to cover. Before even going into this, see these ones. Partner by holding out. 2 minutes I will complete. I don't want to stress this. Very easy. Reason I will tell you why. I am not putting so much efforts on this. Partner by holding out is also there in Partnership Act. Partner by holding out means pretending partner. Actually not a partner. Actually not a partner. For example, I am a manager or a cashier. I am a manager or a cashier working in LLP. Okay? I am a very close friend to the partners. Whenever people used to come, my partners used to tell that I am also a partner to them. Actually, I am a partner or not a partner? Some others are representing that you are a partner and I am silent. Means I am encouraging him to say that. Or I myself is representing to the outside world that I am a partner. Listening? Huh? Then other partners are silent. In both the cases, first case la others are saying that I am a partner, I am silent. Second case la I myself is telling that I am a partner, others are silent. In both the cases, silence is taken as an acceptance. Silence is taken as a... Now tell me, I am really a partner or not a partner? But I will be treated as a... No. I am treated as a partner for liabilities only. Just because of the reason that I am a partner, profit share will not come to me. Because my name is not there in LLP agreement. What you learned yesterday, every person to become a partner, his name must be there in? His name must be there in LLP agreement. Who is a partner? Define partner. Partner means a person who became a partner by LLP agreement. Now I became a partner by LLP agreement, representation. Then how can I be getting a share of profit? I don't get share of profit. I will get share in the liabilities. Not liabilities totally. Credit transactions only. Which transaction? So I don't have time to stretch this example. Fastly I will cover. Okay? Read. Two situations. Conditions attracting the section. Read. A person is representing himself as a partner. In fact, he is not. Or second, a person knowingly permits other to represent him as a partner. Either others are saying that I am a partner and I am allowing them. That's what he said, knowingly permit. Second, first case is what? Representing himself as a partner. But he is really a partner? No. Listening? Yes, in such case, that person will be treated as a... Not answering. That person will be treated as a partner to the full extent or not for the full extent? Then such a person is liable to any person who on faith of such representation gave credit to LLP. Who am I? Partner. Partner by holding out. A, B, C are partners. D is a manager. They are saying to everyone that I am a partner. Here my chest became Hussain Sagar. Abba, I also became a partner. Actually, I am not. Understood? So I thought that they are giving me a privilege. I don't know that they are throwing liability on my face. First, I am a fool. So I accepted. People really thought that I am a partner. Clear? So she is my friend. She thought that I am a partner in that firm. Because I used to tell her, I am a partner, I am a partner, I am a partner. She thought that really I am a partner. Believing in me, putting faith on me, she gave credit to the firm. They didn't pay. Now who is responsible? All are responsible, including me. Ayya, I am not a partner, agreement lo show my name. Those all things we don't know. To the open public, you are declaring that you are a partner. I believed in that. Gave credit to the firm. For that credit, you are also liable with the other partners. That's what he wanted to tell. All other liabilities don't get attracted. All other profits also won't come to the partner by holding out. Understood the concept or not? That's it. Understood? So this is the whole idea behind this concept here. Next. What is the next concept here? Unlimited liability in case of fraud. Now tell me, normally the name of the act itself is Limited Liability Partnership. And the liability of the partners is unlimited or limited? 99 cases limited. But one case unlimited. When if you do some nonsense. See there. When section gets attracted, read. When the acts of LLP are with an intent to defraud creditors or any person. Okay? LLP is doing fraud means LLP is artificial or natural. Can it do any fraud on itself? And who will do? Partners in the name of LLP are doing. Therefore, when the acts are done with a fraudulent purpose, consequences, read. Liability. Liability of the LLP and partners will become unlimited. Punishment, imprisonment, 5 years, not or, and fine. Minimum 50,000, maximum 5 lakh. Compensation to those suffered the loss. I told you, it is civil liability, the criminal liability. Yesterday only we discussed. What is civil? Compensation to the suffered persons is civil. Going inside the jail, criminal. That's it. Read the section. Okay? Completed those two sections. Next. See. Next one is whistleblowing, section number 31. Whistleblowing, section number 31. Simple concept, listen. LLP does fraud. LLP does fraud. Partners are doing some nonsense. Okay? One of the partner among the partners came out and helped the department. Gave all the data, information, frauds done. Everything he has given a leak. Okay, he leaked everything to the department. And here he has done favor to the LLP, favor to the partners, favor to the government. For that, that person who silently does this is called as a whistleblower. If you do the whistleblowing work as a compensation for the risk you have taken, I will either completely waive the liability on the partner. Normally partner has to pay the fine. Completely we will pay. Or at least reduce the punishment. And the answer over. More than this, protection will be given to him from the partners. Or else they will kill. Read. Court or tribunal may waive the penalty or reduce the penalty to any partner who have given information for conduct of investigation. Protection. What protection will be given? Discharge. And partnership firm lunch they cannot throw you. Next, dismiss, suspend, terminate. Simply to tell they can't take any action against you unless government will give a yes for that. Understood the point? That's it. With this, what we completed? Which section we completed? 29, 30, 31. Tell me, what are all the sections we completed now? 22, 23, 24, 25, 26, 27, 28, 29, 30, 31. All these sections it has been completed. So hardly this is a time taken for completing all these concepts in LLP. Up to here everyone had a clarity, yeah? So what completed now? LLP Act 99% of the contents are completed with this. Up to here everyone had a clarity, yeah? Done. We are left out with only one area called as 60, 61 and 62. Please come to the study material. 42 also. First let us complete 60, 61 and 62. Tell me, what are the three sections we are going to complete now? 60, 61 and 62. What is 60? See there and tell. Compromise, arrangement or reconstruction of an LLP. What is compromise, arrangement or reconstruction? See here. Listen first. Important. 60, 61, 62. 61 is a inseparable section. We should attach with 60 and read. There is no separate concept of 61. 61 gets attracted if 60 is there. So separate 61 they don't ask. Whenever you write 60, you must also write 61 attached to that. Clear everyone? Let us begin. What is the concept name? Compromise, arrangement or reconstruction of LLP. What is this concept? Compromise. The word compromise itself represents there is a dispute. Here dispute does not mean physical fight between people. Financial disputes are going on. Means what? Let me give some examples. LLP took loan from the banks. They are not paying back. LLP took short-term loans from the partners and others. They are not paying it back. LLP purchased goods on credit, but they are not returning back money. Like this, so many problems are going on inside the LLP. These are all disputes or not the disputes? Disputes, which kind of disputes these are? Financial disputes. Therefore, to tackle that financial disputes, we will enter into arrangement. We will enter into, bad response, we will enter into arrangement results in compromise. Arrangement results in compromise. Okay? One by one, let us see. Before that, I will give you one example. If you would have done the accountancy reconstruction area, which area? Reconstruction area. Accountancy reconstruction area if you have done, you will remember one concept. Internal reconstruction will be there. Creditors to forego 20% of their claim. Debenture holders to forego their interest. Are a compromise. My company financial position is very bad. I cannot pay you properly. Out of every 100 rupees, 35 rupees only I can pay. Please let us go into compromise. Compromise will be achieved through arrangements. That's the concept of compromise arrangement. Listening? Let's see. Read. First, compromise can be entered between whom and whom? LLP creditors LLP partners. Okay. Whenever you want a compromise or arrangement, you should apply to whom? Tribunal. Tribunal represents what? NCLT. Application will be made by LLP or creditor or partner. If it is in winding up, liquidator. Who's a liquidator? See here. You are a creditor. You sold me goods worth 5 crore. How much I should pay you? 5 crore. Correct or not? But I am unable to pay. Okay. As of now, I don't have cash. I am asking you to waive 20%. Waive 20%. 20% of 5 crore? 1 crore. And I am requesting you to waive how much? 1 crore rupees I am asking you to waive up. Correct or not? So tell me, I am asking to waive how much? 20% of the due I wanted to waive. Up to here, if you are clear, I can go into the next one. Now listen. Before waiving 20%, whom should I ask? You are a creditor. 5 crore I have to pay. LLP has to pay. But LLP is not in a position to pay. Okay? I wanted to get relief of 20% being 1 crore. I wanted to pay only 4 crore. Before doing this, whose permission I should take? Answer. To whom I am doing injustice? You should ask only them. That's why 1 creditor, 2 creditors means okay. If there are 40, 50 creditors are there in the company and in the LLP, you can't ask one by one basis. Therefore, we will conduct a meeting. What we will conduct a? Loudly. Maximum number of partners in LLP. Limiter, no limiter? Loudly. I wanted to enter into compromise with the partners. There are totally 5,000 partners. With the 5,000 partners, how will you enter into one by one contract? Therefore, again, we will conduct a meeting. Therefore, whenever you wanted to enter into a compromise or arrangement, the first thing is apply to whom? I will tell you, repeat at least. Application made by LLP, creditor, partners. If it is in winding up, by liquidator. Start again. Who will make application? LLP, partners, creditors. If it is in liquidation, liquidator. Will make an application to whom? Tribunal. NCLT. Asking for what? Compromise or arrangement. But tribunal also cannot do anything. Tribunal will tell, conduct the meeting of. You are not answering. Conduct the meeting of. If the compromise is with the creditor, creditor. If the compromise is with the members, members. Tribunal on an application of LLP, creditor, partner or liquidator, order meeting of creditors, meeting of partners. So how the meeting should be held? Tribunal orders. Do you know what does it mean? General meetings chapter do not work. 21 clear days are nonsense. Everything does not apply here. Tribunal is ordering. Tribunal will tell when to conduct, how to conduct. Everything tribunal only will tell. No influence of company on that. Understood? Done. Next. What is conducted? Loudly. Meeting of whom and whom? Creditors and partners. Now we have to obtain their consent for that compromise or not. Very, 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 very important exam question. See, if a majority representing 3/4 in value of creditors or partners at the meeting agree to any compromise or arrangement, the compromise shall, if sanctioned by tribunal, bind all the creditors and partners as the case may be, and also on LLP, and in case of liquidation, through the liquidator. So simply, who should approve? Listen. Creditor, partner. Majority creditor holding not less than 75% in value. Same. Majority of partners holding not less than 75% of value. Sir, what is this? I didn't understand. See. Shall we? There are so many people sitting in the class. Let's say For example, let us say 100 people are there. How many are there here? 100 people are attending the meeting. 100 people are attending the, all of your partners. All of your. For example, her share in the firm is 10%. Her share in the firm is 5%. Your share in the firm is 25%. How much is your share? 10, 5, 25, 40% total. Correct or not? He is holding 10. Remaining all people are holding 5. How much? 5. 5, 5, 5, 5, 5. Let us say for example. Okay? 25. 40 plus 25? 65. Loudly. 65. He is holding 10. 75. He is holding 5. 80. First up to here, understood? Listen. Meeting started. 100 partners came. 100 partners came. 100 partners, 100 partners need not say yes, sir. Majority should say yes, sir. Majority means more than half. Majority means? More than? For example, 100 are there. What is the half of 100? Loudly. 50. 50, more than 50. More than 50 is a majority. And 100 la majority will be 51. 51 heads should say yes, sir. And that 51 heads should hold 75% of the capital held by all 100. Understood the point or not? And here I should satisfy one condition or two conditions. What are the two conditions? Majority in number, 75% in value. Understood? Same with the creditor, same with the partners. Once they said yes, then tribunal will also sanction. Once the tribunal also sanction, it will be binding on the LLP and creditors, partners, etc. Understood the point or not, everyone? Okay. This point, keep it on hold, not at all required. First see this. An order of tribunal under subsection 2 shall be filed with the registrar within how many days? 30 days. Simply, tribunal give a sanction order. File it with the ROC within 30 days. This is a penalty, just read and leave. Next. The tribunal may at any time after an application has been made to it under this section stay the commencement or continuation of any suit proceeding against LLP on such terms until the application is finally disposed of. During the compromise going on, intentionally some people will file court cases against the LLP. All those court cases which are coming during the compromise period will be stayed. Stay order will be there. What will be there? Yeah? Stay order. No one can file a complaint against me till the compromise is completed. Till the compromise is completed. Okay. That's it. Read this concept clearly. Except this middle point, read all the remaining points, complete it fast. Have you understood the compromise concept? Answer. But now I will ask one question, try to answer. Compromise ki who applied? Either LLP or creditors or someone might have applied, correct? When we will go for compromise, when our financial position is good or bad? Again this point. No order sanctioning compromise shall be made by tribunal. And tribunal will not sanction that unless tribunal is satisfied that LLP or any other person by whom application has been made disclosed by affidavit all the material facts of LLP, the latest financial position and pending investigation cases. Means three things you need to, for example, I am a partner, I am asking for compromise. I need to give an affidavit containing three details. What are the three details? Full material facts about your LLP. Second one, give your financial position. When I see that financial position, I should understand that your financial position is good or bad, such that it will give a motivation for me to sanction the scheme. Your financial position is super good. Why will I give compromise chance to you? Understood the point or not? That's the missing point here. Okay. So we are done with entire concept. Okay. Now tell me. In the section what we read, we took permission of the creditors, we took the permission of the partners. And we are now going for a compromise. We are now going for a... What is the guarantee that really we will pay that 80% balance? Tribunal said, okay, go for compromise. Tribunal will go left side, I will go right side. Listening? After that, I will not pay to the creditors properly. Actually, I should pay her how much? 5 crore. Already she gave me how much waiver? 20%, 1 crore. And the balance how much I should pay? What is the guarantee that I will really pay that 4 crore to her? Therefore, tribunal is not a fool. They know about Indians very clearly. Therefore, what they said, justify, sanction the scheme. Don't think that I am going and moving on a other direction. I will still supervise you. Supervise whom? LLP. So, tribunal, where tribunal makes an order sanctioning it, it shall have power to supervise the carrying out of compromise. Still, I will be there. Next, may, at the time of making such order, give such directions in regard to any matter or make such modifications which are considered necessary. Means, whenever required, I will make some modifications also. Next, if tribunal is not doing it properly, it can make an order for winding up. That's it. Nothing great in this particular section. I don't want to waste time. Overall idea everyone understood or not? Later you can study. Simply three things. It can supervise, it can modify, it can pass orders of winding up. Who? That's it. Final touch. What is the next one? Amalgamation of LLPs. Amalgamation of? You will tell, I will listen. At the time of amalgamation, two companies will be there. Company amalgamation. Selling company, purchasing company. Correct? Purchasing company books, 3 entries will come. Popular 3 entries. You will tell all the 3 entries to me now. Educate me about accountancy. Theriyadu. Business purchase account debtor to liquidator of selling company. Second entry. Transfer of assets, transfer of liability. Balance can be either a goodwill or a capital reserve. Next, number 3. Everything I am telling, what you will tell? Liquidator of selling company account debtor to purchase consideration, equity shares, preference shares, cash or something is there. All the 3 accounting entries, I told you, you are just nodding head and saying yes. Tell me, what are the 3 entries? Business purchase account debtor to liquidator of selling company. Correct or not? Sir, one second. Whenever amalgamation is going on, amalgamation is like a corporate marriage. Liquidator is a person who will come at the time of death. Correct or not? Why at the time of an auspicious occasion like marriage, person who should come at the funeral, he is coming? You should get the doubt, na? Listen. Companies cannot go for merger when they are going concern. When they cannot go on merger. Merger is possible only when the going concern is lost. Going concern is lost. Therefore, do you know what they will do? I am talking about company. Same applicable for LLP. Finally, we will see. A Limited, B Limited, two companies are there. What are the companies? A Limited, B Limited. What are they? Two companies. B Limited wanted to merge with A Limited. B Limited cannot merge with A Limited directly. First, B Limited assets should be transferred to A. Liabilities will be transferred to B. Liabilities will be transferred to B. Now what is there in B Limited? B Limited assets are transferred to A. B Limited liabilities are transferred to A. What is there in B Limited? What is there? Nothing is there. Over. Correct or not? Now you can merge B with A. Clear or not? Until when they are going concerns, you cannot. When they are going concerns, you cannot. Simple example, it is like a train. Engine key, through a coupling you will attach the compartment. When you will do that? When they are not in running stage. Correct or not? You should first stop and then start the amalgamation. You can merge a compartment to the engine when they are going concern, they are stopped. Same even with the companies also. When they are running their operations, you cannot go on merger. First what you should do at the time of merger, stop the operation. To stop that operations, liquidator will come. Do you understand or not? Therefore, amalgamation time la winding up will not happen. Dissolution will happen. What will happen? Loudly. Sir, I will ask a question, answer. At the time of amalgamation, who will amalgamate? Who will amalgamate? Two companies can get amalgamated or one company can absorb another company. Correct? In our example here, companies are partnership, LLPs are. So here we are going to see amalgamation of two or more LLPs. Two or more LLPs. Correct? Now tell me, what will be transferred from one company to another company? Properties, assets and liabilities. Loudly. Property, assets and liabilities are transferred from one LLP to another LLP. Winding up a dissolution. Loudly. 3 accounting entries you remember? What is the first accounting entry? Business purchase account data to liquidator of sell income. Liquidator will come for winding up a dissolution. Loudly. Dissolution without winding up. Number 2. What? Second entry. Transfer. What will be transferred? Property, assets and liabilities of one company are transferred to another company. Over. Correct? Lastly, payment of purchase consideration. Payment of? Tell me, purchase consideration will be paid in the form of shares, debentures, cash. Correct? Here we are dealing about company LLP. LLP shares or debentures will not be there. They will distribute in the form of capital and cash. Correct? Yes, shall I tell you one point? We completed. See there. Compromise or arrangement has been proposed between LLP or LLPs or to amalgamate two or more LLPs. Listening? And it can be either absorption or a new formation. Anything. Under the scheme, whole or part of property liabilities of one LLP, which will be called as a transferor, or transferred to another LLP, which is called as a transferee. Next. Transfer to the transferee company, whole or part of undertaking. Continuation of legal proceedings. Dissolution without winding up. Dissolution without winding up. If any partners of LLP said no for this amalgamation, throw them outside the firm by paying them money. That's called as dissenting shareholders should be paid. A provision to be made for the persons who dissent from the compromise. Dissent is an opposite for assent. Meeting will be conducted. How many partners should say yes? 100% majority holding 75. And balance are called as accepting or not accepting. For them pay cash and throw them out. Clear? Any other consequential orders? Any other consequential orders? Those are the important points you need to remember here. Other things are only just a formality. Exam this time, this is expected. Okay? Next, I am coming to last section of this chapter, 42. Please come to 42. Mark it important, exam chance. What is the name? assignment and transfer of partnership rights. Means, can a partner transfer his rights of a partnership to some other person? Sir, simple logic, I will tell you. I am a partner in a LLP. My share is 10%. My share is? 10%. What I did is, I have taken loan from a bank, not firm. I personally have taken loan from bank. I kept my partnership share as a security to the bank. Means what? If I don't pay the loan, you can collect that money from my partnership. Can I do like that? Yes. See there. Rights of a partner to the share of profits and losses of LLP and receive distributions in accordance with LLP are transferable. Simply, profits and losses share, distribution of assets, both can be transferable, either wholly or in part. The transfer of any right by any partner does not cause disassociation of partner, because LLP agreement still my name is there as a partner or not. I am transferring partnership, I am transferring share of profits. Share of profits are transferred. I am not leaving the firm. Listening or not? Next. The transfer of right pursuant to the section does not itself entitle the transferee. Simple. Reverse. Tell me. I transferred my share of profits to the banker. Now I am still a partner. Discontinued. Still a partner. Who is she? Banker. Banker will become a partner. That's what they are telling. Transferee. And she is a transferee. I am a transferor. Transferee does not itself entitle to participate in the management or conduct of the activities. If I don't pay money to the bank, bank has a right to collect money from the LLP. Anteni right. You are not a partner, I am not disassociating as a partner. Understood the point or not? 90% this question will come in examination this time. With this, 100% LLP Act is also completed. Okay? That's it. Yeah. First of all, everyone tell me, are you all confident with the chapter LLP Act? So let us start with the revision of next other law called as General Clauses Act 1897. So see here, name of this particular act is General Clauses Act. What is the name of the act? General Clauses Act. This is not the first time that it came. 1868 it came for the first time. Later it came again in the year 1887. Finally, amended one released in 1897. This General Clauses Act will be giving out how to interpret general interpretations. What do you mean by a general interpretation? Shall we? Yes, interpretation of various words which are used in any of the central act or a central regulation. I will give you an example to understand. Okay? This particular act, General Clauses Act, I will do revision on a overall basis. After that, just you read and complete it. Listening. Like in the other chapters, let us not go in depth and spend time. Easy concept. That's why on a overall outset, what is the logic behind this particular chapter, I will discuss in max 45 minutes. I will complete. Thereafter, you shall just read the concept and understand, do the past exam questions and write the exams. That's more than enough for this chapter, because this chapter weightage will be 6 marks in exam, 6 marks to 8 marks. Because FEMA comes for 12, okay? Next interpretation will come for around 12 to 13. This will be given weightage of around 6 to 8 marks in exam. So I am not going to give that much importance like the other chapters for this. First question number 1. Listen. What is the logic behind this chapter called as a General Clauses Act? Logic is very simple. General words are interpreted in this act. Sir, what are general words? Of, from, how to interpret, all these things we are going to see here. If any definition or if any term, repeat, if any definition or a term is not defined in any act, is not defined in any, but if it is defined in General Clauses Act, that act can import to the definition of General Clauses Act. For example, person definition. Which definition? Person definition. Tell me, what is define a person? Define a person. Define a person. Person means a person includes a. Person includes individual, HF, like that you will write, correct or not? Income Tax Act person definition is defined or not defined? Defined. Defined, not defined? Defined already. Which definition? Person definition is defined already. Where? In Income Tax Act. Companies Act person definition is not defined. Defined or not defined? Then what do you mean by person? Defined in General Clauses Act. So, in any central act means a law made in the parliament. Law made in the parliament. Now parliament is there after 1950. But 1947 and 1950 between, Constituent Assembly is there in India. What is there? 1950 Constitution came, Republic Day came, Supreme Court is there, Parliament formed. All this happened in which year? 1950. India became independent in the year 1947. Between 1947 and 1950, where the law is passed, temporary parliament is there. That's called as a Constituent Assembly. Which assembly? Listen. Object of GCA. Shorten the language of Central Act. What do you mean by shorten the language? Avoiding repetition. For example, Companies Act person not defined. SCRA Act person not defined. SEBI Act person not defined. In all these acts, person means what? Person defined in General Clauses Act. Such that they can shorten the language. They need not define again and again. Listening or not, everyone? Number one. To provide as far as possible uniformity of expression in Central Act. Tell me, Companies Act la 1 person, LLP la 1 person, okay, SEBI ki 1 person, SCRA la 1 person, like that it's not there. Uniform. Wherever the act you read, person definition means person as defined in general clauses. So first one, shortening the language. Second one, uniformity of expression. Next. State explicitly certain convenient rules of construction and interpretation of Central Act. They will also discuss about interpretation and construction. Interpretation and construction. Of which act? Central Act. State Acts ki General Clauses Act does not apply. Understood the point? Sir, what is a state act? Act applicable only for a particular state. Like state GST. Like a state GST. For them, General Clauses Act you cannot apply. General Clauses Act can be applied only for what? Central Acts and regulations. That's it. These are the main 3 points. Next. Application of General Clauses Act. To whom you can apply GCA? First one, acts made in the Parliament. Acts made between 1947 and 1950, also called as a Constituent Assembly, also called as a Dominion Legislature. Next, before 1947, Act passed before commencement of Constitution by Governor General or by Governor General acting in legislative capacity. Simply to tell, to whom the General Clauses Act will apply? Acts made in Indian Parliament, acts made in Dominion Legislature. Next, acts passed before the commencement of Constitution by the Governor. Read the concepts up to here. I want you to read 2 things. Number 1, preamble of General Clauses Act and application of General Clauses Act. Fast. I'm not going to put a lot of time on this chapter, 45 minutes to 1 hour max. So please, read it fast. Shall we? Next one. Next one. Come directly to some basic understanding of legislation. Basic understanding of legislation. First, yesterday when we are reading about the interpretation of statutes, when I completed everything in interpretation, some points I left for you to read. Preamble, definitions, same again here also. What is a preamble? What is a definition? Means and includes, shall, may. I think we covered this or not? Shall, may, all this. Okay? Write down here itself. Refer. That's it. Don't read General Clauses Act. And shall I tell you another point? As it is, same is there in interpretation of statutes also. That's why I said GCA you need not separately read again. If you complete interpretation, you will complete lot of things. Come directly to definitions under section 3 of GCA. From here, real subject of General Clauses Act will start. Shall I continue? Okay. What is the first one? Act. Listen, Act here represents not Companies Act la Act, General Clauses Act la Act, actions la Act, verb, not a noun. For example, Criminal Act, in that Act, Civil Act, in that Act, Wrongful Act, in that Act. Understood the point or not? Whenever we say, read what it is. Whenever I say wrongful act, act means doing something. Act means whenever I say wrongful act includes wrongful omissions also. Simply to tell, doing bad is wrong, not doing good is also wrong. Understood the point or not? Tell me what I said. Doing bad is a wrong. Not doing the good is also a wrong. Means what is the logic here? Doing bad is an act of doing wrong. Not doing the good is omitting to do good. That's what the definition wanted to tell. See, act used with reference to offense or civil wrong shall include series of acts. Act represents acts also. Next, continue. Words which refer to the acts done extend also to the illegal omissions. Act does not mean only doing something. Act also includes not doing good thing. Next. Continue. An act required to be done cannot necessarily mean a positive act only and may also include the acts which one is precluded from doing from a decree. This definition is based on section number 32 and 33 of Indian Penal Code and applied to the civil wrongs as well as crime. Act includes illegal omissions as well, but it does not include omission which is not illegal. Simply to tell, an act of civil wrong, an act of criminal mistake also includes a omission to do the thing. Listening? In simple language, rather than remembering all these, I will just give you an example. Okay? See, act always includes also what? Act always includes also what? Act in reference to offense or a civil wrong includes also what? Illegal omission. When I say, listening? Now answer. If a person is hitting another person, a person has given a blow on the face of a person. When I say blow, it is also applicable for plural. Listening or not? One time only you should hit, then only section will get attracted. No. Whenever I say this act is offensive, acts multiple also is offensive. Listening? Acts multiple is also offensive. Clear? See, in the illustration of section 36 of Indian Penal Code, the act by which A causes Z's death consists of series of acts, namely the blow given to beating him, series of illegal omissions, namely wrongfully neglecting or refusing to supply him with the food at proper times. Means hitting a person is an act of wrong. Not giving him food and medication is a illegal omission. Is a illegal omission. There are two things in that. Number one, act of wrong. Second one, illegal omissions. So in simple language, you tell me in one line. Exam law, all these examples are not required. Mainly one line answer you have to write for 2 marks. Tell me, what do you mean by act in case of General Clauses Act? Act in relation to offense or a civil wrong includes series of acts and also includes illegal omissions and also includes next. What is the next one? Affidavit. Listen first. What do you mean by affidavit? Shall we? What do you mean by affidavit? Affidavit means self-declaration. Loudly. Affidavit means generally you should go to the court. Promise on the book and you should tell that you are telling all the right. Court la. You have to promise and tell that you are giving all the true statements. Correct or not? Instead of doing all that, that concept of going to the court and putting a promise is called as an oath. Also called as a swear. Also called as a, instead of going to the court, promising before judge, taking oath or a swear, alternative is called as what? Affidavit. See, affidavit, continue. Shall include affirmation, means confirmation, and declaration in case of persons by law instead of swearing. Swearing will happen where? Court. Affidavits are substitute to going to the court. Listening everyone? Done. There are 2 points derived from the definition. Affirmation and declaration and doing that instead of swearing. That's it. These are all the points. Central Act. Central Act. Act of Dominion legislature or Indian legislature passed before the Constitution. An act made before the commencement of Governor General. Already just we read that point or not? Done. Central government definition not required now. Come directly to the commencement. Come directly to the commencement. Asal, do you know what questions will come in General Clauses Act? Definitions. Every attempt, 1 or 2 definitions will come for 4 to 5 marks. Listening? Remaining entire chapter will come for 3 marks. And what is the important area in GCA? Definition say important. So I am going to cover that now. Clear? Any attempt you take, definitions will come for 4 to 5 marks. Coming A, 6-7 marks. In that 6 marks, definitions will come for 4 marks. So be careful. Start. What is the next one? From here, please show some urgency in understanding. Once completed, I will leave you. Because the main area I wanted to cover in the revision. Listening, remaining concepts I can put also on the YouTube channel. Just you can refer in 1 hour and complete. Main aspects I wanted to cover face to face. Okay, see there. What is the concept there? Commencement. What commencement, sir? Listen. I asked you this way. From when Companies Act came, which date you will tell us commencement? Written data, Parliament approval, President approval, official gazette notification. Which date you will tell that commencement date? For that this section came. Okay? Read. Start. Commencement used with reference to any act or regulation shall mean the day on which regulation, act or regulation comes into force. Force means application. Continue. Coming into force or entry into force refers to the process by which legislation, regulation, treaties or other things have legal force and effect. Very, 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 very important is the next one. A law cannot be said to be in force unless it is brought into operation by legislative enactment or exercise of authority by delegate empowered to bring into operation. The theory of a statute being in operation in a constitutional sense, though it is not in fact in operation, has no validity. 1 minute time I will give. Read it. I will explain what does it mean. Okay, so tell me, when an act will be said to be in commenced, the date on which it actually comes into force. When the act is said to be coming into force, law, regulations, everything should come into actual force. For example, today my act has obtained constitutional validity. My act has obtained constitution, and constitution has given its approval for my act. Listening, that day is not the day of commencement. Commencement does not mean constitutional sense. It should be in fact in operation. Ante really that act is there? No sir, constitution has given approval, but yet to come into operation. Then don't tell that act is commenced. Act is said to be commenced only if act is coming into commencement only if factually it should come into operation, not just in constitutional sense. Understood? Next, let's not waste time more on this. Next, what is the next definition? Document. See, directly you can read the diagram here. Document means a document includes a. Whenever the section use the word includes, it means these are all examples only. So many things are there. These are some examples given. Only these are, also these are. You are not responding very badly. These are also included, only included. Means is used, only those. Includes is used, also those. So tell me, also means? Also include. Only means. Listening, restricted means. Liberal includes. Here this is includes or means? Tell me, document include what? Any matter written. First, document means written, expressed or described upon any substance. Any substance means it can be on a paper or it can be on a computer resource somewhere else. Letters, figures or combination which is intended to be used for the purpose of recording that matter. So tell me, what is a document? Document is any matter written, expressed or described on any substance. Next, what it contains? Letters, figures or combination of letters and figures. Listening. Next, what is the purpose of document? To use it. To use it. Always whenever you write something in a document, what is available? Record is available. Understood the point? That's it. What is the next one? Enactment. Sir, what is enactment? Enactment shall include a regulation and any regulation of Bengal before independent. Bengal regulation, Madras or Bombay Code, and shall also include any provision contained in any act or any regulation. Okay, that's it. These are all old ones, not just required. Just read up to here and leave. Tell me, what are the types of enactment? Enactment shall include regulation, normal regulations made today. Another 3 old regulations. Regulations of Bengal, Madras or Bombay Code. Next. What is the next one? You will tell, I will listen. Generally, financial year starts on which date? 1st of April. Ending on what? So, 1st day of April it will begin and ending on the 31st March. We call it as what calendar? British calendar. Okay. Calendar year starts on January, ends on December. Next. What is the next one? Good faith. Come to the definition of good faith. Okay. Sir, what do you mean by good faith? See here. Anything which is done in innocence, honesty, without intention to cheat others and without knowing about the wrong done is called as a good faith. Sir, I didn't understand. I will explain you in a super way. Listen. Let us understand this way. I stole goods belonging to her and sold to her. Sale of goods act. I stolen goods belonging to A, taken the goods, sold to her. She don't know anything about what has happened. She believed that It is a normal sale and she purchased it. She is called as buyer in good faith. She is called as buyer in. Act was done in negligence or not in negligence? She has done act in negligence or not in negligence? Arey, don't think like a fool, yeah. I will ask one question, tell me. You go out, okay? You wanted to buy a pen. Buy a pen. You will go to a stationery shop. You will ask him, Anna, please give me that pen. How much? He said 20 rupees. You paid 20, take the pen and come out, correct? This is what you will do, yes or no? How many of you will ask, sir, Anna, really are you the owner of this pen? What is the proof that you bought this pen? What is the proof that you did not stole this pen? How many of you asked in your life? Do you know why you will not ask? Sale of goods act, one concept is there, implied condition and warranty. One of the first implied condition is duty to have a ownership of the goods. Clear or not? And the first assumption of every sale contract is buyer assume that seller is the owner of the goods. Is an assumption. On that assumption, anyone will do the work, correct or not? I will go and buy an iPad. I will ask the person, show me that you bought this. You did not steal from some other person. Implied. Understood? Same. Now tell me, who is she? First, A, who is she? Owner of the goods. Illegal possession. And I sold to her. She believing that I am the true owner, she bought it. Now she is negligent, good faith. Answer. Good faith. Because she acted negligently or not acted negligently? Not acted negligently. Second, she know about that I stolen the goods or don't know? That honesty, innocence, all these things makes good faith. Understood the point clearly? And does she know about the irregularity or not knowing? So please read. What is a good faith? A thing shall be deemed to be in good faith where it is in fact done honestly, whether it is done negligently or not. Negligence at least okay, but it should be done honestly. I had no intention to cheat anyone, and she don't know about what has happened. Listening? Next, read. The question of good faith under General Clause Act is one of a fact, depending on the facts of the case. Continue. It is to determine with reference to the facts and circumstances of each and every case. Thus, anything done with due care, repeat, anything done with due care, attention, which is not malified. Malified means good, not bad intention. Malified or not malified? Malified opposite is bona fide. Bona fide means good intention. Malified means bad intention. Have you heard an English word malnutrition? And mal means bad. Malpractices, mal means bad. Fide means intention, mal means bad, bad intention. Not with a bad intention. Listening, huh? Three things make good faith. Due care, attention, no malified intention. Listening, huh? Not malified. Is presumed to be in good faith. That's it. Everyone understood the point clearly, huh? What is good faith under income tax is not good faith under Companies Act. So from act to act, good faith concept also will change. Clear, huh? That's it. Examples and all those can you read later. Main content I will tell and I will complete GCA very fastly. Because most of the time this is linked to interpretation of statutes, which I have already completed. What is the next one? You will tell ya. Government means state or central or both? Ade answer, read. Start. Government or government shall include both central government and state government. Hence, wherever the word government is used, it will include central government and state government both. The object of this definition is to make clear that the word government frequently used as a convenient abbreviation may be construed according to the context in two senses. Simply, at the end what he wanted to tell, any act in India, the word government comes. What does it mean? Central government and state government both. That's it. Next. What is the next definition? Government securities. Okay, read. Government securities shall mean securities of, sir, government means state or central. Government securities means Securities issued by central government or state government or both. Okay? Government securities shall mean securities of the central government or state government, but in any act or regulation made before the commencement of government, and shall not include securities of government of any part B state. Okay? That part B state concept is not applicable for us for exam. So just remember up to here. Listening. Next. What is the next one? Mark it important. This attempt ki chance is there. Immovable property. I am doing a super quick revision of this particular area. Later at home, spend 1.5 hour time and read the remaining concepts and complete. Listening, regarding the General Clauses Act, one video again I will put on YouTube covering all the other concepts. In face to face, I wanted to cover all the important ones first. Anyway, full LLP completed, full interpretation of statutes completed, main concepts of GCA completed, I will complete full FEMA also. So 40 marks, 3 marks only I am asking you to study. And that also I will put on YouTube, 1 hour video I will put on the remaining parts. Main concepts let me cover here. Okay? Read. What is the concept here? What is immovable property? Immovable property include land. Not only land, benefit arising out of land. Land is a immovable property. Crop came out of that. Adi kuda immovable property. Reason? Benefits arising. Next one. Things attached to the land. What is this? See. Things attached to land means, I will ask you a question. Plant and machinery is a mobile or immobile? Plant and machinery, mobile, immobile? Loudly? Immobile. Listen, machinery is mobile. Plant represents attached to land. Andike pair is plant and machinery. Plant is something attached to land. Where plant grow? On sky, Where plant will grow? On the land. Correct or not? That's why name is plant and machinery. Plant means attached to land. Sir, I will ask you a question. Photocopy machine, computers, these are all mobile or immobile? Why? You can move from one place to another while usage also. Laptop, mobile, immobile? Now I'll ask you a question, tell me. Have you ever gone into a flour mill? Flour mill, Pindimara. Have you ever went to a flour mill? When you put the grains of rice, powdered rice will come. Pulses, powdered pulses will come. Have you ever saw? Machinery will be there or not? Big wheels and machines will be there. They are loose, they are attached to land. Those are immobile properties. Now did you understand the concept? Though they are machinery, once attached to the land, they become plant and machinery. Understood the point? So now lead. What is an immobile property? Land, benefits arising out of land, things attached to the land, permanently fastened and attached to the earth. Example what I said you know. Understood the point or not? Okay. It is an inclusive definition. That remaining thing is okay. So tell me, what is the main definition you have to write in exam? Land includes land. Immovable property includes land, benefits arising out of land, things attached to the land are permanently fastened to anything attached to the earth. Next, what is the next one? Imprisonment. What is the next one here? Imprisonment. Imprisonment shall mean imprisonment of either description as defined in the Indian Penal Code. So simply, imprisonment is of two types. Normal imprisonment, also called as a simple imprisonment. Also called as? Loudly. Second one is a rigorous imprisonment. Kathina Karagara Siksha. Simply to tell, imprisonment is of two types. Simple imprisonment. And they will go, come, over. There is second type called as a rigorous imprisonment. That will be done in central prison. So, rigorous imprisonment is called as hard-bound labor work will be there in the jail. So, see what they said. By section 53 of Indian Penal Code, punishment to which offenders are liable under the code are imprisonment which is of two description. Two types of imprisonments are there. Rigorous. with a hard labor and simple. Two types of imprisonment: simple imprisonment, rigorous imprisonment. So when an act provides an offense is punishable with imprisonment, the court may at its discretion make imprisonment either rigorous or simple. Who decides that? Court will decide. So whenever in any section when you are reading imprisonment, which imprisonment it is, simple or rigorous, court will decide that. That's what he wanted to tell. Not you or me should decide. Who should decide? Court decides on the basis of the offense. Next, what is the next one? Indian law. Indian law means any law made within Indian parliament or dominion legislature, all those, not that great. Next one, what is the next one? Month. Sir, month means which month? Month as per which calendar? British calendar. Next one. Immovable property we read. Now what we are going to read? Movable property. Start. Movable property shall mean property of every description other than immovable property. So anything other than immovable property will automatically become movable property. So that's why any property which is not immovable is a movable. Debts, shares, electricity, all these will become movable property. Next, what is the next one? Same affidavit. Instead of swearing and other thing, you will just take a oath. Read. Oath shall include affirmation and declaration in case of persons by law allowed to affirm instead of swearing. Same thing we have read for affidavit or not. That's it. Next, what is the next one? Offense. What is an offense? Read. Offense shall mean an act or omission. I told just now. First definition. What is the first definition we read? Act. Act means what? Doing an act of civil or criminal wrong includes a series of acts and illegal omissions. Same. What is an offense? Offense shall mean any act, not only act, omission made punishable by the law. Any act or omission which is done is punishable under any law is called as a offense. Official gazette. Official gazette is of two types. First one, Gazette of India, the central government. Particular state will also release a gazette called as what? Official gazette of a state. Next, read. I told now person definition defined in GCA. Read. What is the definition? Person includes any company, association, body of individuals, etc. I will ask one question. Only these three are persons, also these three are persons, also these three. How do you know? Includes is used, not means. Next. Registered, all these not required here. Main concepts, let us see. That's it, nothing more greater. All are small points. These are all some important definitions we need to read. Simple concepts as a summary I will tell, remaining what is there in GCA. How to interpret of, how to interpret from. For example, dividends declared, it should be paid to the shareholders within 30 days from the date of declaration, he will tell. From means I should include the date of declaration, exclude is a question now. I will tell the answer also. Whenever the word from is used, exclude the first day and the answer over. Exclude the, who said? Section 9 said. Like this, some basic sections are there. On that I will make one small video and I will put it. Just you listen, don't waste time in the class. Listening, So up to here everyone understood all the concepts clearly? Take a break and come. We'll start with the final act of 12 marks, which is FEMA. FEMA, we will do a lot of research and analysis as that no question should come out of the discussion in the class. Okay. So in this 4 marks over now. Another 2 marks or 3 marks questions are there. That also I will put a one video lecture. Just to listen to that. Let's not waste time in the class. Okay. Thank you.
So let us start with the last other law called as the FEMA 1999. With regard to the FEMA 1999, examination you can expect a 10 marks to 12 marks in exam. Sometimes even more also coming in the examination from the FEMA. Just in a span of a quite amount of 1.5 hour time, how can we complete the entire FEMA without, leaving any concept? Each and every concept exclusively from exam point of view. No logics, nothing. Let us strictly go in the exam point of view. If question comes in examination, are we able to write the answer or not? In that way, if you have to go, we are going to start with a revision on Foreign Exchange Management Act. Okay, you can see on the screen. One by one I will cover and I will complete. See there. Screen is clear? Okay, so let's begin with the concept. Foreign Exchange Management Act. With regard to this, there are only three concepts which are applicable for exam. Final level of CA, final level of CL, FEMA is there. There, FEMA is applicable for around 35-40 marks. That's the reason why around 70% of the entire FEMA is applicable for CA final. But inter-level it is applicable only 1% of entire FEMA. But why so many marks? Reason is very clear. Student don't even know the basics of FEMA at inter-level. Previously FEMA used to be a CA final topic exclusively. Now they brought basics of FEMA into CA inter. That basics are given for 10 marks to 12 marks. Listening. Final level basics will not be there in FEMA. Advanced aspects of FEMA will be there. FEMA itself is a separate module in CA final. Here FEMA is a separate chapter, not small chapter. There FEMA is a module, 390 or 385 pages book it is for CA final. CA final law is 5 modules. 5 module, 5th module is FEMA. That much big it is. So inter level if you ask, it is 1% of final level concepts. So therefore no hard work required for this. Just a smart way of understanding what is FEMA. Okay, let us begin. 1.5 hours I will complete every concept inside the FEMA, including the exam questions. Listening. Whether we will do or not, you will only tell. Okay, from now the time starts. Point number 1. FEMA Act, what is the first one? Preamble. The preamble of this act is to consolidate and amend the law relating to foreign exchange. First preamble. What is a preamble? What is a preamble? What do you mean by preamble? I told in the last class also. It will express the object and purpose of the act. Better than that of long title. Do you remember? Same. So, here the purpose of FEMA is consolidate and amend the law relating to foreign exchange. Whenever you see a preamble like this, it is an indication that there is a previous law for that. For example, old FEMA came in the year 1999. So tell me, first foreign exchange law came in the year 1939. First foreign exchange law came. Next this was amended in 1947. FERA 1947. Again this was amended in 1973 FERA. Later FEMA came. And FEMA is the first foreign exchange law, fourth foreign exchange law. Therefore, whatever these laws are there, these are all consolidated and added and made amendments and released FEMA. Listening or not? FEMA, what is the main purpose? What is the purpose of FEMA? The purpose of FEMA is facilitating external trade, external payments. Loudly. External trade, external payment. Now you will get a doubt, sir. Only payments are, sir. Receipts are not governed by FEMA. Question will arise or not? It is payment, he said. Payment made by you, payment made by them, they didn't. Listening.
Making of payments it can be, receipt of payments it can be. That's why the word payments is used loosely. Here payment made a payment received a. Both will be covered, yeah. Hey, everyone understood? How can you tell that payment means payment received and payment due? Always try to understand. You should make beneficial construction. This act has come to develop the economy. Only payments made if you cover, then receipts, economy will get affected or not. Therefore, interpretation is key role. The word payment has two meanings now. When the language is plain, I will go by literal construction. When a word is having multiple meanings, literal construction will not work. We should go for a hypothetical interpretation. In that we need to go by beneficial. Because FEMA is a economical benefit act. Growth of economy depends on FEMA. Listening. Therefore, whenever I say payments, what should be there? Payment received, payment made. How can you tell that, sir? He used the word trade. He didn't use the word buy. Trade means buying and selling both will be there. If you buy, you will make payment. If you sell, you will receive payment. Both will be included into the word payments. Understood the point clearly? So therefore, that's the first thing that I wanted to emphasize on. So tell me, purpose of FEMA Act first set. Everyone understood clearly? Tell me. Facilitate external trade. Facilitate external payment. Understood? Very good. Next. Not only that, development and maintenance of foreign exchange market. Repeat. What is it? Development and maintenance of foreign exchange market. From time to time, whether everything is going properly in the forex market or not, maintenance also will be done by FEMA. Okay? Next one. So to whom FEMA will apply? First tell me what is the short title of this act? Foreign Exchange Management Act. Again I am telling you, I will complete everything in FEMA in 1.5 hours. Okay? If you go in a different world, by the time you again come back, one concept will be over. నీ దరిద్రానికి అదే ఎగ్జామ్లో రావచ్చు కూడా. Clear? So please cautiously listen to next 1.5 hours. Because I said so many times in the FM class also, my intention is complete syllabus fast. Do your practice for more time. Understood? Your practice, what we can do, make the concepts simpler. Now, previously before the classes, you might have a different notion on other laws. Now, definitely the change will come. Automatically what you should practice, that's it. Practice, read it for 2-3 times. What mistakes you have done in the last attempt, it should not get repeated this attempt. Clear? Then it will benefit you. So now listen, what is the name of the act? FEMA. What is the next one? Extend. To whom it is applicable? Tell me. Whole of India. Not just whole of India. Any, listen, I will write here. Any office, any branch, any agency outside India. Tell me. Any office, any branch, any agency outside India. It's within India, na outside India? Na? But owned or controlled by person resident in India. Owned or controlled by? These are also governed by FEMA. Okay? 1 minute time for you. Please read the content carefully. Have you completed? Can you move on to the next one? What are the two things we completed now? First one is a preamble. Next one is the short title, extent and commencement. Next. See. Definitions. All definitions are not important. Main definition that is important for exam is residential status definition. Okay. 3 definitions are important. Okay. What are the 3 definitions that are important? See, whatever you are seeing on the screen. First one, tell me, what is the first definition? Person. Read. What is a person? Person includes individual, HUF, company, firm, AOP, BOI, artificial juridical person, any agency, office or a branch owned or controlled by such person. All these will come under the point of view of person. Tell me, what is the definition of a person? Person includes individual, HUF, company, firm, AOP, BOI, artificial juridical person, any office, branch, agency owned or controlled by the aforesaid persons. Understood the point clearly? Next, what is the next definition? Resident in India. Next definition is what? Person resident. Listen, person resident in India. Next definition, person resident. Tell me, who is a person resident outside India? Person resident outside India means a person who is not a resident in India. So who is not a resident automatically will become? Who is not a person resident in India automatically become? That means, what you understand? Person resident outside India is not defined. Person resident in India is defined properly. Whoever is not falling into the category of PRI will automatically fall into the category of PROI. Shall we continue? Let's begin now. I will make it full screen. That's better. You can see it well. If you can understand this chart, there can be no new question that can come in exam. Nadi guarantee. See that. First point number 1. Okay, see here once. Start. First one. What is the definition we are going to study? Person resident in India. Whenever we ask a question on person resident in India, it depends on 2 situations. Individuals, other than individual. First, let us focus on other than individual. Okay? Okay. Sir, when I say other than individual, what will come? When I said other than individual, what will come? Companies, firms, I mean LLP, all these things will come. Correct or not? About them let us see. Okay? When a company will be called as a person resident in India, when a person will be called as a company will be called as a person resident in India. A company, LLP or a firm, etc. will be called as a resident in India if the following conditions are satisfied. First, read. Any person or a body corporate registered or incorporated in India. Now tell me, a company is incorporated in USA. What it is? PRI, PROI. What is the full form of PRI? Person resident in India. PROI, person resident outside India. Tell me, company incorporated in USA. PRI, PROI. How do you know that PROI? It is registered outside India. Next. So, to become a PRI for a company, it should be incorporated in India. So, from this, what is the next conclusion you can tell? All Indian companies are PRIs. Understood? Next. What is the next one? Office, branch or agency. This is important for exam. Listen. Whether office, branch or an agency is a resident or a non-resident, how to tell? Listen. There is a checking also for this. If an office or a branch or an agency, if an office or a branch or agency is in India, it will be automatically called as a PRI, irrespective of ownership and control. Irrespective of, for example, a company incorporated in London has its branch office in Hyderabad. What about the branch office in Hyderabad? PRI or PROI? Huh? Why it is a PRI? Because branch is physically located in Hyderabad. Hyderabad is within India. Question number 1 ka answer came. Second one important. There is a company. There is a incorporated in USA. Started its branch in Netherlands. Started its branch in. Now you tell me. It has 2 branches. There is a company in USA. That company has 2 branches. One in India. Another one is in Netherlands. One in Hyderabad in India. Second one is in Netherlands. Now you answer my question. Branch in Netherlands is a PRI or PROI? Start again. There is a company incorporated in USA. First tell me about company incorporated in USA. PRI or PROI? Huh? It has a branch in Netherlands. It has a branch in. What is the status of that Netherlands branch? PRI, PROI? PR? Why? Because the physical location of that branch is in India, not in India. What about the Hyderabad branch? PRI or PROI? Why it is a PRI? It is a branch located in India. I will make one small change in the question. Branch in Netherlands is controlled by Hyderabad branch. Then Netherlands branch also will become PRI. Sir, physically located outside India. Though physically located outside India, technical control is from India. Therefore, you are also treated as a PRI. You are also subjected to FEMA. Understood or not? Now tell me, Netherlands branch of a US company has to comply with the FEMA, na? Need not comply with FEMA, na? Has to comply with FEMA. That's the power of FEMA. FEMA has an extraterritorial jurisdiction. Means what? Its power is not within India. National could be international. Who? FEMA. So, FEMA is not just a national-wide implication. FEMA applies throughout the world. It's have an international acceptance. So that's the importance of FEMA. So a branch is located in India. Automatically it's a PRI, irrespective of control ownership. Because the physical location is in India. Now the question arises, physically I am located outside India. Am I a PRI or PROI? Depends on the situation. Where is your control or ownership? Outside India, then you are a PROI. In India, then you are also a PRI, though physically located outside India. Understood? Answer? This is the point I wanted to convey. Everyone understood the logic clearly? Okay. Now, I want you to read other than individuals first. When we do exam questions, I don't want to listen any wrong answers. So please read carefully when you are reading itself. Okay, na? Completed everyone? Okay. Now, see here. We completed residential status for whom? Other than individual. Now comes the main concept inside this. Individual residential status. Extremely important for exam. 99% this question will be there in the coming exam, because last attempt I expected question to come, but they didn't give. This attempt question will be there from residential status for individuals other than individuals. For individuals will be there in exam. Okay, rest it is with you whether to listen or not to listen. Shall we first read for individual? Start. Person resident in India means a person residing in India for more than 182 days during the course of preceding financial year. Okay, next. And does not include a person who has gone out of India, who stays outside India for employment outside India, for carrying on business or vocation outside India, or any other purpose where his intention to stay outside India is for an uncertain period. Does not include a person who has come to or stays in India other than for the employment in India, for carrying on business or vocation in India, any other purpose where his intention to stay in India is for an uncertain period. That's it. Read first, we'll go into analysis. Exam as it is, you have to write the definition. So be prepared for that. Read properly. We read? First see there, for individuals there are two conditions. Condition 1, you should comply. Condition 2, you should not comply. For example, I stayed in India for less than 182 days in the immediately preceding financial year. Listening, I am treated as a non-resident or person resident outside India, or I am not a PRI. I am not a PRI. When, if I stay in India for not more than 182 days. For example, I stayed only for 182. More than 182 only will be a resident. Even 182 also non-resident. So, person residing in India for more than how many days? 182 days during the course of preceding financial year. So, in the preceding financial year, you stayed in India for more than 182 days. That is condition 1. Listening? For example, last year, everyone sitting here in the class stayed in India for more than 182 days. Correct? What are we? Person resident in India or outside India? Answer. Wrong. Adi, this is how you will write in exam. You will strike the answer. Just because of the first condition, you should not confirm my residential status. You should ask another question. What is the first question you are asking? Have you stayed in India for more than 182 days? Is the first question. They said yes. Next question is, in the current financial year, are you falling under any of these two cases? You should ask. If we say yes, you are not a resident, though you stayed for more than 182 days in the last year. Understood the point or not? So try to understand clearly. What is the first condition? Stayed in India for more than 182 days in the preceding financial year. First condition, you should check for the preceding financial year. Second condition, you should check for the current financial year. In the current financial year, what you are doing. Are you staying in India, leaving India, coming to India? You tell that first. Listening, last year are you staying in India for more than 182? Yes. This year are you going anywhere? No. Are you coming from anywhere? No. Then you are a resident. Listening or not? Case 1, going out of India. Case 2, coming into India. Case 1, going out of India. Case 2, coming into India. They have given 3 purposes. Purpose number 1, employment. 2, business vocation. Not vacation, vocation, skill. Okay, first one, employment. Whenever I say employment, all these are permanent employment, permanent business establishments. Okay, tell me, a person is leaving India, gone out of India, na, coming into India, na? See there, gone out of India for employment, for carrying, or any other purpose, correct or not? So therefore, listen carefully, I will ask a question, answer. Last year I stayed for 182 days, more than 182, 365 days I am in India. When? Last year. Condition 1 satisfied or not satisfied? Last year ante calendar year, financial year. Last financial year I stayed for more than. Condition 1 satisfied, not satisfied? Satisfied. Second condition you ask, this year are you going anywhere? Yes sir, I am going. Where you are going? I am going to USA. Why you are going? I am going for sightseeing, he said. Which one? I asked how many days? 63 days, he said. Under which of the 3 categories it is falling? First or second or third? Answer, none of the 3. Therefore you are a resident. Understood the point or not? How beautifully lawmaker has drafted that employment makes you permanent outside India. Business permanency makes you permanent outside India. You are leaving India. Leaving is pakka. When you will come back, and I asked, you said coming back is uncertain. And what is certain? Going is certain. Coming back is uncertain. And your permanency is uncertain in India, na outside India? Na? They think your permanency is uncertain in India, na outside India? Na? In India. But your permanency is certain outside India. When you will come back, you don't know. Going is pakka, already you are going out. But when you will come, till when you will be there, uncertain. And going is certain, coming back la uncertainty is there. Listening, tell me, start again. When you will call a person as a resident, individual, what is the first condition? Resided in India for more than 182 days during the course of preceding financial year, and does not include 2 categories. Number 1, who has come to India, gone out of India. What are the 3 permanent purposes? Employment, business or vocation, stay for uncertain period. Stay for, in these 3 cases, permanency is more in India or outside India? Think and answer. Permanency is more outside India and lesser. So don't call him resident. Understood? Now use common sense, if any, and answer this question also. Coming into India, what you will write? Last year I stayed for 182 days. I went back. Again I am coming this year. Last year I stayed in India for 200 days. How many days? April 1st to December 31st I am in India. April 1st to, and April to December means 9 months. 9 into 30, even if you take 270 days, I am in India. Correct? After that I left to USA. April 1st again I am coming back to India. Which category I will fall? First or second? Second. What is the second one? Come to stay in India. Come to stay in India. Now use common sense and tell. My permanency is more in India if you are coming for employment or not for employment. Answer. To make you non-resident? To make you non-resident, you should come for employment other than for employment. That's why the word other than came here. Because we are reading does not include category. Understood the point or not clearly? So read all the things now. Once you read, we will revise one more time and then we will be going into the next area. Read properly all the points. There is a case law, circular, 2003 December circular is there. Have you read? Tell me, does not include. Did you understand the logic of what is the does not include? Tell me, what is the first condition? Residing in India for more than 182 days in the preceding financial year. That is one condition. All that condition you did not satisfy means don't look for other conditions. You are non-resident only. First you can satisfy that condition. Next one, current financial year, what you are doing? Three things you can do. Going out of India, staying in India, coming to India. Listening, if you are going out of India, when you will be treated as a non-resident? Going out of India, when you will be treated as non-resident? When you are going out of India for employment, for business or occasion, for uncertain period. Understood? Second, you are coming to India. When you are treated as a non-resident, coming other than for employment, other than for business or occasion, other than for an uncertain period of stay. Answer completed. That's it. This is what you wanted to tell. Understood? But now, one RBI circular is there. If a person is leaving India, if a person is for education purpose, for what purpose? Education purpose. Education is falling under any of these three? No. Actually, education is not any of these three. Correct or not? But the point is what matters. Indians are misusing the opportunity of education because 99 out of 100 students going out of India are working in USA. Yes sir. Telugu వాళ్ళకి కొంచెం ఇచ్చిగాటింగ్ కొంచెం ఎక్కువ. So whoever goes from our place to USA, because the highest immigrants in India for USA is from Andhra. So two Telugu states, to be very frank, highest immigrants from entire India to USA is from these two Telugu states. Yes or no? Huge population. One area is filled with them now. Okay. Last year I went, last 2024 I went again. May 12th I am leaving to US again. So whenever I go there, I don't even get a chance to speak in English in some areas. Telugu, Boothulu, asalu oka aanandam. So we will listen to so much of the Telugu, that itself is an indication that we are established there. Correct or not? So main point that we have to understand is, whenever I say leaving India, people are leaving India for employment purpose, for education purpose. They say they are going for education. After going for education, they are really doing only education. Education and working. Working means what? Employment. Working means what? Employment. After completing their MS, they are coming back, they are doing the employment permanently. And what you are doing, you are a snake in a monkey shadow. Your intention is to do job in USA, but name education. Therefore, Government of India in the year 2003 passed an RBI circular saying that education will be treated on par with employment. That's how that answer came. Understood the point or not? So whenever in examination question came on education, higher studies, etc., it should be treated like employment only, because Indians won't do education only. We do so many extracurricular activities. Understood or not? And the panni interest. So therefore that's the whole logic behind. Everyone understood the logic clearly? So this is all about the residential status. But final touch, institute answers one mistake is there. Okay, So many students might have already know about this. Institute answers, so one mistake is there in FEMA. What is that mistake also I will tell. It is a mistake, but to get the marks you should write that mistake in exam. Because there is no choice. Na? You have to write what is there in study material. My duty is to tell that there is a mistake. Hello, listening. What is the mistake, sir? Tell me. What is the first condition to satisfy? I am staying in India for 150 days in the last year. 150 days a day. This year I am coming to India for permanent employment. Tell me. Who am I? Last year I was there in India for 150 days. Went back. This year again coming back. For what purpose? Permanent employment in India. Tell me who I am. PRA, PROA. I am a PROA actually, because though I am coming in the current year for permanent employment, last year I stayed only for and condition one satisfied or not satisfied. But institute is saying that if you are coming to India for these three purposes, then forget about the first condition. Then why first condition is there? Like this, so many wrong answers institute material has, but we have no choice. Till institute itself admit that there is a mistake, mistake should be written in exam to get the marks. Understood or not? That's it. Everyone, what the point? Exam la what question might come? Exam la what type of question can come? Stayed in India for less than 182. But coming into India for three purposes. Coming into India for? Or going out of India not for these three purposes. He will be treated as a resident only as per ICI. And condition number one, they are taking it seriously or not taking seriously? Not taking seriously ICI. If you see the textbook, you can understand the questions and answers. Listening, we will do it at the last. Once we complete the chapter FEMA, we will do. Okay? Done. With this, what concept we completed? Residential status completed. Okay? Tell me, how many kinds of residential status we covered? Two types. Individuals, other than individuals. Other than individuals, when you will be called as a resident person or a body corporate incorporated in India, or office, branch or an agency outside India owned or controlled by a person resident in India, or office, branch or an agency in India owned or controlled by a person resident outside India will be treated as a residence. Understood? Later this concept. 1 minute time, complete this. We'll be going into the next important area and the final area. Transactions under FEMA. Current account transaction, capital account transaction. For entire other laws, read only the study material. Okay? Don't read any third party material. If you have also, throw them away. Read only study material. From them only questions will come in exam. So not that any chapter. Okay? Did I tell read my book? No. Then I will tell don't read any book. Understood? I never suggest even my book. No one is bigger than institute. Read institute book. Then you will know right wrong also. Okay? Read only the study material. If you are okay with the definition, we will go into the transactions under FEMA. Okay? Let us begin. Last area. That is the main content that comes in exam. One question will come from residential status. One question will come from transactions under FEMA. Do you know last year what question came? 5 marks ki define current account transaction. 5 marks ki define current account transaction. Over. 12 marks ki paper came. 5 marks ki define current account transaction. Another 5 marks question, do you know what they asked? Capital account transaction, they take an immovable property transaction and asked. Listening, over. That means if you read the concept clearly, you will pass. This time, what they will do? One question will come from residential status for 4 marks or 5 marks. One question will come from current account or capital account. Understood? Like that they will ask the question. Obvious answer. Okay? Let's begin. What is the next concept we are going to start with? Current account transactions and capital account transaction. This is CA final material. So everything is not applicable. So what is relevant for you? Let us read. See here, see the screen. Is the screen visible? Everyone, is the screen visible? Okay, first, there are 2 types of transactions: capital account transaction, current account transaction. First, let us see capital account transactions. Okay, read. Start. Hey, read. Yeah, important. Capital account transaction means a transaction which alters assets or liabilities outside India for a PRI. Assets or liabilities in India for a PROI. That's it. Stop. Start again. Capital account transaction means a transaction which alters assets or liabilities outside India for a PRI, in India for a PROI. Moral of the story: if asset and liability both are in India, for a PRI it is not attracted. If asset liability both are outside India, for PROI it will not get attracted. One should be home currency asset, another one should be foreign currency liability, or vice versa. Hey, listening? Or both can be foreign. Understood the point clearly? Start again. Tell me, what is a capital account transaction? Capital account transaction means a transaction which alters assets, liabilities outside India for a PRI, in India for a PROI. Understood? Can I ask questions now? Okay, tell me. We are all what? We all in the class are what? Sir, tell me now. Shall I ask you a question now? Tell me. I purchase an asset in Hyderabad by taking loan in State Bank of India. Current capital account transaction, not a capital account transaction. Answer. Why not a capital account transaction? No asset is outside India, no liability is outside India. I am a PRI. Listening? For a PRI, what should be changing? Assets liability outside India. For a PROI, assets liability in India. Shall I continue? Start. For example, a person in USA wanted to purchase house in Texas by taking loan from Bank of America. For him, is it a capital account transaction? A person residing in USA wanted to purchase a house in Texas. Texas is in USA. By taking loan from Bank of America. Bank is also in USA. Is it a capital account transaction for him? Why? Both are their home currency transactions. Correct? Now I will ask another question. I wanted to purchase a land in USA by taking loan in Bank of America in USA. For me, is it a capital account transaction? Yes. Asset or liability? Both are outside India for a PRI. Listening? American citizen and resident wanted to purchase this building in Hyderabad by taking loan in local SBI branch. Tell me, is it a capital account transaction for that fellow or not? Yes. Why? Asset is in India, liability in India. It is changing for a person resident outside India. Now did you understand, everyone? So tell me, what should be changing? Asset and liability, asset or liability? Asset or liability? I will ask a question. I took loan in India in SBI. I took loan in India in SBI. 1 crore rupee I borrowed. How much? I converted that into dollars. I converted that into and purchased the asset outside India. Now tell me, is it a capital account or not? Yes. What is created outside India? Asset. Liability is created in India. Even then no problem. It's a capital account transaction because assets and liability are assets or liability are. Anyone, if it is outside India for a PRI, it is a capital account transaction. Understood or not? Now, I will write fastly one example. You will tell the answer. Tell me. Asset is created in India by taking loan in India. Asset is created in India by taking loan in USA. Asset is created in USA by taking a loan in India. Asset is created in USA by taking a loan in USA. Now everyone fatafat give the answer. First one, is it a capital account transaction for a PRI? Yes or no? Second, I don't have time. Third, four, no. You are ready? Who am I? PRI. What is changing in the last case? Asset or liability or both? Both. Next one. PROI. Next. That's it. Answer is completed. This is a capital account transaction definition. Everyone understood? For a PROI, what should be changed? Indian assets and liability. For a PROI, what should be changed? Foreign assets and liability. And the answer is over. Understood? For a PRI, foreign assets and liability change. For a PROI, Indian assets and liability change. Assets are liability actually, not end. Assets are liability. Everyone understood the concept clearly? Done. We are now done with definition of capital account transaction. What we completed here? Definition of capital account transaction. Once see here. Okay? Next. I don't want to go extreme into the concept. I will tell from exam point of view what is required. For that, absolute concentration is required. Please see here. Capital account transaction, section 6. Summary I am going to tell. It is revision. What is very important from the exam's point of view, I am going to explain. Okay, wow. See here. Section 6 ki summary I am writing, not every point. Exam ki what is important, I am writing those. Listening? Stay there. There are three types of capital account transaction. Capital account transaction with no restrictions, capital account transaction with restrictions, capital account transactions strictly prohibited. Capital account transactions strictly prohibited. Tell me, what are all the capital account transactions types? Capital account transaction with no restrictions, capital account transactions with restrictions, capital account transactions that are strictly prohibited. First of all, listen carefully. All capital account transactions are strictly prohibited unless permitted. Tell what I said. E clarity you should have. First thing, reading hundreds of pages of FEMA will not give the knowledge. Okay, listening to nonsense on FEMA also will not give the knowledge. You should understand the core idea of FEMA. Then you need not listen after that. You can do any question that comes in exam, because the theme of FEMA you should understand first. Start again. What I said. all capital account transactions are strictly prohibited unless permitted. Repeat. Means what? Means what? Bad response. Means what? All capital account transactions are strictly prohibited unless permitted. I said, correct? What do you mean by that? What do you mean by that? What means what? No. Shall I tell you what? What are permissible, they have given in the act. Other than that, if anything comes in exam, is a prohibited. Moreover, how to understand capital account transaction? Capital account transaction with no restrictions. These are called as freely permitted capital account transaction. Freely permitted capital account transaction. Capital account transaction with restrictions means these transactions are permitted with the conditions. In this, there are two types. RBI permitted, CG permitted. RBI will involve if there are debt instruments. CG will involve in case of non-debt instruments. How many of you read this before? What is a debt instrument then? What is a non-debt instrument? Anyone? Sir, if anyone has read it before, what RBI work is? What is the work of RBI in this capital account transaction? What is the work of RBI? Those who read before, at least you can answer now. What is the work of RBI? RBI, tell me, what is the work of CG? Both of them are having three works. Work number one. At least tell now. RBI in central government work is to tell the loudly. Which limit? Monetary limits. What is the third one? Other conditions. Other conditions. So listening everyone. Ippudu kuda vinapothe exam. So tell me again. What is the work of RBI and central government with regard to the capital account transaction? Start. They will give you the list of permitted transaction. Not just list. They will tell up to what it is allowed. Not only that, additional conditions also they will give. That's why with restrictions we say. Listening? Listening? 1 second. See the screen. See the screen. I have one important thing to share with you. What is this? Study material. Correct? Which we never read. See, in the regular class ki when I take line we will analyze in the regular session, but you should understand one thing. Sorry, okay, past is past, happened has already happened. It is there in study material only. Over. Sir, you said RBI and CG, sir. Here RBI only. Aves padakunna, Bujji. Kanna Chitti. Central government also same point. Listening, na? They have given in study material properly. Manan chadavam ante. Okay? So now tell me, at least now did you understand that what I am writing on the screen? Tell me, what is there? Capital account transactions are of how many types? Sir, first one you said no restrictions, sir. Where, sir? Section 6. Shall I show? Proviso. Amortization of loans, depreciation on direct investment shall not impose restrictions. Read there. Ante restrictions also should not be there on two things. Number one, amortization of loan, depreciation on direct investment. So there are two freely permitted transactions: amortization of loan, depreciation on direct investments. Answer over. Okay. Completed. What completed? What? Capital account transaction fully completed, huh? No, half completed. See, regular aithe, regular I can tell. For 8 hours and 9 hours, same concept. Same thing in 10 minutes also we can cover. Are you understanding? Same FEMA you can see in the YouTube. Okay? I had taken only capital account transactions for 9.5 hours. Only capital account transaction. Like that we can go to the extreme end, we can analyze. But exams, sir, I don't want any knowledge now. I want marks in exam. I wanted to pass this attempt. Adeti the answer. Understood the point or not? Sir, no sir, naka yantaudu sir, I will learn later. First, intlo tattugala pothran sir. I wanted to pass. Then this is more than enough. More than enough. Understood the point or not? So sir, I wanted to just pass. Just to pass means good marks has to come, but I have to pass. Knowledge, other things you forget, sir. I will learn later. I think the answer. Okay? That's why I am not even giving explanation on what is amortization of loan and depreciation. And remember, that's it over. Ni calls marks kada. Let's see there. Tell me, what are all the freely permitted capital account transaction? Amortization of loan, depreciation on direct investment. What are these two? Freely permissible what? Current account or capital account? Capital account transaction. Okay, next. Capital account transactions, the second category is capital account transaction with restriction. Who will give restriction? Either RBI in some cases, central government in some cases. When RBI will involve? When RBI will involve? When RBI will involve? When RBI will involve? In case of debt instruments. Loudly. In case of? Okay. In case of not involving debt instruments, central government. See, what is required from the exam? Everything I have written here. Listening, huh? Now, sir, doubt, sir. Not doubt. Freely permissible, completed. Permitted, list you said. But what is that list, sir? Question will arise or not? Limits, other conditions not applicable for exam. At least list should be given in exam or not? List last attempt it came. List is of two types. Schedule 1, Schedule 2. Schedule 1 permitted list for PRI. Schedule 2 permitted list for PROI. Schedule 1 permitted list of PRI. Schedule 2 permitted list of PROI. Okay? Sir, where it is in study material, sir? Inga paru. Hey, paruda. Idiga. இது யாரு? இது யாரு? சொல்ற? Person resident in India. This list. How easy it is? Dead easy. Really, yes, sir. Very really. See the content? See the content? Kid also can read and understand that. Tell me, what is a capital account transaction? Forgot. Answer. What is a capital account transaction? Capital account transaction means a transaction liabilities in India for PROI, outside India for PRI. We are reading for whom? And everything should happen. That's it. Read. Investment by a person resident in India in what security? Foreign securities or securities in India na outside India na? Asset or liability ya? If I invest, for me it's an asset or liability ya? Indian asset or foreign asset? Who am I? That's it. That's why it become a capital account transaction. Understood? Next. Second. Everything I will not explain and waste my time. I will explain randomly 4-5 points. You can understand after that. What is your work? You should read these and remember at least. I will explain 4-5. Each and everything if you explain, waste of time. Nothing will be there. Sorry, read. Randomly you pick one and tell. Akpa karve patla you say one. A, B, C, D, F, G, H, L, A, K na? Undertake what contract? Derivatives. Derivative is a share market transaction. What transaction? Share market transaction. Okay? Derivatives are two types. One, writer. Second one, holder. Number one, writer. Number two, sir, derivative is a typical insurance contract type. Which contract? Insurance contract type. If I take insurance policy, asset for me. If I write insurance policy for others, it's a liability for me. Listening? Here they just said undertake derivative contract. Which contract? Undertake derivative contract means either I can be a writer or I can be a holder. If you are a holder, foreign asset. If you are a writer, foreign liability. That's way over. Listening everyone? Next, last attempt which question came? Adi kada doubt? C point. On that C point they created one scenario. If you read you will get marks. If you don't read, gone. Ante, as simple as that. First, what you should write in exam? Definition of capital account transaction, 2 marks. After definition of capital account transaction, writing about the point on RBI. Which one? RBI and central government point is there, na? RBI in consultation with central government in consultation with RBI will give the list of transactions which are permitted, limits up to which the transaction is allowed in each case, any other condition. For that 1 mark. Later you have to write this, that this is a part of schedule 1. For that 1 mark. Conclusion give 1 mark. That's how they gave 5 marks question. Understood the point clearly? So now tell me, what is this? Foreign currency loans. Tell me, loan is raised in which currency? And liability asset. Doubt liability asset. In India, outside India. That's it, answer over. This is a transaction attracting capital account. Understood? Randomly if you take loans and overdrafts, transfer of immovable property outside India by a person resident in India. There is a person resident in India. There is a person resident in India. He is selling a immovable property outside India. He is selling an immovable property outside India. If you sell an immovable property outside India, what will happen? Foreign asset is getting sold. Alteration happened or not? Attract the section. Understood the point clearly? Like this you can have some examples. But I have one question. What is this? List of permissible transactions. Permissible or non-permissible? Huh? Very good. These are permissible. Other than this, all are prohibited. That's what I told you. All capital account transactions are strictly prohibited unless permitted. Unless permitted. Very good. Sir, I think you can understand the schedule 1, correct? Tell me, what will be there in schedule 2? Guess. First it will be talking about resident, non-resident. Non-resident. For him, everything should be changing in India. Correct? Read number 1. investment in India. He attempt this chance is there. This attempt is schedule 2 because last time schedule 1 came na. This attempt schedule 2 chances are more. Okay. Very easy, not easy, dead easy. Actually, the difficulty I like easy, medium, difficult, easy. Good radidi. Topic the simple, rumba simple concept. Let's see. Investment in India by a person resident outside India. Asset in India, outside India person is investing in that. It's a capital. Schedule 2 will be talking about PROI. Okay. Whenever I say about PROI, we are talking about Indian assets or foreign assets. Indian liability or foreign liability. Everyone, are they answer? So, any kind of investments made by foreigner in India, this category it will come. But what you have to remember for exam, only these are permitted. Acquisition of immovable property in India, allowed. Guarantees given in India, allowed. Currency notes to India, allowed. Deposits made in a bank in India, allowed. Foreign currency accounts to be opened in India, allowed. Payment in India for capital assets, allowed. Derivative contracts, allowed. Exam what they will give, any transaction other than this they will give in exam. Are you listening? Answer. Purchase of agricultural land by Donald Trump in India, allowed or not allowed? Not allowed. Do you know why? It is prohibited. It is non-resident cannot make investment in some activities. Activities are prohibited. What are those? Let us see. Sir, will you read this list later or not? Exam what they will give this time? List they will give other than the list. Other than list they will give. They will ask you to pick up which are permissible and which are non-permissible. Until to know which is permissible, non-permissible, first you should know the list or not. For that you should read this. They will not ask you write the list. They will ask you a question and you have to write that this is not in the permitted list of transaction. For that you should remember this. Understood the point or not? Understood? Done. So tell me. Schedule 1, everyone understood clearly? Yeah. Tell me the summary. Schedule 1 will contain list of permissible capital account transaction. For whom? PRI. Schedule 2 will contain list of permissible transactions for a PROI in India. Listening? Done. So now, question will arise. Sir, in this chart, capital account transaction with no restrictions, you said. See here. Institute also given that or not? Same, again same. You are not studying study material ante. They have given everything in a simple format. Clear? Sorry, next. Sir, what are prohibited? So, okay, sir. Capital account understood, sir, with no restrictions. With restrictions also understood, sir. Tell about the last one. What is the last one? Strictly prohibited. See here. In strictly prohibited, I have some discussion. See. Two situations will come again. Situation 1. General, specific. You will tell, I will listen. What are prohibited capital account transaction? What are prohibited capital account transaction? Hey, how many times I should tell you? Any transaction which are not permissible automatically will become what? Prohibited. Along with that, for PROI, some specific prohibitions are there. What prohibitions are there? Specific prohibitions. See here. See here. A PROI. cannot invest in any entity, company, LLP, etc. in India which is engaged in chit fund, agriculture, chit fund, nidhi business, agriculture and plantation, real estate, farmhouses, trading in transferable development rights. Don't ask questions, just remember. Okay, fast, tell me. Prohibitions are of how many types? Tell me, what are the two types of prohibitions? General prohibition, specific prohibition. What is the general prohibition of capital account transaction? If any transaction doesn't fall under list 1 or list 2. What is list 1? Schedule 1. What is list 2? Schedule 2. If any transaction is falling under, if any transaction is not falling under schedule 1 or schedule 2, automatically it will be regarded as a prohibited transaction. That is general nature. Listening? I will ask a question. See and tell, no problem for me. Schedule 2 B point you read. Acquisition of immovable property in India by a person resident outside India is permitted or not permitted? Permitted or not permitted? But agricultural land is specifically prohibited. That's how you should understand. Though other things they can buy, agricultural land they cannot buy. What they cannot buy? Agricultural land. Okay. So tell me, PROI, can investor, cannot investor? Bad response. Start again. PROI, can investor, cannot investor? Cannot invest where? In any entity. Where? In India. That entity in India is engaged in what business? Chit fund, nidhi, agriculture and plantation, real estates and farmhouses, trading in TDR. In that business, who is involved? Indian entity is involved. In that Indian entity, you cannot make investment. Understood? In that Indian entity can investment. Everyone understood the logic clearly? With this, we completed entire capital account transactions. This is a overall summary of the concept called as capital account transaction. First, tell me, are you all comfortable with the FEMA up to here or not? But one small concept is still pending from my side. In capital account, not current account anyway pending. Capital account lone another one more pending concept is there. That's called as transformation of residential status and inheritance of properties. జీవితంలో ఫస్ట్ టైం విన్నారేమో నాకు తెలియదు కానీ it is there in the syllabus. Transformation of residential status and inheritance of properties. ఒకసారి ఇక్కడ చూడండి. ఇదే. See here. ఈ అటెంప్ట్ ఈ క్వశ్చన్ వస్తుంది చూడండి ఎగ్జామ్లో. May 2025 కి this will become a guarantee question. What is this concept? Let me explain. Shall we? Dead easy concept. Just listen. Okay. After that you can read and write. There is a PRI. There is a PRI. That particular person once upon a time is a PROI. Once upon a time he is a sir, I will explain this way. I am a PROI 5 years back. 5 years back, who am I? I stayed in USA, example. Then I am a, while I am a PROI, I had a house in USA. I have bank balance in USA. Later, today, I became a PRI. After I become a PRI, asset outside India is a foreign asset for me. Correct or not? And moreover, foreign currencies are there outside India or not? I will bring it to India. When you bring it to India, two options are there. Convert that into rupee. What will be converted? Dollars will be foreign exchange. Dollars will be converted into rupee. That's option one. Option two, do you know what is there? You can put them in India in foreign currency account called as a RFC account, a resident foreign currency account. What account? You can maintain it in the resident foreign currency account. RFC accounts you can open because India la NRIs are very much high. People go to USA, stay there for 25 years. Later they will come back and stay in India with huge money and wealth. At that time, which money they will have? Foreign wealth they will have. For them this section came. Do you know what they are saying? Listen. First, I am a PRI or PROI? OI. Became later? But assets and liabilities and foreign exchange accounts are in? Rupees are foreign currency. Now listen. Source. Until when it was generated while I am a PRI or PROI? FEMA attracted or not attracted? Not attracted in the origin, correct or not? Even when you sell them, FEMA will not touch you. That's what he wanted to tell. Because origin is not subjected to FEMA means destination also is not attracted by FEMA. Listening? I am a foreign resident, USA citizen or resident. Clear? I am a PRI or PROI? OI. When I was a PROI, I have a bank balance of $1 crore. $1 crore dollars. I have a bank balance. I came to India. I kept that $1 crore in RFC account. Which account? From that, I wanted to purchase asset outside India. From that, I wanted to purchase asset outside India. Now, what common sense you have to understand? Listen. I have taken Indian dollars. I brought my dollars and using my dollars. Think and answer with common sense. I am drawing India government dollars I am drawing. My dollars I brought to India and I am using. Then నీకు ఎందుకురా అంత ఆనందం అని అడుగుతున్నాడు. నిన్ను కాదు కదా, నీది అడగలేదు కదా. I did not ask your dollars. Then why you are so much bothered? అవి నావి. Those are my dollars. I brought from USA. I am wanted to use them to purchase outside India. నీకెందుకురా? This is a question Indians asked government. That's why this exemption came. Are you understood the point or not? And asset is created when I am a PRI or PROI. Later I became a Therefore, even though you became PRI, those are created when you are a under source ki FEMA is not getting attracted. You can hold, own, transfer, invest in foreign currency, foreign security, move property situated outside India, provided same was acquired when he was a PROI. Reverse for PRI. I think you can now understand what I wanted to tell. Yes, right or not? So tell me, residential status transformation la India home currency assets might become foreign currency assets and liability. No problem, you can continue normally. Did you understand? Yes, tell me, I purchased a house property outside India. When I was outside India, tell me, when I purchased it, I am a PRI or PROI? FEMA attracted or not attracted? Therefore, I will do whatever I want with that. Shut your mouth and say it, because it is none of your business. Because originally you are not there. I am selling that asset which is generated when I am a PROI. Originally your permission is not there. Then destination also your permission not required. Understood the point? Exam ki this question will come. Mark it very, 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 very important. It will come in exam this time. Understood everyone? And this is the end of capital account transaction. We are having still one more concept. Just 10 minutes I can complete, because everything you have to remember, that's it. Nothing great in the capital current account transaction. See the chart. First, read this, understand this chart before you. I will make it full screen, wait. First, take a minute time, observe the entire content. Okay, ma? See, how many categories of capital account transaction are there? How many categories of capital account transactions are there? 3. What are those? Capital account transactions freely permitted, capital account transactions requiring the RBI approval, capital account transactions requiring central government approval. These are coming under one category. Last one is capital account transactions that are totally 3 categories. Second under 2 subcategories are there. Correct? This is what we learned. Current account transactions also same, but very, very easy when you compare with capital account. Do you know why? Reverse exactly. All current account transactions are permitted unless prohibited. What I said. And what we have to read? Prohibitions you have to read, all others are permitted. All others are other than prohibited. If something is prohibited, you cannot do. Other than that, permitted. Do whatever you want. Reason is very clear. Current account transactions, number of transactions are more, volume is less. Capital account transaction, number of transactions are less, volume is more. Volume is a problem for the government, not the number of transactions. How much foreign exchange is going out is the problem, not how many times. Understood? For example, I will import goods. I will import goods. $1 lakh goods I import. How many lakh? $1 lakh I will import. 1 month ki $1 lakh, 12 months ki $12 lakh. Correct? This is current account transaction. Import is a current account transaction because it will affect trading P&L, not the asset liability. Listening? But listen carefully to one very, very important concept. Reliance Industries 2020-21 time, and COVID time exactly, it borrowed from Barclays PLC. One foreign company is there, foreign bank is there. What is the name? Barclays PLC, public limited company. PLC means UK company. From that UK company in dollars they borrowed. Do you know how much they borrowed? They borrowed $10 billion. Borrowing for 10 years. Borrowing is a asset or liability? Answer. Reliance Petroleum Limited is a company incorporated in India or outside India? And it's a PRI or PROI? For a PRI, foreign liability is a capital account transaction, not a capital account transaction. Attracting FEMA or not? Yes, this is called as external commercial borrowing. What it is? Covered by CA final. CA final external commercial borrowing. So 39 pages notes is there. And a complete external commercial borrowing. So student at CA final level will learn. I'll make FEMA law. Found interla, it is a Mahaprasadam. Which one? FEMA. With nothing they are giving 12 marks. If this itself you feel it difficult, imagine how final will be. Final 380 pages, so only FEMA will be there. Okay? That too coming for 35-40 marks in exam, 30 marks almost. Sir, anyway, see here. Why I am telling this is, listen carefully. $1 lakh import you will make, current account transaction. Even every month you do that, 12 months ki how much it will be? $12 lakh. 12? Reliance Industries, do you know how much it borrowed in ECB? $10 billion. Billion means 100 crores. 10 billion means 1,000 crore dollars. At that time, 2020 time, the dollar rate is 71. 71,000 crore rupees they borrowed. How much? 71 1,000 crore rupee they might have, they borrowed at that time, COVID time. Listening, what is the moral of the story? How many $1 lakh I should do import here to reach that 10,000 crore dollar? It take me 100 years. Ante, what a current account transaction can do in 100 years, one capital account transaction will do in one day. Ante volume lo which is dangerous. Andike capital account transactions with the government is putting a hukkupadam. Understood the point or not? That's why government is more focusing on capital account transaction, not on current chillera transaction. So, going to USA, I want some dollar, current account. Gift, current account. Donation, current account. Listening. Immigration. Immigration means when you are going outside India, immigration la money you have to show how much you are bringing. That one. Allow him. Allow. Education, allowed. Medical expenses. A person wanted to get surgery outside India. Allow, current account. Maximum how much it will be? Oh, $1 lakh maximum it will be. Yeah, leave it. Small transaction, don't waste time. Listening or not? Why you are wasting time in small transaction? So, therefore, what you want to tell us, small transaction, you are wasting your time. Allow, no problem, nothing they will do. Therefore, sir, 1 lakh will become very big amount, na, sir. That also you may get out or not. Like that you should not think. Do you know why? All current account transactions should happen through an authorized person. Should happen through? That fellow will be there to torture you. Listening or not? So therefore, lot of checking will not be there, but checking will be there even in current account. Listening or not, everyone? Why I am telling all these things is, see here, current account transactions, what will be there? Nothing will be there. Current account transactions, P&L account transactions and your personal transactions will be there. What? Sir, financial statement, two types will be there. P&L, balance sheet. P&L? I am not a businessman at all. Then why P&L and balance sheet will be there for Kaushik Mukesh? My personal expenses will be there. Listening, So first I want you to read this one. Personal expenses, read. Remittances of living expenses of parents, spouse and children residing abroad. Means what? My parents are living in USA. For them I have to spend. This P&L, balance sheet, personal transaction. Those all comes under current account transaction. Listening. Next one. Read. Expenses in connection with a foreign travel, education, medical care of parent, spouse. Personal expense again. This also comes under current account. Next. Loan is a dash transaction. Loan is a dash transaction. Capital account transaction. Investment is a dash transaction. Interest on loan is a current account. Income on investment is a current account. Understood? Yes, what I asked you. Loan is a capital account. Interest on loan is a current account. Investment is a capital account. Interest on investment is a current account. Answer over. Understood? Next. After that, trade related. Payments in connection with foreign trade. Payments in connection with next, any other current business and services. Long term loan, current capital account. Short term loans, current account again. 3 months I have to repay current account, capital account. Because big amounts no one will borrow for 3 months. Listening? Sir, I will buy an iPad on EMI. I will buy iPad on EMI. How many years they will give EMI? 6 months, 7 months EMI they will give. Correct or not? I will buy a house, 6 months, 1 month EMI. I will take for 20 years like that. Correct or not? And bigger the volume, higher the term. Short term liability itself means what? Two things are small here. Term is small, amount also is small. When amount is small, allow, don't waste time. Allow them. Don't waste time on these kind of small things. Bigger things are going on other side. Understood? That's how this came. Whatever you are seeing on the screen, current account transaction in any transaction other than capital account transaction, but it includes all these things are there. Exact this chart came for 5 marks in the last attempt. Understood? That's the importance of this chart. Next, sir, what are the types of current account transaction? See the screen. These are the 3 types of current account transaction. Okay? First one, current account transactions. They fast read here. 5 minutes you have to complete this. Read. Strictly prohibited. Previous central government approval. Transaction requiring RBI approval. First one. Second one. Answer. So tell me, all these we have to remember for exam or not? Answer. 1, 2 you remember. Other than that, everything will come under third category. Remember 1, 2. 1 is what? Prohibited. You cannot do. Second one is what? Central government approval. Other than these two, everything is permitted, na? Which require what category? RBI. And there I say example. Over. Understood? Start from the beginning. What are prohibited? I don't want to stretch this and waste time. You read later. Okay? I will tell what is there inside. Gambling, betting, lotteries, all these expenses or incomes out of it is not permitted. It is strictly prohibited. 1, 2, 3. Read properly. Remittance out of income from lottery winnings. Remittance out of income from racing, riding, hobby. Remittance for purchase of lottery tickets, band magazines and football pools. Simply to tell, India la lottery winning came. That amount I wanted to use to convert into foreign exchange. Not allowed. India la racing, riding, betting I kept money. India la I made money. I wanted to convert that into dollar and purchase something. Not allowed. Reverse case. India la income is from good source. I wanted to purchase a foreign lottery tickets. Not allowed. Understood? Number 4. Number 4. Commission on exports towards the equity investment in a joint venture or a wholly owned subsidiary of Indian company. Indian? Simple logic. 1 minute I will complete. Company is in India. Hey, listen. Company is in wholly owned subsidiary. And a mirror image of this company is there in USA. Is there in? Through that company they are selling the goods. Through whom? India na wholly owned subsidiary. Microsoft, you know. It is in India na outside India na? Also in India. Hyderabad head office is there. Okay? Hyderabad what is there? Wholly owned subsidiary is there in India, in Hyderabad. Correct? What it does in India? What it does in India? Microsoft India Limited, private limited will do business in India on behalf of Microsoft outside India. Correct? Likewise, there are so many companies in India which are started in India having wholly owned subsidiaries outside India. How Microsoft is doing its business through its subsidiary, Indian companies are also doing business through its wholly owned subsidiaries outside India. Listening? Wholly owned subsidiary means entire capital who will invest, I will only invest. Correct? It is nothing but my mirror image. Correct? Therefore, it is your subsidiary, wholly owned subsidiary. Ante it will do whatever you say. Correct? Then why you are paying in dollar, pay in rupees only. You settle that in India. Don't waste foreign exchange for payment of commission to the agent outside India. Strictly prohibited. Understood everyone? Next one. What is the next one? Payments made when? What is applicable? Dividend balancing is applicable. What is applicable? Simple. See here. Some persons, listening, some persons will make equity investment in Indian company. Equity investment in? Also called as FDI, foreign direct investment. Foreign? Okay. I am a NRI. I am a NRI. I invest in Indian FDI. For example, I am Microsoft outside India. I am in India, no outside India? Outside India. I will invest in which company? Indian company. I will invest in which company? Indian company equity shares I will invest. FDI. Aim of FDI? Foreign direct investments in equity. FDI they call. Tell me, who am I? Company outside India. I am investing in company in India. Company in? India. Investment I am making. FDI made. FDI is a capital account transaction, no doubt. Listening, why that company is investing in India? Because once they invest, they will promote more exports. They will promote. Microsoft is a company in India, outside India. Invested in a Indian company. When I invest in Indian company, I want that Indian company to grow because my money is also involved. Therefore, Microsoft outside India will give export contracts. It will tell other companies in USA, you wanted to buy iron and steel, don't buy in USA. My person is there, he will sell at a lower cost in India. Like that, what will be promoted? Export. What will be promoted? Export. Listen what they do. Export happened normally in India, $1 lakh. After Microsoft putting FDI in India, it became $2 lakh. And extra $1 lakh is because of whom? Microsoft. Listening. Microsoft invested in Indian company, where it invested? Equity shares. And it's a owner or not? What it received at the end of the year? Dividend. Dividend compared to the export sale only will be paid as dividend. Dividend is $1,05,000. Extra sale because of is only $1 lakh. I will pay only $1 lakh. $5,000 is prohibited. Because there is an imbalance of $5,000 in dividend. Listening or not, everyone? Tell beyond this I can't tell in a revision session. Understood what I said? Normally our exports are $1 lakh. Now because of Microsoft acquisition it became, and because of Microsoft contracts my exports increased by how many dollars, sir? $1 lakh. Correct or not? Total company P&L prepared. Profits came. Dividend to Microsoft came to $1,05,000, sir. 1 lakh? Tell me, how much exports increased because of you? How much dividend will come to you? How much is balanced? How much is balanced? 1 lakh. How much is imbalance? 5,000 ki prohibited. Understood the point or not? Next, what is the next one? Exports under rupee state credit route. RSC means what? Rupee state credit route. There are so many countries in the world, including Russia, who are ready to accept rupee payments directly. When they are accepting rupee, why you are drawing dollars unnecessarily? Not allowed. Listening, remaining, please remember, payments on callback service. It's an illegal telecalling service. Not allowed. Next, non-resident special rupee scheme account. Non-resident special rupee, that's a current account. Current account with interest you should not pay. Listening, last two, beautiful. Those two countries are accepting rupees directly. Nepal, Bhutan, when you are traveling, you can pay directly in rupee. Person in Nepal, Bhutan, you can pay them directly in rupees. Then why you are drawing dollars when they are accepting rupee? Therefore, all these comes under what category? Prohibited. Next comes. These are all central government approval cases. Okay? See that. First one. Business tour is different, cultural tour is different. I am going for a musical night. Cultural tour. Dance program outside India. Cultural tour. Audio release outside India. Cultural tour. Listen to that. Pre-release event of a movie outside India. Cultural tour. Company purpose I am going out of India. Business travel. Business travel is RBI. Cultural tour is central government. Listening, Next one is a dead easy. 4 points I will cover. See, whenever goods are going on a ocean, 4 payments are required. Import payment, freight payment, container detention charges, insurance payment. Tell me, goods are going on a ocean. Tell. First, you are importing goods. Means from USA it's coming to India on ocean. First payment is import payment you should make. Travel ki freight payment you should make. Goods ki insurance you should pay. Container has to be unloaded or not, detention charges you have to pay. 1, 2, 3 and 6. 1, 2, 1 already over. 2, 3, 4, 6. Okay. What is to? Payment of import. I simplified the language also. Read that. Payment of import. Second one, payment of freight. Next one, container detention charges. Sixth one, remittance for membership of P&I club. P&I club is an insurance club. Okay. Protection and indemnity club. Listening? Beyond this, I can tell half an hour about P&I. This is not the time. Just remember. Listening? Next one, satellite connections. Satellite connections. You are hiring the satellites. Transponder we call. Satellite as a transponder. When you are hiring the transponders, anything done by TV channels and internet service providers, and you are hiring a foreign satellite. Loudly. Sir, the example is there, sir. As India an example is there. Tata Sky. Tata is Indian company. Sky is a satellite service outside India. From them we are taking satellite hiring. Clear? For that we have to pay in rupee or dollars or dollars. Central government approval is required for Tata. Understood? Next one. If you are paying any sponsorship or prize money outside India, for example, shall we? Champions League happen. Okay? Some cricket happens in Dubai. Listening? Champions Trophy happened or not? In India or outside India? Who is putting the t-shirt sponsor advertisements? Who are doing? Indians only or not? At that time this only got attracted for them. Up to $1 lakh, no problem. Beyond $1 lakh if you do, central government approval is required. Listening? Next, after that, that's it. These are the important thing. Advertisement if you wanted to give outside India, in print media. Where you are going to give advertisement? Print media. In India or outside India? Outside India. If it is given by government organization, no problem. Other than government organizations, if they are giving up to $10,000, okay. Beyond $10,000, approval of central government is required. Will you remember? Other than this, everything will come under what case? RBI. Now I will ask you a question, tell me. Gift, donation, callback service. Callback service. Very good. Next, container detention charges. Advertisement in foreign print media. Very good. Container detention charges. Freight payment on ocean transit. Travel to Nepal, Bhutan. Answer. Prohibited or permitted? Prohibited transaction. Listening? Foreign education. Foreign education. RBI. Foreign travel. Foreign travel. Medical checkup outside India. Medical treatment outside India. Anything other than first two, you can mohan chodakalla doubt vitti. Is it coming under schedule 1? No. Coming under schedule 2? No. Adi permitted RBI. Understood the point or not? One last concept before we close this chapter. Listen carefully to this point. The important point that requires attention is, if you are doing any of the current account transaction out of RFC account, permission is not required, because RFC account lo what money will come and fall? Already what you earned in foreign. Just now I told RFC account importance. That is earned in India or outside India? Drawn Indian dollars or foreign dollars? Then why you are bothered? You can do whatever you want using RFC account. Understood? Okay, done. Next one. See here. There is one concept called as LRS transaction. Liberalized remittance scheme. Loudly. If you remember this exam question, chance is also there. I will tell you what is LRS. You should be a PRI. Repeat. First condition number 1, to apply LRS scheme, first condition number 1, you should be a PRI. You should be a one resident individual. I will write this way. See here. To whom liberalized remittance scheme will apply. First one, you should be a ante what you should not be? Other than individual you should not be. వినకపోతే పోతావు. జాగ్రత్త వినండి అందరూ. Important. First one, tell me. You are a very good individual. Very good. Next, you are entering into a whether current account or capital account, whether current account or capital account, which require RBI permission. All these conditions should be cumulatively satisfied. Tell me one by one. You should be a PRI. You should be a individual. You are entering into a transaction that can be either current account or capital account, and that transaction requires whose approval? RBI. Ante in the current capital account schedule 1 list, yeah, in this case third schedule, those transactions you are doing in one financial year, in up to $250,000, no RBI permission required. That's called as liberalization. You have to write this point in exam whenever current account question comes in exam. Clear? Tell me, up to what extent, sir, tell me, I wanted to purchase a house property outside India. Current or capital? Answer. I wanted to pay $150,000. Permission required or not required? Not required, because you comes under LRS scheme. Listening, huh? But the thing you have to understand is aggregate of transactions you should see. Each and every transaction and government adukku tinali. Listening or not? All transactions, for example, I paid 150,000 and the balance how much is only available? 1 lakh available, and moreover, one person is treated as one unit in the family. Family members ఒక్కొక్కళ్ళకి 250,000 ఇవ్వడం మళ్ళీ చచ్చుకుంటారు సార్ $10 లక్షల అంటే. Are you understanding or not? So therefore $250,000 for one person in a family. Do you know what is the impact of that one person? If son avails opportunity of LRS, ingante a year father, parents, children, no one can avail the 250,000 again. Ante who avail first will get the benefit first. Listening? That's it. Tell me, when LRS will apply? First, you should be a person resident in India. You should be a individual entering into a transaction, either capital account or current account, requiring RBI approval. And again, central government approval ki these all will not apply. Reason? Guess the reason? Central government transactions ki again these will not apply. Why? LRS concept is brought by RBI circular. LRS is an RBI circular. RBI circular central government exemption la istadu. Are you understanding or not? So requiring RBI approval in one financial year up to a aggregate of how much? 250,000. RBI permission is not required. Everyone understood clearly? Remaining in the study material you read and do. Okay. This is the end of the chapter called as Foreign Exchange Management Act, a super quick revision. Everyone, is it useful for you? Understood the entire FEMA concept or not? After this study material questions and other things you do once, okay, then you will get the confidence of doing it. Okay, I will show you some questions first. Shall we do the questions in study material? Practical questions I will show you, you will tell the answer. See, Printex Computer is a Singapore based company having several business units all over the world. See, one by one you will answer. You need not even open. See there and tell ante. Okay, no extra work. There is a company. Where it is? Tell me. PRI or PROI? PR? Why? Any person or body corporate incorporated in India is a PRI. Singapore based company means incorporated in Singapore outside India. PRI, PROI. Very good. It has business units all over the world. It has unit for manufacturing computer printers with its headquarters in Pune. Headquarter means what? Head office. We read now, office, branch or agency? Office. Where it is? In India. Here controller, physical establishment. Tell me, Pune headquarters is a PRI or PROI? Huh? How it is a PRI? What explanation you will write? Office, branch or an agency in India owned or controlled by person resident outside India will be treated as a PRI. Next. It has a branch in Dubai. Who has a branch? Singapore company has a branch in. I gave an example already. Tell me, company is in? Head office in? That is PRI, PROI. Next. Again, that particular company is having a branch Dubai. Dubai branch is a PRI or PROI? PROI. But Dubai branch is controlled by headquarters in Pune. Headquarters in Pune is already a, and this Dubai branch is controlled by PRI. Therefore, Dubai branch also will become PRI. That's it. Answer is completed. Now, did you understand how the questions will come? Next, remittance of $50,000 for the lottery ticket. Permitted, prohibited? Very good. $1 lakh for sending a cultural troupe to USA. Schedule 1, Schedule 2, Schedule. CG approval or RB approval? That's it. Answer over. But like this, you should not write in exam. You should write full explanation. First, you should write what is a current account transaction. What is a, and then tell which category this will fall. Tell very clearly that if the transaction is made out of RFC account, no permission is required. Understood? Next. A film star wants to perform in New York for the occasion of Diwali, $20,000. Under which case this will fall? ఇది చెప్పలేకపోతే ఒక తోపుదో వస్తారు క్లాస్లో బయటికి వెళ్ళిపోతావు అట్టించటే. A film star wants to perform in New York. Which concept it will come into? The cultural tool ki what schedule will apply? Schedule 2. Schedule 2 la what is there? Central government approval. Next. Heart surgery. Medical comes under 1, 2, 3. 3 means which approval? That's it. Remaining answer you see in the study material how to write. Next, hiring charges of transponder. Central government approval. Callback service. Prohibited. Very good. Next, I will do this one. Lottery ticket remittance. Kidney transplantation. Studies abroad. Studies abroad. Gift. And the answer over. Over FEMA. FEMA concept. Understood the point clearly? Beyond that, do some RTP and MTP. That's more than anyway. RTP MTP discussion I will put on my channel already again anyway. Full April month I will be available. Listening, with this we completed 100% of our other loss 40 marks completed. Okay. So next, once this other loss is completed, main problematic part of the students is done with this.